Broker, my lord. Marriage broker.
Oh, you did not settle, is it?
Not yet, my lord.
Like no money?
Lord, absolute
Halima madam barli, pass over.
grateful.
Yes.
Number 2.
ITP. Huh?
Section. Coffee kudi.
Wilson Garden.
Please.
Hmm?
There is the videographs also, and photographs also. Watch it in detail.
ಆಯ್ತು ಇರ್ಲಿ, ಇದನ್ನೇನು ಅಲೋ ಮಾಡ್ಬೇಕಷ್ಟೇ. ದರ್ಶನ್ ಜೊತೆ ಕಾಫಿ ಕುಡಿದ ಜೈಲಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಕುಡಿಬಾರ್ದ?
ನಾನು ಅದು ಕುಡ್ದಿಲ್ಲ, ನಾನು ನನ್ನ ಅಕ್ಕಿ ಸುಮ್ಮನೆ ಜೊತೆಲಿ ಟವಲ್ ಹಾಕೊಂಡು ಕೂತಿರೋದು.
ಟವಲ್ ಹಾಕೊಂಡ
ಅಷ್ಟೇ.
ಅವ್ರಿಗ ನಿಮ್ಗ? ನಿಮಗೆ. ಯಾರಿಗೆ ಟವಲ್, ಯಾರ ಜೊತೆ ಟವಲ್ ಹಾಕೊಂಡು ಕೂತಿದ್ರಿ?
ದರ್ಶನ್ ಜೊತೆ ಟವಲ್ ಹಾಕೊಂಡು ಕೂತಿದ್ದೆ ಅಂತ.
ಸ್ಮೋಕಿಂಗ್? ಯು ಆರ್ ಸ್ಮೋಕಿಂಗ್?
ನಮ್ಗೆ
ಹ್ಯಾಬಿಟ್? ಅಯ್ಯೋ, ಹ್ಯಾಬಿಟೇ ಇಲ್ವಾ? ಸರಿ ಬಿಡಿ. ಅಲ್ಲ, ಸಾರಿ HGP ಅವರೇ, ಇವ್ರೇನೋ ಸ್ಮೋಕಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ ಹೇಳಿದ್ರು. ಸಿಗರೇಟ್ ಒಳಗೆ ಹೆಂಗ್ ಬಂತು? ಒಳಗೆ ಹೆಂಗ್ ಬಂತು ಸರ್? ಹೌ ಡಿಡ್ ದಿ ಸಿಗರೇಟ್ ಕಮ್ ಇನ್ ಟು ದಿ ಪ್ರಿಸನ್? ಅಲ್ಲೇನು ಅಷ್ಟು ಪ್ರಾವಿಷನ್ ಸ್ಟೋರ್ ಇಟ್ಟಿದಾರ? ಬೇಕರಿ ಇದೆ. ಬೇಕರಿಲಿ ಸಿಗರೇಟಾ? ಮತ್ತೆ ಹೆಂಗ್ ಬಂದ್ ಸಿಗರೇಟ್ ಜೈಲೊಳಗೆ?
Prison officer, 2 FIRs are registered against the prison officers subsequent to this FIR.
ಇವ್ರ ಕೈಯಲ್ಲಿ ಸಿಗರೇಟ್ ಬರ್ಬೇಕು ಅಂದ್ರೆ ನಿಮ್ಮ ಕನ್ನೈವೆನ್ಸ್ ಇಂದಾನೆ ಒಳಗ್ ಬರ್ಬೇಕು. ನಡ್ಸೋದ್ ಬೇಕ್ರಿ, ಏನ್ ಬೇಕಾದ್ರೆ ಸಿಗುತ್ತೆ ಅಲ್ಲಿ ಅಂದ್ರೆ?
When the offense was occurred, then there is a provision in the prisons manual. There is a space for there is space called as a smoking zone.
Smoking zone.
There in the prisons manual. After your lordship's order, they amended by virtue of the circular.
ಈಗ ಸ್ಮೋಕಿಂಗ್ ಝೋನ್ ಇಲ್ವಾ?
Incident ಆದಾಗಿತ್ತು. When your lordship heavily come up on the tissue, on that time, then the DGAG of prisons have passed a circular by removing the particular place as a called as smoking zone.
ಅಂದ್ರೆ ಎಲ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು ಈಗ? ಝೋನೇ ಇಲ್ಲ, ಝೋನೇ ತೆಗೆದ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಡೆಡಿಕೇಟೆಡ್ ಪ್ಲೇಸೇ ತೆಗೆದ್ಬಿಟ್ರಿ. Anyway, we'll answer it. Wait. ಇದು ರಿಸರ್ವ್ ಮಾಡ್ಬಿಟ್ರೆ ಪೈಲಪ್ ಆಗ್ಬಿಡುತ್ತೆ. Anyway, I've heard it. Yes, we'll see. ಇದಿರಲಿ ಮೇಡಮ್. ಹಲಿಮಾ ಮೇಡಮ್, ಕ್ಯಾ ಕರೆ ವೋ?
There is no stay, Lord. Your Lordship has vacated the stay also.
Which matter? First matter?
Yes, first matter.
Oh, 7 husbands.
7 husbands. We will confront them with all those affidavits. Because everybody comes and tells that, no, I am the husband, I am the husband.
That's what.
She has married 4 times. Yes, it is her fate.
She is married 4 times is no problem. You can marry. The allegation, let him come. He is not there. He is not there. Let him come. Elli Mohammed Azharuddin?
That's why, because he was not at all there all the time. Your Lordship was pleased to
vacate the interim order, is it?
Lord, I have filed NOC wakalat, my lord.
ಯಾವ್ದು ಮೊಹಮ್ಮದ್ ಅಜರುದ್ದೀನ್? ಈಗ ಯಾರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು?
I, my lord. For
ನೀವೇನಾ?
Parmeshwarappa C.
Oh, sorry. Azharuddin is not there.
They was vacated for his absence, my lord.
He is retired now. Yes. Mohammed Azharuddin has retired from not cricket. Illi matter inda. Yes. Now one ನಿಮಿಷ ರಾಮ್ಸನ್, ಒಂದೇ ನಿಮಿಷ. We will dissolve the 7 husbands and then come back. ಅಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಿರೋದು ಮೇಡಮ್. Yes sir.
Lord, as per their statement of objections, my lord, it is admitted.
What is admitted?
4 husbands, they admit themselves.
Inna 3?
Inna 3, my lords, have produced photographs
of husbands.
ಯಾವ್ದಾವ್ದಿದೆ ಅವ್ರದ್ದು ಎಲ್ಲ have produced. My lords, every time in a deceitful manner she would disclose the facts of the before marriages. Earlier marriages
Hmm.
will be in a deceitful manner. She convinces
Hmm.
and she does not discloses the true facts.
Hmm.
Marries once again, and on each every husband's, my lord, there is registration of 498A, my lords.
Alla,
If
how
at all
many
she suffered,
498s have you produced now?
my lords, I would take your lordships to annexures I have produced, my lords.
Hmm.
All these cannot be dealt with
Under 482, correct, madam. How many husbands anta, how can I know? Correct.
My lord, third marriage, my lord, third husband is produced at annexure C. Second, my lord, at annexure B.
Ah,
Third husband marriage photos and marriage certificate annexed to C, my lords.
ಆಮೇಲೆ
And further, my lord, marriage certificate and fourth husband's detail annexed to D.
ah,
Further, my lord's fifth husband at annexure E.
ah,
My lord, subsequent sixth husband, the marriage certificate is produced at annexure F.
ah. You are the seventh.
Seventh, my lord, annexure G is mine.
Ah.
Produced all the marriage certificate. I cannot concoct the and create the documents of so many husbands, my lord.
They issue as many number of certificates as they want.
Even if marriage has not taken place.
They will issue.
ಹೌದಾ?
Yes,
Oh.
fake, ಅದೆಲ್ಲ ಅದು.
ಅಲ್ಲ, ವಕ್ಫ್ ಬೋರ್ಡ್ issues fake marriage certificates, ah?
Code ಅಲ್ಲ. In the name of work code, there are so many other short, small shops,
Small boards,
small shops I can.
shops, ah?
ಆ ತರ. ಅಲ್ಲಿ ಅಂಗಡಿ ಇಟ್ಕೊಂಡು ಕೂತ ಹಾಗೇನೆ ಅವರು.
Oh.
ಅದ್ರ ಹೆಸರಲ್ಲಿ ಇವ್ರು ಕೊಡೋದು.
In certificate selling shops, ah?
They have issued. There are so many in Kerala.
Oh,
We have commercials.
all right.
My lord, subsequently eighth marriage was also taken place.
Seventh, ನೀವು eighth ಹೆಂಗಾಯ್ತೀಗ?
ಕೇಳ್ತಿಗೆ ಹೋದ್ರಾ?
Along with photographs.
ಅಲ್ಲ, seventh, you are the seventh husband. And during your subsistence, eighth?
Eighth marriage, my lords. At page number 77, marriage certificate, photographs at 78.
Ah. Yes, Alima madam. ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು? 4 husbands, ah? One by one?
ಒಬ್ಬ ಆದ ನಂತರ, one by one ಅಂದ್ರೆ ಒಬ್ಬನಾದ ನಂತರ, not together at a time two.
At a time two ಹೆಂಗೆ ಮೇಡಮ್? ಅವ್ರು ಆದ ನಂತರನೇ ಅವರು ಹೇಳ್ತಿರೋದು.
ಆದ ನಂತರ ಅಂದ್ರೆ ಒಬ್ಬ ಬಿಟ್ಟು ಹೋದ್ದು, ಒಬ್ಬ ಹೋದ್ದು. Sir, wait my lord.
Correct. I'm not saying anything like that.
It has taken a lot of efforts, my lord, to collect all the documents.
In a small scale, she is into politics.
Politics, ah?
ಅಂದ್ರೆ she does all this ಏನೆಲ್ಲ ಸಿಗ್ತದಲ್ಲ ಫೆಸಿಲಿಟೀಸ್ ಅದನ್ನೆಲ್ಲ ಕೊಡೋದೆಲ್ಲ ಮಾಡ್ತಾರೆ.
ಓ,
ಆ ಹಣ ಸಂಪಾದಿಸಿದನ್ನು ಗಂಡ ಉಪಯೋಗಿಸುದು ಈ ಗಂಡ.
ಈ ಗಂಡ. ಹಾ.
ಅವನಿಗೆ ಮದುವೆ ಆಗಿದೆ, ದೊಡ್ಡ ಮ್ಯಾರೇಜಬಲ್ ಏಜ್ ಮಕ್ಕಳಿದ್ದಾರೆ.
ಯಾರಿಗೆ? ಸೆವೆಂತ್ ಹಸ್ಬೆಂಡಿಗ?
ಇವನಿಗೆಲ್ಲ ಅವನಿಗೆ ಎಷ್ಟನೇ
Is confused, my lord, so as to which husband she is.
but he has he did not disclose that his wife is there. He said she is not there. She has
And you married him?
divorced me ಅಂತ ಹೇಳಿ ಇವಳನ್ನ ಮದುವೆ ಆದದ್ದು. ಹೀಗೇನೆ ಅವನು ಹೇಳಿದ ಸುಳ್ಳನ್ನು ಇಲ್ಲಿ they are not disclosing here, and he has children of marriageable age. ಅದು ಇಟ್ಕೊಂಡು ಅದನ್ನೇ
ನೀವು ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಾ ಅವ್ರ ಮೇಲೆ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ, ನಮಗೆ ಗೊತ್ತೇ ಆಗಿಲ್ಲ. ಇಲ್ಲ ಇದೆಲ್ಲ
ಇಲ್ಲಿ ಗೊತ್ತಾಯ್ತಾ?
ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ಗೊತ್ತಾದ್ದು. ಇಲ್ಲಿ ಮಾಡಿದ್ರೆ ಸರಿಯಾಗುತ್ತೆ.
ನಿಮ್ಮ ಮೇಲೆ 420 ಒಂದು ಹಾಕಿದಾರಲ್ಲ,
That is it.
ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
Yes, my lord.
ಕರೆಕ್ಟ್.
My lord,
eighth ಯಾರು ಈಗ?
eighth, my lords, his name.
No, so that I don't get another petition of that person.
In page
ಇಲ್ಲೇ
number
ಹೇಳ್ಬಿಡಿ ಈಗಲೇ.
Gafur K. Patel. Gafur K. Patel, my lords. Fact is that, my lords,
Trial court, trial.
ಯಾರು ಮೇಡಮ್? 498A ಕೇಸ್ಗೆ ಈಗ ಉಂಟೆ?
ಎಲ್ಲ even 420
ಹ್ಮ್.
let it be.
Lord, she is having a permanent adobe apartment in Manipal, my lords.
ಅಪಾರ್ಟ್ಮೆಂಟ್
Apartment al irodu.
ಯಾರು?
The respondent number 2. Every time she marries, she only stays in a short time duration with the husband. She comes back every time to the
Where?
apartment.
To the apartment.
ಬರ್ತಾರೆ. Subsequently, she lodges a malicious complaint alleging
Why?
all cruelty against husband and family members.
ಅಲ್ಲ, ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರದೇ ಅಲ್ವಾ?
ಅವ್ರದ್ದು ಇರ್ತಾರೆ.
ವಾಪಸ್ ಹೋಗಕ್ಕೇನಂತ
But
ಅವ್ರಿಗೆ?
nobody is living under the same roof to consider 498A.
Doesn't live.
What is your problem?
It's an offense not to
ಇಲ್ಲ,
live in her.
498A ಕೆಳಗಡೆ
ಅವ್ರದ್ದು ಅದಲ್ಲ, ಅಪಾರ್ಟ್ಮೆಂಟ್ ಪರ್ಮನೆಂಟ್ ರೆಸಿಡೆಂಟ್ಸ್. ಇನ್ನ ಬೇರೆ ಕಡೆ ಮದುವೆ ಆಗೋದಲ್ಲ ಟೆಂಪರರಿ ರೆಸಿಡೆನ್ಸ್ ಅಂತ ಹೇಳ್ತಿರೋದು ಅವರು.
Why to probe the in-laws and other
ವೈ
family
ಟು ಪ್ರೋಬ್ ದ
members
ಇನ್ಲಾಸ್?
in a criminal
ಈಗ
case?
ಇನ್ಲಾಸ್ ಇದಾರೆ ಇಲ್ಲಿ.
Well, that's, FIR came to be registered against in-laws as well.
ಇಲ್ಲಿ ಯಾವ ಇನ್ಲಾ ಇದಾರೆ ಸರ್?
Other cases which came to be settled, they've probed.
ಸೆಟಲ್ಡ್ ಅಂತ ಹೇಳ್ತೀರಿ, ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
ಆಗಿದೆ. Compromise decrees.
ಈಗ ಫಸ್ಟ್ ಮ್ಯಾರೇಜ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲಿದೆ ಕೊಡಿ.
Page number 3.
3.
1 second, Manoj.
ಫೋಟೋಸ್ ನಮ್ಗೆ ಕೊಟ್ಟದ್ದು ಯಾವುದು ಕೂಡ ಅವಳ ಇದಕ್ಕೆ ವ್ಯಾಲ್ಯೂ ಆಗ್ತಿಲ್ಲ. ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ವೆಲ್ ಫೋಟೋ. ಯಾರ ಫೋಟೋ
Page number 41.
ಅಲ್ಲ ಈಗ ಮೆಮೊ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದಿರಲ್ಲ,
ಹಾಕಿದ್ದೀನಿ.
ಪೇಜ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ಇರೋದು ಯಾರು? ಇದು ಫೋಟೋ ಕ್ರೈಮ್ ನಂಬರ್ 40 of 2023.
Yes, my lord.
ಇದ್ಯಾವುದು?
ತಬುಸೋಮ್
ಅಲ್ಲ ಹೆಸರು ಬೇಡ ಸರ್.
ಗಂಡ ಅನ್ವರ್ ಅಂತ ಸ್ವಾಮಿ.
ಅಯ್ಯೋ ಅದು ಹೆಸರು ಬೇಡ. ಕ್ರೈಮ್ ನಂಬರ್ 40 ಯಾವುದು?
My lord, first husband.
ಅದಕ್ಕೆ
He married at the age of 16 is the first husband.
ಇದು ಫಸ್ಟ್ ಹಸ್ಬೆಂಡ್.
ಹೌದು.
ಸೆಕೆಂಡ್ ಯಾವುದು? ಫಸ್ಟ್ ಹಸ್ಬೆಂಡ್ ಮೇಲೆ ಅವ್ರ ಹೆಸರೇನು? ಅನ್ವರ್. ಆಲ್ ರೈಟ್. ಅವ್ರ ಮೇಲೆ ಇದು 498. ದಟ್ ಈಸ್ ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇಡ್, ಡಿವಿ ಆಕ್ಟ್ ಅದು.
Yes, my lord.
ಮೇಂಟೆನೆನ್ಸ್, ದಟ್ ಈಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 11. ದೆನ್ ಸೆಕೆಂಡ್ ಯಾವುದು?
My lord. ಇಲ್ಲ, ನಿಮ್ಗೆ ಕಾಪೀಸ್ ನಾವು ಸಬ್ಮಿಟ್ ಮಾಡಿದೀವಿ. ಕ್ಲಿಯರ್.
ಮುಂಚೆನೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್, ನಿಮ್ಗೆ ಕೊಟ್ಟಿಲ್ವಾ? ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಿ ಇದನ್ನೇ ತೋರಿಸ್ಬಿಟ್ಟು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಿ. ಇದು 24 ಹಾಕಿರೋದು, ಇವತ್ತಲ್ಲ. ಎನಿವೆ ವಿಲ್ ಸಿ.
Yes, my lord.
ಹರ್ಡ್ ರಿಸರ್ವ್. ಎಸ್,
Grateful.
ಇಲ್ಲದ್ರೆ ಇಲ್ಲಿ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ರೆ ಆಮೇಲೆ ತಪ್ಪಾಗ ನೋಡ್ತೇನೆ. ಓಪನ್ ಕೋರ್ಟಲ್ಲಿ ಬೇಡ ಇದು. ಇದ್ರ 8th ಹಸ್ಬೆಂಡ್ ಬೇರೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅದಕ್ಕೆ. ಎಸ್, ಅದಕ್ಕೆ ಹರ್ಡ್ ರಿಸರ್ವ್. ಏನಾಯ್ತು ಮೇಡಮ್?
Number 2.
ಅವರು ಮೊಹಮ್ಮದ್ ಅಜರುದ್ದೀನ್ ರಿಟೈರ್ಡ್ ಅಂತ ತೋರಿಸ್ಬಿಟ್ಟು.
Obliged, please.
ಎಸ್.
Sorry, but mention my lords.
ವೈ?
Serial number 38, your lordships passed over.
ಹ್ಮ್.
They moved the matter in court all 1 at 2:30. We just came back. ಅದು ಕ್ಲಬ್ ಆಗ್ಬೇಕು, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್.
ಯಾವ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್?
PMLA matter which your lordships ಅವ್ರು ಟೈಮ್ ತಗೊಂಡು ASD ಬರ್ತಾರೆ ಅಂತ. Your lordship may take call it at 4 o'clock. Not most unfortunate part on the PM.
Get the ASG. Yes.
ASD did not. They mention it in court all 1 at 2:30.
ಏನಂತ?
That there are connected matters which are in other court, all have to be clubbed. And I mentioned that there is an order today that.
No, I have already passed a judicial order saying that it has to come before this court.
Lords, they
What
could
is
have
this?
told it before this court, not in court all 1 mentioning at 2:30.
What happened there?
Court said, my lord, there is no urgency. You want urgency, we'll club that here today. Then they walk out.
Well, where is Anuparna?
That's why, my lord, it's 4 o'clock or 4.
No, I
Please
will take it. I will take it up now. Definitely take it up. This is highly unfair.
When he asked for a
Absolutely
count,
unfair on the part of the
could have
respondents.
told it in the morning. When he asked for a counter, they say we'll mention it in court all 1. Not done.
Absolutely unfair. Let's see. How can the enforcement directorate do this?
Lords, I am shocked.
Let's
As
see.
law officers, we have to be fair to the court first. Otherwise, tell the court.
Well, let them make a mention, no problem. But you should have told me.
Exactly.
Yes.
ಪಾಸ್ ಓವರ್ ತಗೊಂಡು ಕೌಂಟರ್ ಕೊಡ್ತೀವಿ, ರೆಡಿ ASD ಅಂದ್ಬಿಟ್ಟು.
Then. ಈಗ ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ತಾನೆ ಏನು?
ಇಲ್ಲ.
Is who appeared there?
They said ASD, Mr. Raju will log in. He could not log in. So the council, Anuparna's colleague, he made a mention.
Right, or yeah, inform them and inform the ASG. I'll take it. Yes. We'll take it at the moment they come, sir. At 4 o'clock, I'll take it. There's one
As a-
specially ordered matter at 4 o'clock. I'll finish that and take it. Yes.
He just wanted to.
Yes, yes.
Most,
No, they asked for a Passover in the morning. Yes.
Number 2.
And one more thing, I have in that Gamescraft matter, I guess, I have passed an order.
There is I mentioned to the first court that there is a judicial order.
Yes,
now.
it's
What
not.
happened? Some matters not arising.
No, that is because of the Delhi High Court's order. I think they have said something. That also I've considered in this and told.
In fact, your lordships are right. Your lordships have considered the judgments from 2 or 3
Of
different
Delhi High
states.
Court also and have said it should be in this court only because of conflict.
Not only that, because your lordships will also just bear in mind that these petitions are the first filed petitions. These petitions were filed on 8th of
Correct.
July.
No,
15th.
according, you see, I was very clear in my order. It can't go anywhere else.
That's right.
Let me see. Let them come. But inform the ASG about this. Yes.
Still number 2.
ಇದು ಇರ್ಲಿ ಇನ್ನೊಂದು ದಿನ ತಗೊಂಡ್ಬಿಟ್ಟು 29ಕ್ಕೆ ಹಾಕ್ತೀನಿ 29th ಹಾಕ್ತೀನಿ ಐ ಹ್ಯಾವ್ ಸೀನ್ ದಿಸ್ ಎಸ್ ಅವತ್ತು ಮುಗಿಸೋಣ ರಾಮ್ ನಿಮ್ದು ಯಾವ್ದು ರಾಮ್ ಸಿಂಗ್ ನೀವ್ ಯಾರು ನೀವೇ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ನಾಗ ಇದ್ಯಾರು ಇನ್ನೊಂದು ಯಾರು
Connected.
All right.
Please.
Yes, next.
Still number 3.
May I? Lord, allegations are section 310, 31RS of the Prevention of Atrocities Act, read with 352. The allegation are that, Lord, talking over a phone call with one of my colleagues, I made insulting remarks against the respondent number 2 complainant. My lords may take the FIR at page 12. No mention of the name, my lord, and the conversation, my lord, has been taken place in telephonic conversation.
Yes, Mohan Kumar. Unmute, sir.
Lord, I don't have anything to dispute with regard to the facts of the case. I leave it to my lords.
Yes, sir. That's fairness. The petitioner is before the court calling in question registration of a crime in crime number 240 of 2024 registered for offences punishable under so and so, page 10. The petitioner is the accused, the second respondent, the complainant. A complaint comes to be registered against the petitioner on 26/10/2024 on a strange allegation that the complainant had heard the petitioner speak ill or hurl abuses over a telephone, that too hearsay from a friend of his. This comes to be the fulcrum of the crime in complaint in crime number 240 of 2024 for the aforequoted offences. The petitioner on registration of the crime is before this court calling in question the said registration. The learned counsel appearing for the petitioner submits that none of the ingredients which are necessary as to be present on in terms of section 31R or S is even present in the case at hand for further investigation to be permitted to be continued. The learned counsel would seek quashment of the proceedings. Counsel H. Mohan Kumar, representing the complainant, would not dispute the facts that led to registration of the crime, but would submit that matter is still at the stage of crime and it should be permitted to be investigated into. The learned counsel Nageshwarappa HCGP would toe the lines of the learned counsel appearing for the complainant. I have given my anxious consideration to the submissions made by the respective learned counsel. The afore narrated fact of the issue the issue lies in a narrow compass. The compass revolves around a crime registered, a complaint registered by the respondent complainant on 26/10/2024. The issue gets triggered thereon. Therefore, I deem it appropriate to notice the complaint. It reads as follows, page 14, 15. The fulcrum of the complaint is that the petitioner was, the complainant has heard from his friend that the petitioner was hurling abuses, taking the name of the caste of the complainant over a telephone, over a mobile phone. If over a mobile phone. Therefore, it becomes an offense under section 31R and S. Section 31R and S read as follows. Section 31R requires the hurling of abuses to be in a public place, and 31S to be a place of public view. If calling on a telephone, hurling abuses over a telephone, which is heard between two persons over a telephone, it is ununderstandable as to how it could become a place of public view or a public place for it to become a crime. The case projects a classic illustration or a textbook illustration of abuse of the process of the law in relating to Atrocities Act. Permitting further proceedings would become an abuse of the would lead to miscarriage of justice. Bhajanlal Court Madi. Quashed. Next.
Great.
Number 4.
1 week time, my lord.
As per the petitioner, ಏನಿದು ಪ್ರಸನ್ನ ಕುಮಾರ್
My lord.
CBI
No, private.
ಪ್ರೈವೇಟ್
My lord, on 17/12/20.
ಇದು ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್
Atrocities.
ಈ ಕಾರಣ
My lord, land dispute, my lord. My lord, 10 days time, my lord.
ಇಷ್ಟೊಂದು ಇದು CCTV ಫುಟೇಜ್ ಅದು ಬ್ಯಾಂಕ್ ಹೇಳಿತ್ತಲ್ಲ. Then release the matter from status of being parted, post the matter on 29th.
My lord, kindly extend this stay.
Interim order,
Please.
Number 5.
Appearing for the patient.
Appear for
As
the
your lordship,
respondent in
short
this
accommodation may be given as the argued counseling.
1 minute. What's the matter?
matter is in
138, but 138 Negotiable Instruments Act, my lords.
State of Karnataka ಯಾಕೆ?
State of Karnataka, because an auction order has been passed. The petitioner
Passed.
herein has filed a revision petition, and that is still in process, my lords. Amongst that, they have again gone before the magistrate and got an auction order issued against this petition.
That is
my
stayed,
lords.
is it?
Yes, my lords.
yes, my lords. I represent the
Uh,
complainant in the 138 proceedings, my lords.
Lordships may kindly grant some time.
One moment.
In revision petition, what they have filed.
1,90,000 you have withdrawn?
No, not.
Why? I have already passed an order.
And they have not paid the rest of
No,
the
no,
amount.
you have deposited or not?
No,
Lordships have proxy
Deposit,
counsel. No,
not
further-
No,
deposited.
ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ಮೇಲೆ proxy counsel, nothing, yes. If this court on 5/3/2025 had passed the following order. The petitioner submits, the counsel submits that she is representing the other counsel who is not present, the counsel on record who is not present. In the event the deposit of 1,90,000 is not made as directed, the interim order would not get extended. In the event the deposit is made, it is only then they list the matter on 29th.
The date may be given.
One moment. Wait. Madam, deposit ಆಗಿದೆ. I have permitted you to withdraw. ಬೇಡ್ವಾ?
I am eagerly waiting. from
Eagerly waiting
2015,
ಅಂದ್ರೆ
2015.
if you are eagerly waiting,
And,
then you should withdraw
lords,
it.
The other, they have already
No,
availed.
wait.
They have already availed.
The learned counsel submits so that in terms of the order dated 5/3/2025, the deposit has been made. In the light of the deposit made, the counsel for the respondent is at liberty to withdraw the same, as this court had already passed an order permitting such withdrawal. The interim order subsisting will continue till the next date of
Lords,
hearing.
there are two options. One, they have already availed the statutory
ಈಗ-
remedy. Statutory remedy
ಈಗ
by
ದುಡ್ಡು
filing.
ಬೇಡವಾ?
ಆ?
ಬೇಡವಾ?
ಅಲ್ಲ ನಾನ್ ತಗೋತೀನಿ.
ತಗೊಂಡ್ಬಿಡಿ.
ಫರ್ದರ್ ಸ್ಟೇ ಅಂದ್ರೆ ತಿರುಗಿ
ತಗೊಂಡ್ಮೇಲೆ ಮತ್ತೆ ಫರ್ದರ್ ಸ್ಟೇ ಕೊಡಕ್ಕಾಗತ್ತೆ. ಎಷ್ಟು ಟೋಟಲ್ ಅಮೌಂಟ್?
ಟೋಟಲ್ ಅಮೌಂಟ್ ಇಸ್ ಅರೌಂಡ್ 9,60,000.
I think ಸದ್ಯಕ್ಕೆ 1,90,000 ತಗೊಳ್ಳಿ. Yes. Next.
No, 1 lakh is paid earlier.
So 290 ಆಯ್ತು. ಹಿಂಗೆ ಕೊಟ್ಬಿಡೋಣ.
Short date may be accommodated.
Yes.
Date. When is date?
September, sir.
Number 6.
For the petitioner in this case. This
Matter
is
settled.
is on the
Not
way,
yet.
my lord.
On the
Maybe,
way?
Yeah.
Parties
Discussion-
are coming on the way.
No, no, discussions are
Settlement
going.
is on the way.
Yeah, discussions are going
It
on.
may be called on 25th, my lord. We will report settlement.
Parties to the list submit. The learned counsel appearing for the petition and the respondent submit the talks of settlement between the parties are afoot AFOT. Place the matter on 25th at 4 PM to report settlement.
Much obliged.
Yes.
My lord.
Interim
order
order
may be
extend ಆಗುತ್ತೆ. Don't worry. Yes. Nandkumar sir.
Lord,
What's
I must
this?
point out,
In this case,
His
my
lordship,
lords, for my
sir.
learned friend, my lords, sir.
I just wanted to point out about his lordship, Justice Shanti Bhushan, as his lordship then was appearing.
Now, today, my lords.
Petitioner ಈಗ.
ಅಲ್ಲ,
ಇಲ್ಲ, for
respondent
respondent.
one ಗೆ.
I'm appearing.
Don't worry. Inಮೇಲೆ he will
I
appear.
know. Last,
Just file receive ಆಗಿದೆ.
ಆಯ್ತು, ಆಯ್ತು.
that's the reason I made that.
29th.
Yes.
List on 29th.
Interim order, my lord. I'm on interim bail. That may please be accepted.
Interim bail ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes. The Supreme Court,
Supreme Court's
Honorable
bail.
Supreme Court.
Yes, yes. The order that is subsisting today shall continue till the next date of hearing.
Please, grateful.
My name, my lord.
Legislature will print the name of Councillor Rajshekhar, the learned DS, Rajshekhar appearing for the petition.
Respondent.
Appearing for the respondent. Flow al ಬಂದ್ಬಿಡ್ತು, sorry.
Great.
Report? ಯಾಕೆ ಮೇಡಮ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇರಲಿ ಹಂಗಾರೆ.
Number 7. Sorry, 8.
Petitioners. As this is a matter,
ಏನಿದು
my lord.
ವಿಘ್ನೇಶ್?
Lord, what had happened, my lord, they kept certain FD in, Lord, in the year of 2010. Subsequently, my lord, they are not collected the money. My lord, we, in fact, we found the, my lord, the petitioner, my lord, we have informed them. That after, my lord, informing that, my lord, after 18 years, they, my lord, filed a present petition saying that, my lord, they are entitled for some more money. My lord, in fact, my lord, this honorable court directed me to, my lord, file a, my lord, the memo, which I filed, my lord, on 20th March 2025.
ಅಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ 2015 ಆದ್ಮೇಲೆ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟಿದಾರಲ್ಲ.
Everything we paid.
ಅಲ್ಲ 2015 ಆದ್ಮೇಲೆ ನಿಲ್ಲಿಸ್ಬಿಟ್ರಲ್ಲ.
That is, my lord, some reason is there.
Why, sir?
Whatever entitled.
Money was with you or not, sir?
Me.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ನೀವು ಸಾಲ ಕೊಟ್ರೆ ಇಂಟ್ರೆಸ್ಟ್ ತಗೊಂತಿರೋ ಇಲ್ವೋ ಸರ್?
Interest ತಗೊಳ್ತೀನಿ, my lord.
ಫ್ರೀ ಆಗಿ ದುಡ್ಡು ಇಟ್ಕೊಳ್ಳೋದು ಗೊತ್ತಾ ನಿಮ್ಗೆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ? ಇಲ್ಲಲ್ಲ.
3% interest ಕೊಟ್ಟಿದ್ದೀನಿ. That's what I stated.
3% ಆಗಲ್ಲ
ಅಲ್ಲ,
ಸರ್.
may kindly read my memo.
No,
my lord.
sir.
I read
No
my-
3%,
which is-
sir.
Lord,
Whatever interest a citizen is entitled to, he should get, because bank is ದುಡ್ಡು ಬ್ಯಾಂಕ್ ಅಲ್ಲೇ ಇರೋದು.
ಅಲ್ಲೇ ಇತ್ತು. my lord,
ಹಾ,
kindly see
ಅಲ್ಲೇ
the
ಇತ್ತು,
memo.
ಅದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿರೋದು ಈಗ.
ಅಲ್ಲ, kindly see the memo. My lord, what money.
See, if this court finds that the bank has stopped payment of interest in 2015 after the expiry of 10 years and has kept the amount still in fixed deposit and have not calculated the interest thereon, exemplary costs with costs of litigation would be imposed on the bank. Shall I do it now?
I may permitted to read the memo, my lord, which
Yes,
we have
sir.
paid. Which we have paid.
ಆ ಮೆಮೊ ಆದ್ಮೇಲೆ ಬರ್ದಿರೋದು ಇದು. ಆಮೇಲೆ ಹಾಕಿದೀರಾ ಮೆಮೊ?
The memo ಹಾಕಿದ್, my lord, on my lord,
The memo
28th
was-
March 2025.
Yes, Sunil.
My lords, memo was filed subsequent to the lordship's order, my lords.
Hmm.
Here they say, my lords, FD of year of 2005, my lords.
Hmm.
In one amount, 25 lakhs was kept in FD in the year of 2005, my lords.
Yes.
They say, my lords, it's only for 3 years.
Ah.
And they say the contracted rate is for 6%, my lords. In the other petition, my lords, the FD is of 6 lakhs.
Ah.
That is also done in the year of 2005.
Ah.
In that FD, my lords, they say it's for 3 years for 8.5 interest. Two different interest, and they don't produce all the documents.
ಈ
but
3 years ಗೆ ಎಷ್ಟು 6% ಇಂಟ್ರೆಸ್ಟ್?
in one case they say 6%, in the other case they say 8.5%.
ಈ ಕೊನೆಗೆ ದುಡ್ಡು ಯಾವಾಗ ಕೊಟ್ರು ನಿಮ್ಗೆ ವಾಪಸ್?
Should after lordship's order they paid around 67 lakhs, my lord. That is, it is appearing in the order
60
sheet, my lord.
ಅಲ್ಲ, you should get 1 crore 40 lakhs.
Some calculation is made, my lords, from my client, my lords. I shall produce it, my lords.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಏನಿದೆ ಕೊಡಿ.
Around 1 crore 30 lakhs is what my client is
ಯಾರು?
saying.
The petitioner.
Petitioner, my lords.
He is entitled to get that much.
Entitled to that. And even in the memo, my lords, your lordship can see, they say, my lords, they said after the maturity on 25/3/2010,
Hmm.
they kept it in some RBI, as per RBI circular,
Suspense account.
suspense account, and they don't communicate to me. They only calculate that it's 6%, and in one case 6%, in one case they say 8.5%. They don't produce all the documents. When I approach, they don't give anything. When I approach this honorable court, they come up with this minutes. Only upon your lordship's order, they transfer the amount. Otherwise, that I would not have got.
My lord, they never approach, my lord. In fact, my lord, I'll file an affidavit before this honorable
ಸರ್
court.
ಅದು ಏನಾರು ಆಗ್ಲಿ
ಅಲ್ಲ,
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ದುಡ್ಡು ಇದ್ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್
ಕೊಟ್ಟಿದ್ದೀನಿ,
ಕೊಡ್ಬೇಕಲ್ಲ.
what they are entitled, my lord.
ನಿಮ್
My lord,
ಪ್ರಕಾರ ಅಲ್ಲ, ಎಂಟೈಟಲ್ಮೆಂಟ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಬ್ಯಾಂಕ್
I'll
ಅಲ್ಲಿ
produce the
ಯಾರಿಗಾದ್ರೂ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ರೆ ದುಡ್ಡು ಇಟ್ರೆ
ಇದ್ರಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀನಿ. My lord, what had happened, my lord?
ಈಗ ಫಸ್ಟ್ 2005 ಅಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟಿತ್ತು?
1, my lord, two different FD. One is, my lord,
ಒಂದು
8.5%.
ಅದ ಹೆಂಗೆ?
ಅಲ್ಲ, my lord,
ಅದು 8.5 ಹೆಂಗೆ 6 ಹೆಂಗೆ?
that is, my lord, that point of time they agreed, my lord.
ಅಲ್ಲ ಅಗ್ರೀಡಾ?
ಅಲ್ಲ, that is,
ಅದೇ ಅಗೇನ್ಸ್ಟ್ ದ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಹೌ ಕ್ಯಾನ್ ಸಮ್ವನ್ ಅಗ್ರಿ ಸರ್?
my lord, that is point of time, my lord, we have agreed maybe that
Then
duration.
ಅಲ್ಲ,
duration.
do you treat the customers like this?
No, it's my
ಒಂದೇ ಟೈಮ್ ಅಲ್ಲಿ FD ಆಗಿರ್ಬೇಕಾದ್ರೆ 8.5 ಒಬ್ರಿಗೆ 6% ಒಬ್ರಿಗೆ
ಈ same customer, my lord.
ಪಾಪ ಅವ್ರಿಗೆ ಗೊತ್ತಿರಲ್ಲ ಅಂತ ಏನ್ ಬೇಕಾದ್ರೆ ಕೊಟ್ಟೋಗ್.
My lord, it is not that, my lord, they are not aware. They are aware everything.
ಮತ್ತೆ
They thought
6% ಯಾರು ಒಪ್ತಾರೆ ಸರ್?
thought, my lord, kindly see, my lord, in the 2010 or 2006, whenever they kept an FD, in the year of 2024, my lord, I said that FD is with me. Then, my lord, they approached this honorable court. It is not, my lord, in fact, my lord, I stated in my memo.
ಅದೇ you told FD is with you when you told in 24 ಅಲ್ವಾ? ಮತ್ತೆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ಬೇಕಲ್ಲ ಅಲ್ಲಿ ಅವರಿಗೆ.
Interest, whatever they entitled, I
Entitled
my lord,
ಏನು?
have it, my lord, and my lord, 6.6% and whatever, my lord, 8. Whatever they're entitled as, my lord, what will happen, my lord? Particular period, my lord, FD will be there for a period of 3 years or 4 years or 5 years.
Which bank is this?
Canara Bank.
All right. ಆಮೇಲೆ
My lord, the FD will be for like this, my lord, for a particular period 5 years. After that, if they're not coming, and my lord, they're not extending.
No, if a citizen does not know the nuances of banking, which generally they don't know, ಅದು ಬ್ಯಾಂಕರ್ಸ್ ಮಾತ್ರ ಗೊತ್ತು.
ಎಲ್ಲ ಗೊತ್ತಿತ್ತು.
ಅವು ಒಂದು ದುಡ್ಡು ತಗೊಂಡೋಗಿ ಕೊಟ್ರೆ ನೀವು ಒಂದು 6 ಲಕ್ಷ FD ಗೆ 8.5%, 25 ಲಕ್ಷ FD ಗೆ 6% ಹೆಂಗ್ ಕೊಡ್ತೀರಾ ಸರ್?
ಅದಲ್ಲ, after, my lord, period lapse, they would have approached the bank, my lord, they would have extended, or my lord, they would have enhanced FD.
ಫೈನ್. ಈಗ 2024 ವರೆಗೆ ಯಾವತ್ತು ಎಕ್ಸ್ಪೈರ್ ಆಯ್ತು FDs?
My lord,
2015 ಗೆ ಎಕ್ಸ್ಪೈರ್ ಆಯ್ತು.
my lord, my lord, I'll just read the memo, if my lord
No, ಮೆಮೋ ಅಲ್ಲ.
2009 ಗೆ expire ಆಯ್ತು.
ಹಾ.
The petitioner, Mr. Chandrasekhar, was eligible on auto renewal facility. Deposit had been before 2009, and the maturity
ಈಗ
deposit.
ಆಟೋ ರಿನ್ಯೂವಲ್ ಮಾಡಿದ್ರಾ?
ಮಾಡಿದ್ವಿ, ಅಲ್ಲ 25/3/2010. After the maturity date at 25/3/2010, the petitioner had not claimed an overdue deposit for a period of 10 years. For the overdue deposit amount, the bank has paid prevailing SB rate of interest till 10 years from the date of maturity as per bank policy. The respondent bank has paid interest 10 years from the maturity date of deposit of at SB rate of interest for an amount of rupees 7,58,098. That is rupees so and so. It is submitted that the Reserve Bank of India formulated deep cell in the year of 2014, the Depositor Education and Awareness Fund established by the Reserve Bank of India to hold unclaimed deposits and other amounts that have been inoperative for a period of 10 years or more. Even though 10
What
years.
is your policy on that, Kodi? What is that you have? List the matter on Monday 24th.
Let them also place all the relevant
For the
documents
hearing.
pertaining to FD also, my lord.
ನಿಮ್ದು ಎಲ್ಲ ಕೊಡಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ.
Please.
Yes. ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ದುಡ್ಡು ಇದ್ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ಬೇಕು
They
ಅಷ್ಟೇ.
have to enhance it ಅಷ್ಟೇ. ಅವ್ರು ಬರ್ಬೇಕು, they would have sought, my lord, another 5 years, I would have given the same rate of interest.
ಈಗಲೂ ಕೊಡಿ ಸರ್.
ಈಗ ಅಷ್ಟು ಕೂಡ ಬರೋದಿಲ್ಲ.
ನೋಡ್
What SB rate of interest?
ನೋಡ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದ್ದೇ ಇದೆ. ಎಸ್.
Date, please.
ಮಂಡೇ
Please.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಎಸ್.
Much obliged.
Number 9.
These are two petitions.
ಕೋರಮಂಗಲ and ಇಂದಿರಾನಗರ್.
Matter needs to be heard, Manoj, although there are not too many pleadings by the respondents, no pleadings by the respondents.
Respond, yes, Raghavan sir.
But insofar as demolition, not your lordship had permitted.
I had permitted.
That is now complete, Lord. The BD has now not passed a resolution in May, my lord, 2026. But if they place that under comment, the entire.
ಆಯ್ತು, ಎಲ್ಲ ಕೊಡಿ. ನೀವು ಅಲ್ಲಿ ಏನು ಹಾಕ್ಬೇಕಾ?
No, so I have, I'll file some case law, Manoj, and then there are a few
ಅಷ್ಟೇ.
arguments, Manoj, that I need to. Any day, Manoj, any day with your lordship.
Monday for the hearing.
BD, my lord, has to place that resolution, Lord, so that.
ಆಯ್ತು, Tuesday at 4 PM. For the hearing, heard the learned senior counsel Harsh Narsappa, then Srinivas Raghavan, ಎಲ್ಲರದು ಹಾಕ್ಬಿಟ್ಟು. Next.
Bill number 10.
Some short accommodation.
Why, sir?
Today, some personal inconvenience to the senior. No?
ಎಲ್ಲಿ where is ರೂಪಾ ಮೇಡಮ್? 29ಕ್ಕೆ ತಗೋ.
Please.
List on 29th. Yes.
Admission at 2:30, seal number 110.
Petitioner in this matter, my lord.
Lordship, non-furnishing of records, officer was asked to be present, your lord.
ಕೊಡಿ.
Criminal breach of trust and cheating, my lord.
ಅಲ್ಲ ಅದಕ್ಕಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. Yes, who is that? Who is the investigating officer? What's your problem? You can't give the information or furnish records immediately. ಅಲ್ಲಿದ್ದೀನಿ ಇಲ್ಲಿದ್ದೀನಿ ಅಂತ ಏನ್ ಹೇಳೋದು ಅವ್ರಿಗೆ? I will direct ಯಾವ ರೆಸ್ಕ್ಯೂ ಆಪರೇಷನ್? ಯಾರನ್ನ ರೆಸ್ಕ್ಯೂ ಮಾಡ್ತಾ ಇದ್ರಿ ಮೇಡಮ್?
Is
ಯಾವಾಗ?
human trafficking unit, she is also involved, your lordship. She was in a rescue, that is what is that.
Is the rescue correct or it is coming to a rescue?
It is, your lordship.
ಯಾರಿಗೆ?
Minor girls.
Fine. ಈಗ ಬಂದಿದೆಯಲ್ಲ. This court on 12/8/2026 had passed the following order. The officer is present before the court and would submit that she could not interact with the government advocate for the reason that she was in a rescue operation of securing minor girls. Therefore, the explanation is accepted. The presence of the officer is noted and the presence of the officer is dispensed with in future. All right. ಈ ಕೊಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲ? List the matter on Monday, fresh matters. Next. ಬಂದಿಲ್ಲ ಯಾರು?
Continue, 71.
ಪಾಸ್ವರ್ಡ್ ಏನೈತಲ್ಲ? ಎಷ್ಟಿದಾವೆ? ಪಾಸ್ವರ್ಡ್ ಬೇಡವಾ?
Not this.
ಇಲ್ಲ, ಇದು ಕರೀರಿ ಮೇಡಮ್. One minute, Devanand. I'll just finish off password.
Please.
Password matter. List number 2, seal number 1.
ಇದ್ರಲ್ಲಿ
ಮಾವತ್ತೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲಪ್ಪ?
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ವಿ, ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಆಗ್ಬಿಟ್ಟಿದೆ. ಎರಡು ಕ್ಲಬ್ ಮಾಡಿ ಒಂದರಲ್ಲೇ ಮಾಡಿದ್ವಿ.
ಆಯ್ತು ಸರಿ.
ಅದು 370 ಅಕ್ಯೂಸ್ಡ್ ಬೇಡ ಅಂದಿದ್ದು.
ಆಲ್ ರೈಟ್.
ಮತ್ತೆ
Seal number 3.
Petitioner.
Page number 76, my lord. Para number 76, asset decision.
ಏನ್ ಸರ್ ಇದರದ್ದು?
So only thing is, my lord.
ಇಲ್ಲ, ನಾನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಲ್ಲ ಈಗ. ಅದ್ರಲ್ಲಿ ಏನ್ ತಪ್ಪಿದೆ?
ಬಿ ರಿಪೋರ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು ಅಂತ.
ಒಂದ್ ನಿಮಿಷ. ನಾನು ಏನ್ ಮಾಡಿದ್ದೀನಿ? ಓಪನ್ ಕೋರ್ಟ್ ಡಿಕ್ಟೇಷನ್ ಇದು.
Yes, my lord.
ವಾಟ್ಸ್ ಯುವರ್ ಪ್ರಾಬ್ಲಮ್? ನಾನು ಅವತ್ತೇ ಯಾಕೆ ಹೇಳಿಲ್ಲ?
I was on online, my lord.
ಯಾಕೆ? ಇವೆಲ್ಲ ನಡೆಯಲ್ಲ, ತಾಳಿ ಒಂದ್ ನಿಮಿಷ. ಏನು what is the correction in the order?
As per the, I have to file an objection to seek further investigation.
ಒಂದ್ ನಿಮಿಷ sir. Set aside, matter is remitted back. The investigating officer now permitted to file protest petition if he so desires. So what?
Protest petition. I have to file an application for further investigation.
ಅದು ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ.
Kindly see, my lord, as per Supreme Court.
No. You take it this also to Supreme Court. Nothing doing.
What's the procedure?
Nothing.
Procedure.
No, sir. This court on 1st of July 2026 had passed the following order.
Only one submission.
Nothing. Yes.
Only one submission.
Don't try to obfuscate the issue. I will never get. Yes. This court had passed the following order. Quote the operative portion. The investigating officer who was was permitted to file the protest petition if he so desires. And on the filing of the protest petition, the concerned court was at liberty to pass necessary orders in accordance with law within an outer limit of 8 weeks from the date of receipt of the copy of the order. All contentions except the one considered was kept open. The respondent has now moved a memo on being spoken to on the score that what should have been ordered is an application seeking further investigation. That is not the purport of the order. That is not the order that was passed while dictating it in the court, in the presence of the respondent counsel. Filing of an application seeking further investigation is always open to the respondent. That was not what was considered by this court at that point in time. No further orders apart from what is observed here and above is required in the case at hand. Next.
97 same.
97 same order.
No, let's say we already filed I have to get instruction. We already second time allowed. We have already filed a B report. That's why it's a infructuous.
Infructuous, sir. Sorry, bidi andar.
Next time I
97 list the matter on 25th in the fresh matters list.
Please.
The learned counsel for the respondent submits that a B report has been filed in the case twice over. Therefore, the petition is rendered infructuous. List this matter on 25th.
Please.
In the fresh matters list. Next.
Till number 16.
My lords, matter has been settled, my lords.
Any offense?
106.
Parties are there?
Swimming pool.
This matter.
10 lakh decide
10 lakhs was.
Oh, correct.
We have
Yes.
paid, my lords.
Paid,
Deposit
FD.
ಮಾಡಿ.
ಎಲ್ಲಿ ಹೆಂಗೆ?
FD, my lords.
Fix ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ. The petition called in question registration of a crime in crime number 136 of 2026, registered for offense punishable under section 106(1) of the BNS, which is 304A of the earlier regime, the IPC, Rash and Negligent Act. The case at hand was regarding death of a death of a child of 13 years. The petitioner, the learned counsel for the petitioner tried to made strenuous contentions with regard to the fact that it was not a swimming pool, it was a pit that was drawn for the purpose of agriculture, and the son of the petitioner had complainant had come in and fallen into the pit and succumbed to the breathlessness therein. Therefore, the complaint comes to be registered and the matter was settled between the parties for an amount of rupees 1.5 lakhs initially. Later, it was
1.2. 1.2.
1.2 lakhs initially, which was not accepted by this court, and it was enhanced to 7 lakhs, which was also not accepted by this court, as the life of a child could not be assessed at that amount. Therefore, it was directed the petitioners to increase the amount and get a receipt of a fixed deposit in the name of the mother of the child. Therefore, the petitioners have now complied with it, with enhancing it to 10 lakhs and an FD to that effect. The receipt of FD to that effect is handed over to the mother of the complainant.
Complainant.
To the complainant. The complainant, the interest that the account that the fixed deposit accrues shall be the mother of the complainant. The complainant is entitled to withdraw the interest that gets accrued in the said amount intermittently, and after about 5 years of its deposit is at liberty to treat the account as she wishes, treat the fixed deposit as she wishes. Yes.
Great, my lords.
In the light of the aforesaid, the proceedings stand quashed. Yes, next. Or kotra? Yes. FD receipt kotra? ಸಿಗ್ನೇಚರ್ ಹಾಕ್ಸ್ಕೊ.
Signature. Odd sheet. 68.
I'm appearing for the petitioner. Your Lordship, the petitioners and the complainant, they have a verbal altercation near their private land. ಅವ್ರ ತೋಟದ ಹತ್ರ ಊಟಕ್ಕೆ ಹೋಗ್ತೀವಿ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ, ಬಟ್ ಇವ್ರಿಗಿಂತ ಮುಂಚೆ ನಾವು ಕೊಟ್ಟಿರೋ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಕುಡಿದು
ಊಟ ಯಾರು ಮೊದಲು ಮಾಡಿದ್ದಾರೆ ಅಂತನ?
ಅಲ್ಲ, ದೇಸೆ 7 ಗಂಟೆಯಲ್ಲಿ ನಾವ್ ಅಲ್ಲಿ ಊಟ ಮಾಡ್ಕೊಂಡು ಮಾತಾಡ್ತಾ ಇದ್ವಿ. ಆಗ ಪಕ್ಕದ ತೋಟದ ಮಾಲೀಕರು ಬಂದು ನಮ್ಮನ್ನ ಐ ವಿಲ್ ರೀಡ್ ಔಟ್ ದಟ್ ಅಲಿಗೇಷನ್. The allegation is ನಾಯಕ ನನ್ನ ಮಕ್ಳಿಗೆಲ್ಲ ಇಲ್ಲಿ ಏನ್ ಕೆಲಸ.
ಓದ್ಬಾರ್ದು ಅದಲ್ಲ, ಹರ್ಲಿಂಗ್ ಅಬ್ಯೂಸಸ್ ಅಂತ ಹೇಳಿ ಸಾಕು.
Apologies, Your Lordship. That was made near the private land between these two people having conversation, Your Lordship. For that, they have charged 3 clause 1R and 3 clause 1S and 3 clause 2V.
There's no interim order?
No interim.
Heard the learned counsel appearing for the, I forget your name. Yes.
Shirish Ayyar.
ಅವ್ರು ಕೇಳಿದ್ದ, ನಾನು ಕೇಳಿದ್ದ. Yes. So and so. The petitioner is before the court calling in question proceedings in special case 12 of 2023 registered. Madam, ಇದು 307 ಇದೆ? 326, 307. Atrocities matra will stay. Yes, so and so. The learned counsel submits that the offences under the Atrocities Act are loosely laid against the petitioners as a counterblast to what crime that the petitioners have registered against the complainant. In that light, there shall be an interim order of stay only insofar as the Atrocities Act are concerned till the next date of hearing. Yes.
Grateful, Your Lordship.
Next.
69.
ಇದು ಇಡಿದು. Oh, correct.
My Lord, appearing for the petition.
Nagamma.
Yes.
Yes.
Actually, in this FIR, there are 7 accused are there. Accused number 1 is a husband of complainant. 2 is a father-in-law who passed away recently 2 months back herself. And the third one is Nagamma, is a mother-in-law of a complainant.
Yes, madam. Really?
A4, A5, A6. A4 is a brother-in-law and A5, A6 are sisters-in-law of the complainant. These are got
Interim order, where is that?
My Lord.
Which petition?
Petition number for A4 actually 12090/2023.
A4 120
90 2023 2023 dated 21/10/2024.
21/10/2024.
Yes. And criminal petition number 10805/2023 for accused number 5 dated 3/6/2024. And number 3 criminal petition number 10962/2023 that is for A6 Shobha 5/3/2026. And granted order from this honorable court only.
Anyway, ಬರ್ಕೊಂಡ್ರ? ಇದು A3.
Yes, my lord. And she is a senior citizen. Please take into consideration of the same.
ಬೇರೆ ಎಲ್ಲ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ ಮೇಡಮ್ ಎಲ್ಲರದು, ಮತ್ತೆ 23 ಲೇ ಸ್ಟೇ ಆಗಿದೆ.
And recently she got her husband also, madam. Please take into consideration.
Okay, madam. Wait. Nice. This is also 23. ಅವಾಗಲೇ ಫೈಲ್ ಮಾಡಿರೋದು. It has been framed after. ಬೇರೆಯವರದೆಲ್ಲ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ.
Yes.
Yes. ನೀವು accused number 3 ನಾ?
Yes, my lord.
Yes. I thought tag along with so and so.
Deeply obliged.
70.
For petitioner, my lords, praise time, my lords.
Praise time? No grants time.
Senior, ಹುಷಾರಿಲ್ಲ sir.
Not well.
In fact, I appeared through VC Mode because of my ill health.
ಈಗ ಸರಿ ಇದೆ. ನಿಮ್ಮ ವಾಯ್ಸ್ ಪ್ರಾಬ್ಲಮ್ ಅದಾ? ಸರಿ ಬಿಡಿ. ಆಯ್ತು, praise time, grants time. Not well.
71.
Yes, sir.
My lord, the passage dispute between the two members of the family who are closely related to each other will lead to
ಒಂದೇ ಕ್ರೈಮ ಅವರು ಹಾಕಿದೆ ನಿಮ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಅವ್ರು ಹಾಕಿರೋದು
ಇದು ನಮ್ದು crime. ಅವರು ಹಾಕಿದ್ದಾರೆ.
and in respect of
ಅದ್ಯಾವ್ದು ಪೆಟಿಷನ್ ಇದೆಯಾ?
ಇದೆ
ಎರಡು ಕಾಸ್ಟ್ ಮಾಡ್ಬೇಡ ಕೊಡಿ.
ಅದು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರು ಅವರು.
ಯಾಕೆ ಇದು ನೀವು ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ see the earlier counter case what they had filed
sir
was withdrawn.
7 feet passage between relatives. Why are you wasting the criminal court's precious time?
No, there is a suit pending in respect of.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು more so why are you wasting criminal court's precious time?
And now apart from that, after withdrawal of the proceeding of the counter claim of the counter case, the matter was committed to the Sessions Court.
ಏನ್ 307 ಇದೆಯಾ?
307 ಇದೆ.
ಅದು ಬೇರೆ ಇದೆಯಾ?
And deep cut wound on the temple region. And there they filed an application in the 227 for discharge.
That is
was
rejected.
disallowed. Again they come up here and they obtain this stay.
ಅದು ಕೊಡಿ ನಂಬರ್ ಕೊಡಿ 307 ಇರೋದು.
The SC
ಅಲ್ಲ ಸರ್ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಕೊಡಿ.
criminal petition number. Then 10522 of 2020.
Tag this with 10522 of 2020.
25.
For 2025, 25th. Well,
25th is the hearing date.
ಈಗ ಸ್ಟೇ ಇಲ್ವಾ ಇದರಲ್ಲಿ?
Yes.
ಇದೆಯಲ್ಲ ತೊಂದರೆ ಇಲ್ಲ. 25th, yes. Next.
72.
No representation.
73.
2 weeks. No representation, 2 weeks.
Hearing for the petitioner, your lordships.
Press time.
Press time.
Lordships.
No grants time.
Chandan for R3 months.
Why?
Senior not keeping well.
Senior not keeping well. ನಿಮ್ ಹಿಂದೆ ಇರೋದು ಯಾರು? ನಿಮ್ senior ಅಲ್ಲ?
Respond number 3.
Your lordship.
Chandan.
If I may be allowed to make a submission, your lordship. It's been a mistake on our part. It's been dismissed for DNP, your lordships.
ಇದಾ? ಯಾವಾಗ ಆಗಿದೆ? It is not dismissed, sir.
39/2023, your lordships.
22.
23.
Sir, we are in 26, sir.
Before the court.
Office objection overruled ಎಲ್ಲ ಆಗಿದೆ. Yes. It is not dismissed anyway. You want time?
No, not dismissed. We are ready.
There is no interim order anyway. Yes, at the request of the council appearing for the petitioner and the third respondent, list the matter after 2 weeks. Yes, next.
74.
PCP NDT.
Please, my lord.
Interim order ಇದೆಯಾ?
Interim order ಇದೆ. There is only one page, my lord. I would like.
One page interim order.
Page number 94.
ಏನಾಗ್ಬೇಕು?
2017 ಅಲ್ಲಿ I have resigned. 2024 ಅಲ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿಬಿಟ್ಟು kindly see page number 94, my lord. Resignation also is accepted.
ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಲಿಲ್ಲ ನೀವು ಇಂಟರ್ಮ್ ಆರ್ಡರ್
94.1.
94.1. ಈಗ ಯಾವ್ದು ತಗೊಳ್ಬೇಕು?
94 ಅಲ್ಲಿ ನಾನು
74
ಸಾರಿ 74 ಅಲ್ಲಿ ನಾನು ರಿಟೈರ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿ
ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ?
ನೆನ್ನೆ ಫೈಲ್.
ಅದು ಬರ್ಲಿ ಬಿಡಿ ಅಂದ್ರೆ 74.1 ಕೊಡಿ.
ಪೇಜ್ ನಂಬರ್ 94, my lord.
ಒಂದು ನಿಮಿಷ. ರಿಸೈನ್ ಮಾಡಿದ್ದು ಯಾವಾಗ ಸರ್?
6th February 2017, page number 94, my lord. May I read it, my lord?
Clumax,
Please, my lord.
This is accepted.
Please, my lord.
Page.
Next, same page ಅಲ್ಲಿ. 7th February
We hereby
2017.
accept. All right. ಇದು ಯಾವಾಗ? 2020
ಇದು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಆಗಿರೋದು 2023 ಅಲ್ಲಿ ಮಿಲಾದ್.
17 ಅಲ್ಲೇ ರಿಸೈನ್ ಮಾಡಿದ್ದೀರಾ?
Yes, ಮಿಲಾದ್.
The petitioner is before the court calling in question proceedings in CC 8536 of 2026 registered for offences punishable under so and so, drawing him as accused number 1. The petitioner, who is said to be a reputed radiologist, gets embroiled in the dragnet of crime for the aforequoted offences, not on any act of his, but his past. The petitioner at one point in time was a radiologist in Clumax Diagnostics. He tenders his resignation on 6th February 2017, which comes to be accepted on 7th February 2017. The subject inspection of Clumax Diagnostics takes place in the year 2025 at 2025, and the crime 2023, and a crime comes to be registered, a private complaint comes to be registered in PCR 9993 of 2024, which then becomes CC 8538 of 2026. The petitioner, as observed, is drawn as accused number 1. Therefore, the petitioner is before the court calling in question the said proceeding. The learned counsel Tejasvi appearing for KV, appearing for the petitioner, would take this court through the documents appended to the petition to demonstrate that the petitioner left Clumax Diagnostics about 6 years prior to the date of conduct of inspection, and notwithstanding the same, merely because his name figured in the list of radiologists of the hospital, has been dragged into the web of crime. For 6 years, there was nothing against him, but after 6 years, after 6 years of his exit, the sword of crime is hanging on his head today for no reason. The learned HCGP would, however, seek to defend the action on the score that the complaint is registered, cognizance is taken, it is for the petitioner to come out clean in a full-blown trial. I have given my anxious consideration. So therefore narrated facts lie in a narrow compass in so far as the present petitioner is concerned. The petitioner is drawn as accused number 1 is a matter of record. Why he is drawn as accused number 1 is again the matter of complaint. It is for violation of the provisions of the Act. The inspection admittedly at Clumax Diagnostics takes place in the year 2023. By then the petitioner, by then it was 6 years that the petitioner had quit the job of a consultant radiologist in Clumax Diagnostics. The electronic mail correspondence between the petitioner and the Clumax Diagnostics, which is of the year 2017, is in vindication of the submission of the counsel appearing for the petitioner. It reads as follows, page 94. In the light of the petitioner's absence on resignation and its acceptance 6 years prior to the conduct of inspection, the petitioner could not have been drawn into the web of crime, and for proceedings under the Act, drawing him as accused number 1. On the said score, the petition deserves to succeed. Allowed cost.
ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಫಾರ್
ಅದು ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಹಾಕಿ 74ನ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks ಮಾಡಿ. Next.
75.
Let's, on the last occasion, Millets,
Yes.
On the last occasion, my lords had directed me to file an amendment application, including the quashing of the charge sheet as well, Millets. I have done it yesterday, but Millets, before that, I have a submission.
Really?
Millets, I may have to pursue my lords to again look into the same issue, that the charge sheet was filed after the stay was granted for this purpose, Millets. Last time I had filed an application seeking contempt, Millets. My lords disposed of, saying that no charge sheet was actually filed 5 days prior to the grant of the stay. My lords may kindly look at, I've produced a charge sheet along with the memo on the last occasion, page number, my lords. Let's page number 19 may kindly be taken, which are produced along with the memo, my lords. 19. Ali sheet date, charge sheet date is given as 10/10, my lords.
I got a stay on 15/10, 5 days later.
Hmm.
But my lords may kindly see that what is written in the pen by the Honorable Court, 17/11/25 ಗೆ
Hmm.
check and put up ಅಂತ ಹಾಕಿದ್ದಾರೆ.
Hmm.
So my humble submission is this, that should be the reckoning date when the charge.
See, as far as the investigating officer is concerned, his job is to place the charge sheet before the concerned court. Checking it, putting it, saying that, putting a signature that is checked and found correct and others, some magistrates do it after 4 months. You cannot haul the investigating officer for contempt on that reason. That's what I have written in that. It was, see, the interim order was granted on 15th.
Yes, my lord.
The charge sheet was placed before the concerned court on 10th, 5 days prior to the grant of the interim order. His job was over. Whether the court checks it and signs it and takes it into idu, it's a different thing.
I leave it to
Contempt
the
ಬರಲ್ಲ.
discretion of this honorable court, but
I've
one more
already passed
submission
an
on
order.
this, my lord.
I've already passed an order on it.
Now, I'm trying to convince this honorable court.
On merits,
If
you
my
can.
lords, if my lords are convinced that charge sheet is filed after, irrespective of the order my lords have passed, just in case if my lords want to reconsider it, my lords, the charge sheet may be taken as invalid and I may be heard only on FIR is my attempt, my lords.
What's the use? It's better you come on the charge sheet itself. You will have better material to argue.
Yakandre, my lords, they have definitely fabricated, my lords.
What is
because-
fabric? Charge sheet?
ಅಲ್ಲ ಅಂದ್ರೆ date they have called me on 15/10 only on the date on which I got a stay that they want to serve notice. Now I will produce the documents along with the memo. My lords,
Hello,
we kindly-
why are you getting that touchy about it?
That touchy?
If merits ಮೇಲೆ ಬಂದ್ರೆ it's okay. If you have good case on merits, why you hinge upon that?
I cannot go back, my lords, once I start on merits.
Please, who's asking you to go back? You start on merits. What's the matter about?
It's 498A.
ಅಷ್ಟೇನಾ? ಅಷ್ಟಕ್ಕೇನು ಇಷ್ಟೊಂದು ಮಾಡ್ತಾರೆ?
My lords.
ನೀವು ಹೇಳ್ತೀರ ನೋಡಿ 306 307 ಇದೆ ಅನ್ಕೊಂಡ್ಬಿಟ್ಟೆ.
We know for sure that the date is fabricated.
ಅಲ್ಲ, that's all
the
right.
reason I was just
Merit
trying
ಏನು
to-
ಹೇಳಿ?
ಅದು amendment application allow ಮಾಡ್ಬೇಕು, my lords. Then I'll file the amended petition.
ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇದೆಯಾ ಈಗ?
Interim order ಇದೆ.
ಸರಿ.
Next week date ಕೊಟ್ರೆ.
ಯಾರು? Who are the petitioners?
Petitioners is the husband and mother, father, sister and brother-in-law. My brother-in-law and sister stay in Bangalore. Mother
ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಎಲ್ರಿಗೂ ಇದೆಯಾ?
ಎಲ್ರಿಗೂ ಇದೆ, even including the husband. For this reason that I filed restitution, husband filed restitution, immediately she goes and files 498A.
That's not the ground at all. ಆ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ನಡೆಯಲ್ಲ. ಬೇರೆ ಏನೋ ಗ್ರೌಂಡ್ ಇದೆಯಾ?
There are some materials which I can rely upon, my lords. She has, on the day when she left the house, the previous night she has written a letter, very simple letter saying that we don't get along as husband and wife. ಹೇಳ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ next day. Then she weaves a story in the complaint and says that she was dragged out of the room on the very same night she wrote the letter. And she was threatened.
ಮತ್ತೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಯಾಕೆ ನಿಮ್ಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಯಾವತ್ತು ಹಾಕಿದ್ರು, ಏನ್ ಹಾಕಿದ್ರು, ಯಾಕೆ ಬೇಕು?
Please, my lords.
Yes, sir.
My lords may kindly.
So the charge sheet is filed, my lord.
Huh?
They're filing application.
You forget it. Now you tell me what is it? ಅವ್ರು ಚಾರ್ಜ್ ಶೀಟ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ. ಚಾಲೆಂಜ್.
There is a serious allegations against the petitioners, my lords. Page number 22 is the allegations, my lords. Each and
Against all?
Against all, my lords.
Only husband?
No, against all, my lords.
My lords, that is precisely what I'm
Even
relying on.
the page number 23, my lords, they're relying upon the one letter. The same letter was addressed in the para 3 in page number 22. Regarding that letter is concerned. ದೂರ ಇದ್ದೇವೆ, ಜೊತೆ ಇಲ್ಲ, ಬೇರೆ ಇದ್ದೇವೆ ಅಂತ ಹೇಳಿ ಅದನ್ನು ಕೂಡ ಹೇಳಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ. ಅವ್ರು ಏನ್ ದೂರ ಹೋದ್ರು ಅಂತಾನು ಹೇಳಿದ್ದಾರೆ.
My lords may kindly see for a second.
ಆಯ್ತು, ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲೋ ಮಾಡೋಣ.
Please.
For the reasons indicated in the affidavit accompanying the application, the application for amendment stands allowed. The petitioner to file an amended petition. The interim order subsisting will continue till the next date of hearing.
Next week, my lords.
27th.
Please.
Yes.
I'm so grateful.
ಅದ್ ಬಿಟ್ಬಿಡಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಯಾವತ್ತಾರು ಆಗಿರ್ಲಿ.
Please.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರೋಣ.
76.
Sir.
As a government servant arises accused number 8, lordship.
Kya
The
hai?
basis 18, on the basis of the statement of A11, A12, lordship. The allegation is that he has facilitated money to the jail inmates. and they, jail inmates, and they are using this money for for buddy purpose and for buying some other
Jail
illegal
interest ka.
Yeah, they used to do this kind of business there in the jail. But you kindly appreciate, they have presented
Jail appears to be a world by itself.
90 pages of bank account. There is not even a single transaction which is connected to me, Lordship.
Entry model ಇದೆ.
No entry model is
ಇದೆ.
there. That was in writ petition, earlier writ petition was there, Lordship. Then they filed subsequent charge sheet also.
There is an entry model, sir. Throughout detail order pass ಮಾಡಿದ್ದೀನಿ ಇಲ್ಲಿ.
They may be continued, Lordship.
Detail order is passed. List of 2 weeks entry
Lordship,
model
the difficulty that the government servant got suspended because of this
Agar
case.
28 list on 28 entry
And
model
have it on
subsisting
25th, Lordship.
28 barli 2 days 26th raja ಅಲ್ಲ.
Okay.
Yes. Next.
77.
Your Lordship, I appear for the petitioner in your
For the respondent, I undertake to file wakalat.
Lieutenant Counsel so and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent.
And pray for time to file up.
Fresh time.
138.
Objection. Lieutenant Counsel seeks 2 weeks time to file statement of objections. Yes, next. Entry model will continue.
Your Lordship, the entry model.
Yes, yes, sir. ಹೇಳ್ದೆ ಹೋದ್ರು continue.
13(1)A MLS PC Act.
Petitioner.
Misconduct.
ಮಿಸ್ಕಾಂಡಕ್ಟ್ ಇದೆ MLS. 78 ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ವಿ, 78.1 ಅಲ್ಲಿ ಹಾಕ್ಲಿಲ್ಲ MLS.
ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಒಳಗೆ.
ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಇದ್ದಾರೆ ಯಾರು? ಗುರುರಾಜ್. Anyway, objections if any by the next date, 27th.
Please, MLS.
28th, sorry. Yes.
Protection.
Great.
79.
Offense is 108 and SC/ST Act, my lord.
2 weeks I go. Yes.
Similarly, in
Interim order
respect
there
of 108, there is no interim order, my lord. Your Honor has called for the report from the IO. That was on 27/4/2026, my lord. Report is also submitted. No allegation, my lord. Only through phone, my lord, they have abused the deceased, and then he commits suicide. My lord. He is a security person in the gated community forum.
Investigation papers.
April ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋ
ಈಗ ಕೊಡ್ತಾ ಇರ್ತಾರೆ.
ನೋ ಮೆಟೀರಿಯಲ್ಸ್ ಆರ್ ದೇರ್ ಮೆಲಡ್.
ಅದೇ ನಿಂಗಂದ್ರೆ ಸ್ವಲ್ಪ ನೋಡಿ ಏನಿದೆ ಅದರಲ್ಲಿ.
Through phone, they have abused the deceased ಅಂತ.
ಫಾರ್ಮ್ ಹೌಸ್ ಏನ್ ಫಾರ್ಮ್ ಹೌಸ್? ಅವ್ರ ಫೋನ್ ಅಂತಾರೆ, ನೀವು ಫಾರ್ಮ್ ಅಂತ ಇದ್ದೀರಾ?
They are the owners of
ಕೊಡಿ, ನಿಮ್ಗೆ ಆಗಲ್ಲ.
Shantivana gated community farm, my lord. Shantivana farm was followed. It is a gated community farm, lord, where they have purchased the land from the deceased was the security person. Allegation is through phone, they have abused. Why you are not doing the proper work, and if you are unable to do the work, leave the job. That is the only allegation, my lord. There is nothing is there, my lord.
Yes, this court on so and so Deepthi alವಾಗ ಹೇಳಿದ್ದಕ್ಕೆ. Yes, this court on so and so had date, one ನಿಮಿಷ madam, on 27/4/2026 had passed the following order. A perusal at the investigating papers would clearly indicate that the hurling of abuses which led to the commission of suicide of the husband, complainant,
father
of the complainant was that he was working as a security guard in the community in Shantivana gated community, and the petitioners have hurled abuses saying that his work was not satisfactory. This, in the considered view of the court, albeit prima facie, would not mean that it would amount to proximity, goading or instigation, as is necessary for offence punishable under section 108/306 of the IPC. Therefore, further proceedings, all the further investigation, all the offences shall remain state till the next date.
Maybe covered by judgment. Maybe
ಈಗಲೇ ಕಾಸ್ಟ್ ಮಾಡ್ಬಿಡ್ಲಾ?
Any date may be given, my lord.
Yes, next.
80.
Similar matter, 306. Allegation is I've heard abuses to my uncle. Uncle is
Entry model ಇಲ್ವಾ?
ಇದೆ. It can be disposed of, my lord.
ಬರ್ಲಿ.
My lords, it is
next
served.
next bench will try my discourse.
My lords, covered by decision, my lords. My lords, investigation papers are called for, my lords. There is no allegation, my lords. Only allegation is scolded him.
28th.
Yes.
81.
Appearing for the petitioner, my lordship. Matter settled ಆಗಿತ್ತು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಸೆಟ್ಲ್ ಆಗಿತ್ತು ಬಟ್ ಪ್ರಾಪರ್ಟಿ ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಕೇಸ್ ಫೈಲ್ ಮಾಡಿ
ಏನ್ ಮಾಡ್ಲಿ?
ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡು.
ಪ್ರಾಪರ್ಟಿ ರಿಲೀಸ್ ಮಾಡಕ್ಕ? ಸೆಟ್ಲ್ ಮಾಡಕ್ ನಾನ್ ಡೈರೆಕ್ಷನ್ ಕೊಡಕ್ಕಾಗತ್ತೆ?
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಸೆಟಲ್ಡ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ ಇದು.
ಸೆಕ್ಯೂರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಹೇಳಿದೆ.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
Just check, man. No, I can't give a direction like that. Tuesday, fresh matters. Next.
82.
The petition, my lords.
Ah.
My lords, the complainant doesn't wish to prosecute. She has said the same.
69.
Yes, my lords.
She was here, is it, last time?
No, my lords. She has given her 183 statement, my lords.
Oh, 183 statement. Yes, madam. 183 statement. I am not interested to pursue the matter anta iradu. Yes, Anuparna madam. You took time here and went and moved the division bench? What, madam? Why you don't want this court, is it? Then? Why? I am hearing the matter and why all this suddenly and you took time in the morning and went and made that mention? Pass over in the morning and went and you could have made that mention here only. 1 minute, you could have made a mention here only. Have I not passed an order, judicial order saying all attachment proceedings pursuant to ECI will come here only? Then what is that you are trying indirectly to do there? No, you could have made that mention in the morning itself here. Whatever it is, you could have made that mention here. And what happened there? Nothing. Ultimately, nothing has happened. What happened? You know? No, what happened? You know? You should not lose a court like this.
Yes, we have only brought it to your lordship's knowledge what has transpired at 2:30.
So why on that? You could have informed me. And when I passed a judicial order saying ECIR attachment proceedings will follow, what is that you're trying to do by making a mention following the Delhi High Court judgment which I have considered in that? Then why all this, madam? No, why all that? Argue the matter and close it. Why all these methods? Then
When did you serve? They serve after mentioning. They could have told that to the court.
That's all right. Now you're ready for argument, right? Don't we see if you tell me yes, we are making a mention there, I would have myself adjourned.
Exactly.
Then what? Because in the teeth of my order that is passed, where will I send it? It has to be here only. Then
Lords, my learned friend may be very guarded. Just to say we have informed and pointing a fingers.
No, that's all right. But
when did she inform?
That's all right. Now you're ready. I'll take it at 4:30. Yes.
To say we have informed.
No, you could have told me
counter is
only.
asked.
No, you could have told me only that you're making a mention there. Or all right. Well, for that. Correct. Yes. No, that's why I said you could have told me only.
It is not a voluntary information. When we asked for a counter, that's when he was informed.
It's all right. No problem. Yes. 4:30, madam. 4:30. Madam, 4 o'clock ಗೆ ತಗೊಳ್ಳಿ. Now you served the objections, Anuparna madam. Yes, sir.
Proceedings may be quashed, my lords, in the right.
Proceedings may be quashed. Why?
My lords, she's not interested to.
Not represented also.
Yes, my lords. We served a notice.
Nale fresh matters. 10-8 ಅಲ್ಲ, ಬಟ್ 183 ಶೆಟ್ಮೂಲ್ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ. Anyway, list on 28 one chance ಕೊಡು.
Please.
Interim order subsisting will continue to the next date of hearing.
83.
My lord, in the last date, your lordship had directed HCGB to take instructions. My lord, 498 A, my lord.
Husband?
Yes, my lord. My lord, but the cases earlier it was charged for during the FIR stage.
302, sir.
302, my lord. After that, 498 A.
498 ಆದ್ರೂ ಇರ್ಬೇಕಲ್ಲ.
No, my lord. The allegations are completely different.
Yes, list the matter on 28th ಅಲ್ಲ, 3rd September. Yes, next.
84.
ಎನ್ನೇದಾ?
Petitioner is a superintending engineer working for the Karnataka Power Corporation. A mishap occurs on 4th January 2025 at a power generating plant at Bidadi. She was transferred from Jog to this Bidadi plant on 20th 12/2024. Later, she between 2nd and 5th, she was on leave to shift her residence from Jog to Bidadi. Incident has occurred on 4th. 5th, she came back and resumed the duty. As on the relevant date, she was not a designated factory manager. The factory.
That is on 4th. Why? Because she was on leave.
Not only on leave, then though she has been transferred on 20th, it is not a deemed possession. It has to be intimated to the factory's authorities under Form 7A, which has not been done. She only signed the report on 5th.
SPP, you have to appear in this. ನಾಳೆ ತಗೊಂತೀನಿ ಬೆಳಗ್ಗೆ.
Even it's covered by your lordship judgment.
ಒಂದು ಕಸ್ತೂರಿ ಅವರದಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ ಅನ್ಸುತ್ತೆ ನೋಡಿ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಕಸ್ತೂರಿ ಅವರು ಅಪೇರ್ ಆಗಿ.
No, this is different, my lord. Here what happened, though she is an employee of Karnataka Power Corporation, she is a superintending engineer. The post of superintending engineer, not ex officio post of factory manager.
We'll see. Yes, tomorrow.
Escom,
Vescom, they correct.
No, it's Karnataka Power Corporation.
ಎಲ್ಲ ಒಂದೇ. Yes. Tomorrow. Yes. ನಾಳೆ. But ಇದರಲ್ಲಿ offense is not 304A. 92 and 94 Factories Act.
Is a vicarious liability here. Tomorrow at first list, my lord.
Precarious problem, vicarious liability. Yes.
No, yesterday your lordship ordered for the fresh list, but
Fresh matter ಬಂದಿರೋದು ಈಗ.
Second list ಅಲ್ಲಿ ಬಂದಿದೆ.
ಅದು ಬೆಳಿಗ್ಗೆ fresh matter 50 matter will get over in 15 minutes ಅಷ್ಟೇ.
Let me have that privileged position.
ಅದಕ್ಕೆ ಬರಲ್ಲ, ಅದು separate list ಅದು. That is auto listed matters. It won't come to that.
My prayer is to put me in that privileged list.
Yes, yes. 4 o'clock matter ತಗೊಳ್ಳಿ. ಸರ್ವಿಸ್ matter. ಎರಡು ತಗೊಂಬಿಡಿ.
85.
Section 8 and 12 of POCSO Act, my lord. My lord, the alleged incident.
28th, the interim order will continue to the next.
86.
My lords. Under 138, my lords. After lapse of 7 years, they have filed application for alteration of plea.
Alteration of?
Of plea, my lords.
Company.
Please, my lords. Set found.
Learned counsel of the petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. There shall be an order of stay of further proceedings before. There shall be an interim order of stay of the order ಮಾಡಿದಾರಾ ಈಗ?
Please, my lords.
Order
to put
dated
up
2/6/2026 till the next date of hearing. It is made clear further proceedings are not stayed.
Please, my lords.
Further hearing 4 PM, 112.
kind permission, my lord, I may be permitted to present the original files, my lord, your lordship.
You are for the
directed us.
VTU?
I am for the chancellor, my lord.
On previous occasion, it was directed for respondent number 1 to
Oh, you
produce the
ಕೊಡ್ಬೇಕು.
records. Your lordship.
Records are with me, my lord.
ಕೊಡಿ ಯಾರು ಕೊಟ್ಟರು ಪರವಾಗಿಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ರೆ ಸರಿ.
Government ಹತ್ರ ಇರಲ್ಲ.
Yes. Both the orders are there, my lord.
ಸರ್ಚ್ ಕಮಿಟಿ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ ನೀವೇ ಅಲ್ವಾ?
Extension and
Next
also.
posting is being by respondent number 2, your lordship.
It's
We
on-
formally approve the appointment, that's it.
No, extension order is also there, my lord.
ಹಾ ಆಯ್ತು, ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ. ಹೂ ಇಸ್ ಗೋಯಿಂಗ್ ಟು ಸಬ್ಮಿಟ್?
My lord,
ವೇರ್
my-
ಇಸ್ ಹಿ? ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಅಭಿಷೇಕ್ ವಾಸ್ ಹಿಯರ್.
Senior appears notes for the university notes.
ವೇರ್? ಇದೇ ಮ್ಯಾಟರ್ ಅಲ್ಲ? ಎಸ್ ಸರ್.
My lord,
ಸಬ್ಮಿಷನ್ಸ್ ಆರ್ ಓವರ್ ಸರ್.
my lord, may I just
ನೀವೇ ಮಾಡ್ಬೇಕು.
may I just make a few more submissions, my lord?
ಫ್ಯೂ ಮೋರ್?
ಹೌದು ಸ್ವಾಮಿ,
All right.
ಮೊನ್ನೆ ತೋರಿಸ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ ಎಲ್ಲ.
ತೋರಿಸ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ.
My lord, the documents I could not bring to your lordship's notice.
ಆಯ್ತು.
My lord, I have read to your lordship, my lord, the UGC regulations.
Sir, your submissions were threefold.
Please, my lord.
One is that the search committee did not contain a member of the UGC.
Please, my lord.
So the proceedings in the aftermath of the search committee gets vitiated.
Please.
One. Two, the integrity of the candidate that is continued now is questionable because of 1, 2, 3 incidents, whatever you've indicated. One. Therefore, writ of quo warranto would lie against him on as a person without an integrity is holding the chair, or continuing in the chair. That is the submission.
My lord, one other submission is, my lord, the select committee contained 3 other names, my lord, who were connected with the university. One was the executive committee member. Another, my lord, was the academic council member. Third, my lord, is the former registrar. UGC regulations clearly say that, my lord, the search committee should contain unconnected persons connected with the university.
All right.
And my lord, he was involved in facilitating mass copying of a
Correct.
VTU
The
examination.
integrity. Integrity was questionable.
And no
That,
inquiry has been concluded in that
submission.
regard.
Yes.
My lord, then qualification. My lord, he secured only a second class multi-attempt pass BE degree. So he cannot be called as a distinguished academician.
Oh.
My lord, I have produced his degree certificate. He took more than 4 years, my lord, to pass the degree. And my lord, for 1 year it appears he was detained. He scored, my lord, only a second class in his BE examination.
ಅದು ಫಸ್ಟ್ 3 years ಗೆ ಅಪ್ಲೈ ಆಗಲ್ವಾ? ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾತ್ರ ಇದೆ.
ಅಲ್ಲ, first 3 years also is under challenge, my lord, extension also. The first 3 years also is challenged. And my lord, then my lord, this extension was done, that writ petition was withdrawn and a fresh writ petition was filed. Challenging that.
That was also challenged.
That was also challenged. In this, my lord, that prayer also is contained in this.
Yes. What do you want to show? ಹೇಳಿ.
My lord, your lords may kindly see. My lord, the notification at
page.
1 second, my lord. My lord, page 92.
I am holding WP 28442.
Please, my lord.
Yes.
My lord, page 92, serial number 10.
Amended petition.
ಹೌದು ಸ್ವಾಮಿ, ಅದು ಮೇನ್ ರಿಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಇದೆ. ಅದೇ
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಅಮೆಂಡೆಡ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಉಂಟು?
My lord, it is annexure H3.
Yes.
H4. My lord, page 92, serial number 10. Professor Kripashankar. My lord, he is the member of, at the relevant point of time, my lord, he was the member of the academic senate of the VTU. Then, my lord, your lords may turn to the previous annexure, page 88. My lord, executive council member. My lord, serial number 17 at page 89. Dr. M.S. Shivakumar. My lord, he was the former registrar of the very same university. Then, my lord, one more document, my lord, is annexure H5, page 93. Jitendra P. Nayak, my lord, he was the member of executive council, EC, of the VTU.
All right.
All the 3, my lord, one was the former registrar. and other two, my lord, were the current academic and executive committee members. UGC regulations clearly state, my lord, that prescribe they should be unconnected with the university.
All right.
And degree certificate, my lord, is at then there were series of misdemeanors, my lord, as as the vice chancellor of KSOU, Karnataka State Open University. Those things, my lord, I have produced at page 63, annexure G. My lord, the audit and accounts department of the government of Karnataka, my lord, had called for the account particulars. It was shielded, and my lord, a private account in a private bank, an account in the name of the university was opened. My lord, actually the accounts are required to be operated jointly by the registrar and the finance officer. In the instant case, my lord, a faculty.
So that's the allegation against him earlier.
Previous, my lord, before becoming the vice chancellor, as a vice chancellor of another university.
All right.
My
So
lord,
it touches upon the integrity.
Integrity.
All right.
Integrity and morals. My lord, he shielded all the account particulars.
Aito, integrity and morals. Details and bada.
How? My lord, he, as far as his distinguished academic thing is concerned, my lord, I have produced the degree certificate. It is at annexure B. My lord, page 27. My lord, second class B degree from Bangalore University. Page 27, annexure B.
All right. Yes, sir. Page also.
Page 27, Swami, annexure B.
Yes, sir.
And my lord, this is covered by series of judgments, my lord. If your lordship permits, my lord, already the judgment.
First facts mugispanna amale.
Then, my lord, he was kept under suspension for, that is order at annexure C, page 28. Shri so and so ravaru Pradhyapakaru Mechanical Vibhaga Dean
kept under suspension.
Kept under suspension for allowing mass copying of a VTU examination. My lord, no inquiry has been conducted by the VTU. Now, my lord, he has.
Next.
This is, my lord, to show that his credentials. Then, my lord, the other one is annexure E, page 33, my lord, that is the UGC regulations, which I have read to your lordship on the last occasion.
Yes.
Page 33, my lord, if your lordship permit, I will read only one paragraph. A person possessing the highest level of competence, integrity, morals, and institutional commitment has to be appointed as a vice chancellor. The person to be appointed as a vice chancellor should be a distinguished academician with a minimum 10 years of experience as a professor in a university, 10 years experience in a reputed research or academic administrative organization with the proof of having demonstrated academic leadership. The selection for the post of vice chancellor should be through proper identification by a panel of 3 to 5 persons by a search cum selection committee through a public notification or nomination or a talent search process or a combination thereof. The members of such search cum selection committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. My lord, two of them, my lord, were current academic and executive committee members. One was a former registrar. My lord, as a quid pro quo, after getting selected, he nominated him, my lord, on the EC.
All right.
For 2 terms. Still, my lord, I understand he is continuing as the EC. So, my lord, on this ground, my lord, the appointment is vitiated.
Quid pro quo. Quid pro quo.
Quid pro quo.
EC for VC.
VC, yes, my lord. All EC membership for VC position.
EC for VC.
Please, my lord. My lord, my lord, one sect, my lord, I have furnished.
What is that?
Judgments, my lord.
ಹೇಳಿ.
My lord, ಇನ್ನೊಂದು ಬೇಕಿದ್ರೆ ಇನ್ನೊಮ್ಮೆ ಕೊಡ್ತೇನೆ, ಅದು ಇಲ್ಲ ಅಂತ ಆದ್ರೆ ಅದು.
ಇಲ್ಲೇ ಉಂಟು ಹೇಳಿ. University of Delhi versus Raj.
ಅದಲ್ಲ, ಗಂಬರ್ಧನ್ ಗಡ್ವಿ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಗುಜರಾತ್. First judgment, my lord. The lordship got it, my lord.
Yes, sir. Yes, sir.
My lord, this your lordship gets the relevant portion, my lord, at my lord, judgment starts in page 1.
Hmm.
My lord, may I just read the head note, my lord, instead of reading the.
Yes, sir.
Chancellor, Vice Chancellor, appointment of Vice Chancellor, norms to be mandatorily followed, importance of post of Vice Chancellor, relevance. State Act, if not on par with the UGC regulations held, must be amended to bring on par with the applicable UGC regulation. Until then, it is applicable UGC regulation that shall prevail. Then, my lord, furthermore, the search committee has no jurisdiction to prescribe any diluted eligibility criteria which do not strictly comply with the applicable UGC regulations. Further held, the state of Gujarat and all universities thereunder are bound by the UGC regulations. Appointment of R4 as Vice Chancellor, so and so, so and so. My lord, in the instant case, there was no nominee of the UGC, my lord, on the selection panel. So, sorry, selection committee. My lord, that was held to be illegal. This has been followed, my lord, in not less than 3 to 4 judgments of the Supreme Court subsequently.
Yes, sir.
My lord, your lordship gets it at Srijit versus Dr. Rajeshri, 2023. Then, my lord, Nagendra Singh Bandari
Latest
versus.
is Daru Nayak.
Otherly, it was a continuation for the second term. I think, my lord, your lordship read it. I need not repeat it.
Yes, sir.
My lord, there the Honorable Andhra Pradesh High Court has held that if the initial appointment is bad, my lord, continuation.
That is Daru Nayak.
Daru Nayak. The continuation is bad. Then, my lord.
Now you have to tell me whether the appointment, see, in a quo warranto, the examination is limited. Examination is limited to qualification and appointment per contrary to the mandate of the statute. That is all that is needed.
So
now, under the UGC for an appointment of Vice Chancellor, the integrity question comes into issue. That cannot be assessed in a quo warranto proceeding. Quo warranto is only 2.
My lord,
then we'll consider.
That is
as far as my
7.3.
limited knowledge goes, that is.
My lord, 7.3 clearly shows that, my lord, the selection committee was not as prescribed by the UGC.
All right.
UGC regulations clearly says one nominee of the UGC and other members totally unconnected with the university.
All right.
Here there is no UGC nominee. My lord, I have produced the committee. Your lordship gets it at.
Yes, you showed me that.
My lord. Selection committee, you the selection committee.
Adi alone. Page.
My lord, 1 second. My lord, annexure H, page 85. My lord, Himamshu Rai, Director IIM Indore, Chairman. My lord, he is the nominee of the Chancellor. MS Shivakumar, former registrar.
You are against the last 2.
Against the last 3.
3.
Shivakumar, my lord, was the former registrar. Last 2 were, my lord, one of the academic council.
Former registrar and former vice chancellor. Presently, what was he then?
My lord, presently he was not the registrar. My lord,
so ಯಾವಾಗಲೂ ಒಂದ್ಸರಿ ಅದನ್ನ ಪೋಸ್ಟ್ ನ ಟಚ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು ಒಂದು ಬರೋಂಗೇ ಇಲ್ಲ ಕಮಿಟಿಗೆ.
That is how, my lord, the Honorable Madras High Court has interpreted that. And other 2, my lord, were connected with the university. One was the
other 2, all right. That we'll see. We'll answer that.
Please.
Yes. ಆಮೇಲೆ.
My lord, no UGC nominee. Then, my lord, then your lordship is not considering that, my lord, is merit in a writ of quo warranto. ಅದಕ್ಕೆ ಒಂದು ಡಿಸಿಷನ್ ಬೇಕಿದ್ರೆ ಕೊಡಬಲ್ಲೆ.
ನೀವು ಕೊಡಿ, ನಾನು ನೋಡಬಲ್ಲೆ. ಎಸ್.
My lord, that is your lordship knows JP Kulashrestha versus somebody.
Right.
High second class and 52%. So second class cannot be called as a distinguished academician.
Right.
Then if anything is there, my lord, they made an attempt, my lord, to trap me. My student was set in. He took me by
separate proceeding. ಅದಕ್ಕೂ ಕೋವಾರಂಟೋಗೆ ಏನು ಸಂಬಂಧ?
ಅಲ್ಲ, ಅದಕ್ಕೂ ಕೋವಾರಂಟೋಗೆ ಏನು ಸಂಬಂಧ ಇಲ್ಲ. My lord, next writ petition, my lord, that is not connected to appointment. That is something else.
ಅದೇನು again
ಅದು KSO ಇದು ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಓಪನ್
ಅದು
ಯೂನಿವರ್ಸಿಟಿ.
ಈಗ ನಿಮ್ಗೆ ಅದ್ ಬೇಕಾ ಇದ್ ಬೇಕಾ?
ಅಲ್ಲ ಇದು
ಇದು ಬೇಕಲ್ವಾ?
ಹೌದು, ಹೌದು.
ಇದು ಕೇಳುವ ಫಸ್ಟ್. ಎಸ್ ಸರ್.
I am only for the university. I think the chancellor who has appointed, he has to
Beneficiary or the benefactor?
Beneficiary speak last. Benefactor should speak first.
Yes. ಅದೇ ಜಯಲಲಿತಾ 2003-7 Justice Rajendra Babu. Yes. Benefactor first and the beneficiary later. Yes.
And then root and the weed also may come here.
Yes. Nimans.
Demands.
Yes.
Shekhar versus
Indramma.
Indra.
Yes. So to say.
Lord,
Yes, sir.
Please come to my lord, this act itself.
ಯಾವುದು?
The act, my lord.
VTU.
VTU act.
ಅದೆಲ್ಲಿದೆ?
Certainly section 13(3).
I don't have the act, sir.
My lord, it is produced, my lord, as an annexure.
Page, sir.
Annexure C, my lord, I understand. One second, my lord. I'll just provide the page number. My lord, annexure E, page 30, sorry, my lord, annexure
Writ petition
F.
ಇಲ್ಲಿದೆ. F page 35. Yes, sir.
certainly page 45. Para 13 or section 13. Subsection 3. For the purpose of subsection 2, the committee, my lord, committee is.
ಜಾಗ ಬಿಡಿ ಸರ್. ಮೈಗೆ ಜಾಗ ಬಿಡಿ ಸರ್ಗೆ.
Oh, I'm sorry. No, it's okay.
ಸಂತೋಷ್ ನೀವು ಆ ಕಡೆ ಬನ್ನಿ.
Irli, doesn't matter. Committee, my lord, shall be
Which section, sir?
section 13(3), subsection 3.
Yes, sir.
For the purpose of this subsection, my lord, that is vice chancellor who shall be, for the purpose of subsection 2. Subsection 2 is, my lord, appointment of chancellor from a council, panel of 3 persons who are outstanding in the so and so, recommended by the committee, section 3. So the committee, my lord, shall consist of subsection 3. Member of the academic senate, member of the executive council, representative of the government, person of eminence in the field of engineering, technology, industry nominated by the chancellor. Therefore, my lord, the senate member and executive council member are connected with the university. My learned friend says that, they can't be connected. My submission is the act itself provides for it. One. Secondly, my lord.
No, he is on the UGC and not this.
Yes. Very well. Then, my lord, please look at my lord, this writ petition has been filed after 3 years. Delay and laches is another aspect. Even in
No, that is first appointment. ಇದು ಅಲ್ಲ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿ 3 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದಾರಾ?
ಅಲ್ಲ
ಇಲ್ಲ
ಮೊದಲು ಹಾಕಿದ್ದನ್ನು ವಿಡ್ರಾ ಮಾಡಿ
ಆಯ್ತು.
once extended, once again it was filed.
ಆಯ್ತು.
Then, my lord, we had submitted on the last judgment ಕೊಟ್ಟಿದ್ದಾರೆ Mativannan judgment, where, my lord, their lordship hold that, my lord, the state, if it does not receive any university does not receive any aid from the UGC, my lord, UGC act will not, my lord, apply. My lord, the state act will apply. That, my lord, we have placed before.
So the VTU act will apply.
Oh, yes. Thirdly, more important is, please look at, my lord, the judgment of the Honorable Supreme Court itself. Annexure R4 in our objection statement. Supreme Court has, my lord, this matter came up before the Supreme Court in another companion petition. R4.
Yes, sir. Page, sir.
My lord, page 261 and 262.
261. 261.
The compilation. How a compilation? No? Annexure R4 to R6. ಹೌದ್ರಿ ಅದನ್ನೇ ತೋರಿಸ್ಬೇಕು. 261 ಗೆ ಬನ್ನಿ. R4. Statement of objections filed by fourth respondent.
Objections of fourth
There is no
respondent.
216 at all, sir. It stops at 155.
252. 252.
It stops at 155.
ಎಂತದ ಮಾಡ್ತೀರಲ್ರಿ ನೀವು? ಇದೇನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಏನಿದೆ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ಸಾಹೇಬ್ರ ಹತ್ರ ಬರೀ 150
ಯಾವ್ದ್ರಲ್ಲಿ ನೋಡಿ ಮೇಡಮ್, ಅವ್ರಿಗೆ ಕೊಡ್ಲಿ. ನೀವು ಐಪಾಡ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಗಲ್ಲ.
28442 28442
ಕೊಡಿ ಅದೇನು ಒಂದು ನಿಮಿಷ. ಬಿ ಶಿವರಾಜ್ da. That's the order you're saying. Yes, sir.
Please come to my lord. Petitioner filed the writ petition under Article 226 before the High Court for writ of quo warranto. They declare the appointment of respondent as Vice Chancellor of the University illegal, remove the said respondent from the office of the Vice Chancellor, etc. Please come to the next page.
Oh, VTU dena?
Haudu. Same. My lord. Same petition. Same Vice Chancellor.
Same Vice Chancellor.
Haudu. Next. ಆಯ್ತು ನಾನು ಹೇಳ್ತೀನಿ.
ಆಯ್ತು ಡಿಸ್ಮಿಸ್ಡ್ ತಾನೆ.
Please come.
Yes,
Para 3 ಬನ್ನಿ ಸ್ವಾಮಿ. It was urged. It is urged on behalf of the petitioner that a misleading government has been made before the High Court to the fact that the petitioner suffered punishment so and so disciplinary proceedings. Fact that the matter is that he was eventually exonerated in those enquiries. In fact, ಅವರು ಏನನ್ನ ಹೇಳಿದ್ರು, there was a committee appointed by the former judge of the High Court. My lord, he has said that there is nothing, no illegality. Anyway, may not be relevant for quo warranto.
Para 4 clinches the issue.
So far as challenge the appointment. ಅದನ್ನೇ ಹೇಳಿದ್ದು ಅಷ್ಟೇ. Do not find any merit on the challenge. ಇಷ್ಟೇ ಇದನ್ನ ತೋರಿಸೋದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು ಅಷ್ಟೇ. ಇನ್ನೇನು ಹೇಳೋದಿಲ್ಲ. ಸುಮ್ಮನೆ I don't want ಅದನ್ನೇ ನಾನು ನೋಟ್ ಅಲ್ಲಿ ಅದನ್ನೇ ಹಾಕಿದ್ದೀನಿ ನಾನು.
ಆಯ್ಪಾಯ. Yes. Yes, sir.
ಇಷ್ಟೇ ಇನ್ನಿದಕ್ಕಿಂತ.
Yes, sir.
One thing is.
Now benefactor is over.
That is the thing.
Yes, sir.
In fact, earlier writ petition was filed, maybe by different person.
And another aspect, ಒಂದು ನಿಮಿಷ. If my lord, if the original appointment was held to be valid, extension can't be. That's all I would say.
All right.
I would only add 2 sentences.
Anyway, we'll have to answer quo warranto.
Quo warranto. Whether he is of doubtful integrity.
Qualification, statutory violation.
Statutory prescribed qualifications.
Idya
There is no allegation I do not possess. They may say that I took 4 years to pass. That is not a statutory. Repeaters are not entitled ante ಎಲ್ಲೂ ಬರೀರಿಲ್ಲ. In fact, one view is more number of times he has written the exam.
More experienced.
He will be a better engineer. ಅದಕ್ಕೆ ತೆಲುಗಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ ಪೆದ್ದ ಡಾಕ್ಟರ್ ಅಂತ ಹೇಳ್ತಾರೆ. 11 ವರ್ಷ ತಗೊಂಡ್ರೆ. That is a person who passes MBBS after taking 11 years. He is a big doctor because he would have acquired so much clinical experience while in college itself. More importantly, the 2 judgments I would like to point out is, that is, for extension, all these will not apply. First judgment is State of West Bengal versus Anindya Sundar Das. ಅದು ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ? ಎಲ್ಲಾದರೂ ಇದೆಯಾ?
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಲ್ಲ ಇವರು ಅಧಿಷ್ಠ ಅಥಾರಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ವಿ. This is ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ? In the petitioner's compilation, it is judgment 4.
Yes, sir.
There, my lords may kindly take para 44, 51 and 52.
Sundar Das.
Anindya Sundar Das. State of West Bengal
versus
Anindya Sundar Das.
Yes.
The 44.
Yes, sir.
The Chancellor has been described in section 7(1) as the head of the university. Power of appointing a VC is vested by section 8(1)(b) in the Chancellor. That provision stipulates VC shall be appointed by the Chancellor. Section 8(2)(b) empowers the Chancellor to allow a VC to continue, notwithstanding the expiration of its term, for a period of not more than 2 years at a time, in consultation with the minister. Here again, the continuation is subject to the satisfying state government and on the basis of his past academic excellence and administrative success established during the term of office in the capacity of VC. These words are in terms identical to those contained in section 8(2)(a). Section 8(5) enters the Chancellor the power to appoint VC as a result of temporary inability to VC where a vacancy has arisen. Then kindly go to section para 51 and 52. Para 51.
Yes.
It would be appropriate to analyze whether the reappointment of the VC has to follow the same process as a fresh appointment by setting up a selection committee under section 8(1) of the Act as indicated by the Chancellor. Section 8(c) stipulates the manner in which a vacancy in the office of the VC which occurs by reason of death, resignation, expiration of the term, removal or otherwise shall be filled up. The provision indicates that such vacancies shall be filled up in accordance with the provisions of subsection 1 of section 8. Section 8(6) has to be read in conjunction with 8(1) since the former expressly refers to the latter. The reference to the provisions of subsection for filling up a vacancy on expiration of the term of office will not obviously apply to a reappointment because the procedure contemplated by section 8(1)(b) of a search committee would not attach to a reappointment. On this aspect, the High Court has correctly disagreed with the petitioner before it and noted that the amended section 8(2)(a), which provides for reappointment of a VC for another term, does not require the procedure prescribed in section 8(1) has to be followed for reappointment.
Over that.
Kindly see annexure A, which is the order of extension. This is under section 8(3), which Mr. Uday has already referred to 8(3). I don't want to. 8(3).
8(3) ಅಂತ ಹೇಳಿಲ್ಲ but
ಅದು wait, act ಅದು.
Act.
ಅದು 19(3)
Kindly see this on page 25. Whereas Dr. Vidyashankar S was appointed Vice Chancellor VTU Belagavi under section 13(2) of the VTU Act for a period of 3 years, by a notification GS dated from the date of assuming charge with effect from 30th September 2022, which will end on 29/9/2025.
So next 3 years is extended.
Yes. Whereas as per his request and having perused his accomplishment as the Vice Chancellor of VTU Belagavi and his ideas of further goals to be achieved merits an extension. Now therefore, I so Governor of Karnataka and Chancellor of VTU, using my discretion and in exercise of powers conferred on me by section 13(4) of the VTU Act, hereby extend the term of Dr. Vidyashankar as Vice Chancellor for another term of similar period with effect from 30th September 2025. This is the
So all the nuances that are necessary for the first appointment will not be there for
will not be applicable
for a reappointment.
For a reappointment.
ಇದೇನು renewal of permit ಅಲ್ವಲ್ಲ route.
This is not renewal of permit. Then my lords may kindly see at the page 46 of the writ petition. 45. Section 13 of the VTU Act there. Section 3. The subsection 3 of section 13 deals with constitution of selection committee for the first appointment. Subsection 4 governs the reappointment or extension. Subsection 4 says the term of office of the Vice Chancellor shall be 3 years, extendable by another term of similar period at the discretion of the Chancellor.
So there is no constitution of committee.
There is nothing. It is pure and simple discretion of the committee. If he wants to challenge the discretion exercised by the Chancellor in favor of the fourth respondent, he himself ought to have been a candidate.
No, that is no. Our co-warrant
In a certiorari,
co-warrant ಬೇಕಾಗಿರಲಿಲ್ಲ.
Co-warrant ಬೇಕಾಗಿಲ್ಲ. Co-warrant ನಲ್ಲಿ scope is limited.
Yes.
Limited scope. Kindly see the proviso below subsection 4.
Proviso
Provided that that is about the resignation.
Yes.
Therefore, this appointment is admittedly traceable to subsection 4 of section 13 of the VTU Act. It does not speak of. Then I pointed out that apart, there is another judgment of the Supreme Court, that is Dr. Premachandran Kilot versus Chancellor Kannur University. Year 2024. I think on behalf of the university, it was given, my lord, sir. What do you want? Copy. ಅದು ಇದ್ದಂಗಿಲ್ಲ. ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಇದ್ರೆ ನೋಡಿ, ಅವ್ರು ಕೊಟ್ಟಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ಸ್.
ಇದು ನಿಮ್ದ ನಾರಾಯಣ್ ಭಟ್ ಸರ್?
I am also relying on the same judgment.
Ramachandran?
Idu versus Kannur University.
Oh, yes.
Premachandran.
Yes, yes.
Kilot.
I got it.
Paragraphs 58, 59, 60. Paragraph 58. At the bottom of the left-hand column of page 161.
Yes.
Reappointment of Vice Chancellor has been provided under subsection 10 of section 10 of the Act 1996. The proviso to subsection 10 of the Act now further makes the intention of the legislature to provide for reappointment more clear. The legislature has not thought fit to prescribe any particular procedure or any particular mode or manner of reappointment. The UGC regulations are also silent as regards the reappointment of Vice Chancellor. The language of subsection 10 of section 10 of the Act 1996 is plain and simple. The provision does not confer right to seek reappointment. There is only one way of reading the provision, which is that a Vice Chancellor once appointed, subject to the provision of subsection 10 of section 10, is eligible to be considered for reappointment. What this implies is that an incumbent Vice Chancellor may not have to reapply along with other candidates and compete for the same position once again. Reappointment essentially means the incumbent Vice Chancellor would receive another term of 4 years if the Chancellor deems fit without reopening the position for new applications or without constituting a selected committee. Re means again and is freely used as a prefix. It gives color of again to the verb with which it is placed. Reappointment as an act of process of being appointed again is act or process where the appointment is to be made for the first time or where the same person is being reported second time, but not in continuation of the term. The procedure prescribed under section 10 must be gone through. Here, my term was expiring on 30th of September. The extension has been granted on 3rd September. It is pure and simple, traceable to subsection 4 of section 10. There cannot be any. Then, of course, several things I said, all those things we have placed on record with the objection statement of 4, that suspension. Ultimately, the disciplinary proceedings concluded by an order passed by the management of the Vakkaligar Sangha, where they said,
and one
the
more
proceedings are dropped.
Then Senior Counsel Udayala sir said that the judgment, you don't receive any grants, then UGC is not applicable.
Yes.
Which is that judgment?
Mathivannan's and two
Manivannan, all right. Yes.
Then another thing they said, my name was included in the FIR. Charge sheet has been filed where I have been dropped. My name is given up. This is my lord's just.
Was the part of the PIL.
KSOU. PIL ಹಾಕಿದ್ರಾ?
PIL ಬೇರೆಯವರು ಹಾಕಿದ್ರು. Otherly, that was a charge. Against the petitioner, there was an injunction not to reveal that. On that ground, my lord, that PIL was dismissed, not on merits.
All right. Yes.
Not on that. Not
My
on
lord, may I
merits.
just, by way of
Lords, I
reply.
beg to appear for the Vice Chancellor. May I make a submission?
Sir appear ಆಗಿದ್ದಾರೆ.
I appear for the university.
University. He is appearing. Yes, sir.
Lordships. My lords, before I go into the merits.
1 minute, sir. Sondi sir, 1 ನಿಮಿಷ.
Please, my lords, I'll wait.
Judgment lordships wanted Mathivannan and Uttarakhand. Nodi.
Oy, Kalyani Madhivana. Yes. That's all. Yes.
Before is my lord that state of Uttarakhand versus Sudhir Budakot.
No problem. Kalyani Madhivana.
This my lord, sir, about the conduct of the petitioner who questions even under co-warrant. That is Srinivasa Reddy is relevant, my lord. That's 84 to 87.
Yes.
About the conduct. Paragraph 51 to 54 is the limits of
co-warrant. Lakshmanan.
Yes, my lord.
Yes, sir.
Not single, division bench.
ಅಲ್ಲ ಜಸ್ಟಿಸ್ AR ಲಕ್ಷ್ಮಣನ್
CMP ಇಲ್ಲಾದ್ರೆ ಒಬ್ಬರೇ ಕೂತ್ಕೊಂಡು ಬರೀತಾರೆ.
ಅಲ್ಲ ಜೊತೆಗೆ ಆತರ ಅವರೇ ಅಲ್ವಾ?
ಹೌದು. ಡಾಕ್ಟರ್ ಲಕ್ಷ್ಮಣನ್.
ಡಾಕ್ಟರ್ ಲಕ್ಷ್ಮಣ್, AR ಲಕ್ಷ್ಮಣ್. Justice Dr. AR Lakshman.
Yes, sir.
Yes, sir. Anything in re?
Yes, my lord.
Because this is reappointment.
Please.
Lords, may I in the meanwhile make my
Oh, yes, sir. Let's only, sir, finish. Yes, sir.
Lordships forgot about me.
No, sorry, sir.
I realize
So that,
I'm on VC.
No, that is No, that is beyond possibility.
I'm so grateful.
Yes. Sir.
Well, before I make a couple of submissions on merits, there is one submission on the conduct of the petitioner that I want to highlight. There is an IA for dismissal that we have filed. Basis a development that took place while the matter was seized off.
Sir. Yes. Abhishek.
On 3/2/2026, when the matter, my lords, had been heard before an earlier bench.
Yes, sir.
A demand was made, my lords, on this respondent by the petitioner for payment of 1 crore to withdraw the case. And this is, yes, and this is not a bald or irresponsible statement I'm making. I promptly registered an FIR and there is a charge sheet for extortion now laid against this gentleman.
I have also registered a.
Sir,
You will reply.
wait.
Yes.
I know my friend would like to say something. Their
Yes.
FIR, a B report is filed. It's a counter blast. On my FIR, there is a charge sheet filed, and I have placed that before your lordships, along with my IA, my lords, for dismissal of the petition, and with a copy of my complaint and the charge sheet.
It's
So,
on
my lord,
record.
it's on your lordship's record.
Yes.
And I'm requesting my colleague to just point out the page number. The IA for dismissal is there, my lord. The charge sheet came a little later. Charge sheet was filed a little later. That was also placed before your lordships with a memo. Now, my lords, in a quo warranto, even more than an ordinary writ petition, the conduct of a petitioner, my lords, has to be absolutely clean. Because your lordships are aware, quo warranto is the one writ where locus is ordinarily relaxed. But it is relaxed with a corresponding duty on the part of the petitioner to have absolutely clean hands. And this fact, my lords, in my very respectful submission, is sufficient to reject the petition, my lords, on conduct and equity. And there is a related conduct development, which is that earlier your lordships are aware a PIL was filed. That PIL came to be dismissed, my lords, with strictures on the petitioners therein. Here, the writ is filed by way of a private writ petition, not as a PIL. Possibly because the disclosure requirements, my lords, under the PIL rules may be higher. I do not know what considerations weighed with the petitioner.
That's why quo warranto. Yes.
Even there, my lords, the challenge was to my appointment.
That is read with quo warranto. It's pure quo warranto. Yes.
Sum and substance, my lords, quo warranto, whether a PIL or not, the locus requirement is generally relaxed.
Correct. Yes.
So, but my lords, in that PIL, when the petition was dismissed, the petitioner therein, represented by my learned friend there also, though a different party, took the matter to the Supreme Court. And there, my lords, I do not know if the order of the Supreme Court has been brought
That
to your
is
lords.
Shivraj.
That's right.
Yes.
Lords, your lordships have perhaps seen para 3 and 4.
Para 4 is enough. Yes.
Yes, my lords. Challenge to the appointment of R3 as Vice Chancellor is concerned, we do not find any merit in the challenge. So, arguments were made on merits on these very grounds, and arguments were made, my lords, also to entertain the PIL, saying that his conduct was all right. The SLP was dismissed with liberty to file a review. I'm instructed no review has been filed. But be that as it may, on the merits, my lords, that order closes the issue. Lordships have also seen, my lords, section 13, which my esteemed friend Mr. Rajgopal had pointed out, that the extension under 13.4 is very different from the in limine appointment. Virus of 13 or 13.4 is not in question. Much water has flowed. I have already completed one term as the Vice Chancellor. No challenge was brought except at the fag end, my lords, in the PIL. And one of the observations in the PIL was laches. Now here there is no challenge, my lords, to the virus of 13.4. Under 13.4, my lords, the extension is at the discretion of the Chancellor. It's a very different consideration. It's not even a reappointment in that sense, my lords. It is an extension. And therefore, to link it to the original appointment, my lords, would be reading the UGC regulations in a completely misconceived light, as the petitioners have sought to do. And the extension, my lords, is granted by the Vice Chancellor. The order granting extension is in your lordship's file. after considering, my lords, the report from the government, the credentials of the petitioner and various other factors, a speaking order is passed, my lords, by the Chancellor in exercise of this statutory power. And certainly, my lords, as far as 13.4 is concerned, UGC regulations have absolutely no overlap. On the larger question, my lords, of the applicability of the UGC regulations, my lords, learned senior Mr. Holla has referred to two orders. There is also the judgment in Loknath of a division bench of this honorable court that when it comes to institutions that are not funded, then the UGC applicability itself is doubted. And my lords, in fact, I think your lordships have already seen the other orders also. I don't want to repeat the orders, my lords, in Kalyani and others. So there is the larger question, my lords, of applicability of the Act itself. And one other aspect is, my lords, keeping aside all other questions, is that, my lords, under section 19 of the Act, the authorities of the university, a nominee of the UGC is ex officio a member of the Executive Council. So any which way, this submission that UGC's blessings have not been obtained, my lords, for the appointment of the Vice Chancellor really is a nominal or a notional submission, because the UGC is in the know of what has happened. The situation under the VTU Act is very different from the other statutes that have been interpreted, my lords, by the Kerala High Court and other courts. Here, UGC is represented ex officio in the Executive Council. I believe your lordships have seen that, my lords. Yes. And on that extension, since I made a reference to it, page 25, my lords, is the order of extension granted by the Chancellor in force since 3/9/2025, basis the report, my lords, placed by the state. So those are my submissions, my lords, on merits, but I would very respectfully request your lordships to consider, my lords, the conduct of the petitioner. It's not a bald allegation. There is a charge sheet laid against them, basis the direct allegation of trying to influence, my lords, not only this is not about the parties, my lords, this is about the purity of the process of the court. And that is today the subject matter of the charge sheet, and also, my lords, the background of the PIL that was filed leading up to this petition. I'm grateful.
Yes, sir. But sir,
My lord, first submission, my lord, by senior counsel Mr. Uday Holla is that, my lord, if no aid, Mathivarnan, and not applicable. My lord, the statute clearly says, your lords may kindly turn to Annexure E.
statute is UGC or
UGC. It clearly states that, my lord, these regulations may be called as university grants, minimum so and so regulations, appointment of teachers and other academic staffs in universities, colleges, and other measures for maintenance of standards in higher education regulations. These shall apply to every university established or incorporated by or under the Central Act, Provincial Act, or a State Act, every institution, including a constituency or affiliated college recognized by the Commission in consultation with the university concerned, so and so, Section 2 of the Universities Grants Commission Act, and every institution deemed to be a university under Section 3 of the said Act. There is no reference to aid. Added to that, my lord, I have filed an affidavit. My lord, if your lordship finds it difficult to trace it, I'll provide it.
find it difficult to
Trace it.
Good.
Fine. My lord, Annexure L6, page 5. My lord, it is a notification of 1999. My lord, this university was established somewhere in 98 or 99. A new university, namely Vishweshwaraya Technological University, Belgaum, has been established by an act so and so of Karnataka State Legislature and notified by state government notification so and so. The said university is included in the list of universities maintained under Section 2F of the UGC Act. The above university has, however, not been declared fit to receive central assistance in terms of the rules under Section 12OB. Then, my lord, this university made an application, Annexure L7, page 6. proposal for inclusion of the list of universities under section 12B of the UGC Act. This is addressed to the VTU in the year 2018.
Yes.
This is in reference to so and so. The committee considered the report of the UGC inspection committee along with the complaints submitted by the university. Committee decided to recommend approval of 12B status to the university so and so Belagavi. The university is advised to get a NAC accreditation at the earliest. The recommendation of the committee along with the report of the UGC inspection committee were placed before the commission on 5/27 so and so so and so. The commission considered and approved the recommendation of the committee and the university is included in the list under section 12B. 12B, my lord, if your lordship sees, it is pertaining to grant of aid. Your lordship may kindly see next document, annexure L8. My lord, the relevant portion, my lord, is at page 11. Serial number 104. Vishwesvaraya Technological University, Jnana Sangama Belagavi, page 11 top ali. Adu shade ಮಾಡಿದಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಪರವಾಗಿಲ್ಲ.
My lord, this is a university, my lord, registered for grant of aid. My lord, how much aid is received, my lord, from the UGC? How much aid is granted by the central government? My lord, the custodian of the record is the university. I do not have any access. So it is incorrect to state that this university is not receiving aid. It is not a factually correct statement. You make an application that I want aid. My lord, that is taken after inspection, my lord, the UGC allows that. You are registered under 12B to receive aid. You cannot say that I am not at all receiving. Maybe when it was established, it was not receiving. From 12,018 onwards, my lord, it is registered for aid.
12,018?
2018 ನಂತರ ಅಲ್ಲಿಯವರೆಗೆ aid ಇರಲಿಲ್ಲ. My lord, then my lord, another submission was that state act ಪ್ರಕಾರ ಮಾಡಿದ್ದೀವಿ ಅಂತ. My lord, there are two Supreme Court judgments. One is Gamardhan Gadiv. My lord, even if it is a regulation framed under the UGC, my lord, it becomes a part of the act and it will prevail over the state act. States have been advised, my lord, amend their regulations. If they don't amend their act, my lord, the Honorable Apex Court has observed that it shall be the UGC regulation alone which will govern the field. If that is the position in law, my lord, without inclusion of the UGC nominee and including two members, my lord, who are the sitting members of the EC and academic council, my lord, the selection is bad. In a writ of quo warranto, there is no delay and laches.
Don't worry about that. Don't labor on that at all. Yes.
Then
As long as he is holding the post, there is a ground. Yes.
Then my
Co
lord,
warrantoಗೆ ನೀವು ಲಾಸ್ಟ್ ಡೇನೂ ಹಾಕ್ಬೋದು.
then my lord,
ಡಿವಿಷನ್ ಬೆಂಚ್ ಒಂದು ಲಾಸ್ಟ್ ಡೇ ಕೋ ವಾರಂಟು ಕೊಟ್ಟಿದ್ದಾರೆ. Yes.
my lord, then one more submission is that, my lord,
Huh?
Supreme Court ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, delays of no consequence.
ಅಲ್ಲ, in this court, next day he was to retire, previous day it was pronounced co warrant. Yes.
then my lord, the next submission is that, my lord, the extension is required to be done, my lord, on his own by the appointing authority, the chancellor. It is not, my lord, on a request made by the sitting vice chancellor or on a recommendation made by the government of Karnataka. That, my lord, your lordship gets that.
Will that vitiate the reappointment?
It will vitiate the reappointment. That is, my lord, what has been observed in that Kannur University, which your lordship referred, my lord.
All right. Yes.
My lord, I'll just read it, my lord, for my satisfaction.
No, sir. Even my satisfaction also he reads.
My lord, point number 4 points were framed, my lord, by the Honorable Apex Court. Your lordship gets those 4 points, my lord, in. My lord, page 83 of that today just given bench, my lord.
Yes, sir. Page 83.
Page 83 ಅಲ್ಲಿ ಇದೆ.
Yes, sir. ಇವಾಗ ನೀವು ಕೊಟ್ಟದ್ದಲ್ಲ?
ಈಗ ನಾನು ಕೊಟ್ಟದ್ದು. My lord, senior counsel Mr. Rajgopal read that.
ಹೌದು, ಗೊತ್ತು, ಇಲ್ಲೇ ಉಂಟು, ಹೇಳಿ.
Page 83 ಅಲ್ಲಿ 4 points are framed on the left hand side, your lordship gets it. Having para 40. Having heard the learned counsel appearing for the parties and having gone through the material on record, the following questions of law fall for our consideration. Whether the reappointment permissible in respect of tenure post, whether the outer age limit so and so, whether the reappointment of the vice chancellor has to follow the same procedure. Fourth, my lord, all the three are held against the petitioners, writ petitioners. Fourth, did the chancellor abdicate or surrender his statutory power of reappointment of the vice chancellor? My lord, this finding on this is, your lordship gets it at para 81. My lord, para 80.
Page 93.
Page 93. It appears from the press release issued by the Kerala Raj Bhavan dated so and so that the opinion of the Advocate General also sought for in connection with the reappointment of the respondent number 4 as Vice Chancellor. The very first para of the press release states that Kerala Raj Bhavan strongly refutes the claim in some news reports that it was on the direction of the Honorable Governor that the name of Dr. Gopinath Ravindran was suggested for reappointment as Vice Chancellor Kannur University.
On this point, it is held vitiated.
It is held vitiated. Here, my lord, recommendation of the government.
Para 86.
Para 86. So, my lord, your lordship may see the records. My lord, according to their submissions, they took the report of the government of Karnataka and the representation of the sitting Vice Chancellor. My lord, if that is so, this para 4 applies. My lord, finding on para 4 applies and this is vitiated. Next submission is, my lord, special leave petition dismissed. My lord, friends did not read the entire order of the special leave petition. My lord, Shivraj. This honorable, my lord, I appeared for Shivraj. My lord, there was an injunction against one of the petitioners, not against Shivraj, not to make a statement on his sex scandals. My lord, there was a criminal case for harassment of a woman in workplace in KSOU. Fourth respondent. Shivraj. Fourth respondent. My lord, that the another petitioner, my lord.
Other facts
that was dismissed on that ground. There was an injunction operating against one of the petitioners not to divulge, and this fact was divulged, my lord, in the PIL. When there was an injunction, he should not have divulged. So his on his conduct, my lord, it was dismissed. In the writ petition order, my lord, this honorable court has observed that we are not touching the merits of the case, and we are only dismissing on this ground. Is the observation. This honorable court did not touch the merits. My lord, if your lordship.
That was taken to the Supreme Court.
That was taken to the Supreme Court. May I just pass on that judgment, my lord? My lord, may I just pass on that judgment, my lord? I have only one copy. My lord, I'll just read one sentence and pass it on, my lord. However, in our considered opinion, petitioners rights and petitions have not approached the court with clean hands, clean heart and clean objective. This apart, there is a short unexplained delay on the part of the petitioner calling in question. So and so, so and so. Then it has been settled position in the domain so and so, my lord, they observe. In the above circumstances, these petitions are dismissed with cause having been made reluctantly easy. We make it clear that we have not expressed any opinion as to the regularity or otherwise of the entire proceedings that culminated in the appointment of the third respondent in this petition as Vice Chancellor of the fifth respondent university. It is also made clear that the observation here in above made being confined to the disposal of these cases. Then, my lord, the matter went to the Supreme Court. Here nothing is decided on merits.
Supreme Court, nothing is decided on merits.
My lord.
But paragraph 4 only, it is said.
My lord, it is true. My lord, no notice is issued. My lord, on that.
No notice is
not. No notice is issued. It was a dismissal in limine. If such an observation is.
Limine ishtond baradra.
Haudu.
And limine hoytadu.
Alla, limine hogalla. If SLP is dismissed, my lord, I may be permitted to.
It's no ground dismissed at the limine.
ಅದಾದ್ರೂ ಹೀಗಿದ್ದ ಅಬ್ಸರ್ವೇಷನ್ ಇದ್ರು ಬರಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದೆ.
ನೋಟಿಸ್ ಕೊಡದೆ ಮಾಡಿದ್ರೆ ಲಿಮಿನಿ ಅಂತ.
ನೋಟಿಸ್ ಕೊಡದೆ ಮಾಡಿದ್ರೆ ಲಿಮಿನಿ ಅಂತ ಇದೆ. Your lordship may kindly take, my lord, the bunch which I have provided.
I am in that bunch only, sir. Yes.
My lord, first is first judgment. My lord, para 7. My lord, it is at page. My lord, para 7 ಬಂದ್ಬಿಟ್ಟು page 13 ಅಲ್ಲಿ ಇದೆ.
Para 17, sir.
ಅಲ್ಲ, para 13.
13.
ಅಲ್ಲ, page 13, para 7.
Huh.
So far as the first question is concerned, Article 141 of the Constitution unequivocally indicates that the law declared by the Supreme Court shall be binding on all courts within the territory of India. The aforesaid article empowers the Supreme Court to declare the law. It is therefore an essential function of the court to interpret legislation. The statements of the court on matters other than law, like facts, may have no binding force, as facts of two cases may not be similar. But what is binding is the ratio of the decision and not any findings of fact. This, my lord, your lordship may kindly see. SLP dismissed in limine, SLP dismissed with some observation, one sentence observation, not touching the merits. SLP dismissed after grant of leave, my lord, civil appeal is registered and one sentence order is passed. Then, my lord, a detailed order in civil appeal. In the two former cases, where SLP is dismissed by one sentence or one paragraph order, my lord, the Honorable Apex Court has held that it is not a binding precedent and it is not a finding on merits. My lord, the second judgment on that is, my lord, 2019 6ACC, page 270, para 9.2. My lord, your lordship gets it at page 24. My lord, the relevant portion is 9.26 and para 9.27. My lord, finally the High Court had relied upon the decision of Muktiranjan Acharya versus so and so to hold that the promotions could be given under so and so, so and so, so and so. The counsel for the contesting respondents prayed for dismissal of the present civil appeals by submitting that the said decisions had not been affirmed by this court wide order dated so and so. It is well settled principle of law emerging from catena of decisions that, including Supreme Court Employees Association, that dismissal of an SLP in limine simply implies that the case before this court was not considered worthy of examination of reasons which may be other than the merits of the case. Such in limine dismissal of the threshold without giving any detailed reasons does not constitute any declaration of law or a binding precedent under 141. My lord, there is one more decision, my lord, 2000, volume 6 ACC 3459.
Sir, that is rudimentary. In bad. That is too rudimentary.
ಆಯ್ತು, ತಾವು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ನಾನು
ಅಲ್ಲ ನೀವು ಓದ್ಬೇಕಂದ್ರೆ ಓದಿತ್ತು
ಅಲ್ಲ ಓದಲ್ಲ. ಅದರಲ್ಲಿ ಹೇಳಿದೆ ಅಂದ್ರೆ ಹೀಗೆ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿ SLP ವಿದೌಟ್ ನೋಟಿಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಅದು ರೆಸ್ಟುಡಿಕೇಟ್ ಅಥವಾ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಫೈಂಡಿಂಗ್ ಅಂತ ಬೈಂಡಿಂಗ್ ಅಂತ ಇದೆ. ನಾನು ತಮಗೆ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ದಿನನಿತ್ಯ ತುಂಬಾ ಜನರಿಂದ ಇದನ್ನು ಕೇಳಿಸ್ಕೊಂಡು ತಾವು ಬೇಜಾರಾಗಿರ್ತೀರಿ.
ಇಲ್ಲ ಆತರ ಏನಿಲ್ಲ. ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನು ಬರೀಲಿಲ್ಲ ಅಂದ್ರೆ, ರೇಷಿಯೋ ಇಲ್ಲ ಅಂದ್ರೆ ದಟ್ ಫೈಂಡಿಂಗ್ ಇಸ್ ನಾಟ್ ಬೈಂಡಿಂಗ್.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ even otherwise we do not find merits in the contentions ಅಂತ. ಮೆರಿಟ್ಸ್ ಏನು ಹೈಕೋರ್ಟ್ ಏನು ಕನ್ಸಿಡರ್ ಮಾಡಿದೆ ಅದರಲ್ಲಿ ಮೆರಿಟ್ ಇಲ್ಲ ಅಂತ. ಹೈಕೋರ್ಟ್ ಮೆರಿಟ್ ನಲ್ಲಿ ಏನು ಹೋಗೇ ಇಲ್ಲ.
ಅಲ್ಲ ಅದಲ್ಲ, 4ನೇ ಪ್ಯಾರಲ್ ಇರುವುದು ಹೈಕೋರ್ಟ್ ಮೆರಿಟ್ ಅಲ್ಲ, ಕ್ಯಾಂಡಿಡೇಟ್ ಚಾಲೆಂಜ್ ಮೆರಿಟ್ ಇಲ್ಲ ಅಂತ.
ಸ್ವಾಮಿ ನಾನು ಓದಿ ಬಿಡ್ತೇನೆ ಅದನ್ನು.
ಅಲ್ಲ ಇರ್ಲಿ ಬಿಡಿ,
ಓದ್ಬಿಡು. My lord, para 3, my lord. It is urged on behalf of the petitioner that misleading governments had.
ತಗೊಳ್ಳಿ.
Thank you, my lord.
Some more energy.
I am grateful to your lordship.
Yes, sir. Water.
More energy is required, my lord, to offer.
That is why I gave it to him.
ಅಲ್ಲ ನಮಗ್ ನೀರು ಕುಡ್ಸಕ್ ಬಂದು ಅವರೇ ಕುಡಿತಾ ಇದ್ರು.
ಓ,
ನಾವು
ಈಗ ಅವ್ರು ಕುಡಿದ ಮೇಲೆ ನಿಮಗೆ ಕೊಡಿಸ್ತಾರೆ ಇರಿ. ಬಂತ
ಬಂತು. It is urged on behalf of the petitioner that the misleading government was made before the High Court to the fact that the petitioner had suffered punishment pursuant to disciplinary proceedings. The fact of the matter is that he was eventually exonerated in those inquiries However, petitioner did not get any opportunity to bring the such material on record before the High Court. It is also contended that the other circumstances, either punishment to petitioner, my lord, to impeach the integrity of the petitioner, they produced some show cause notice issued by the government. Ultimately, my lord, it ended in his exoneration.
That is Shivaraj.
Shivaraj. So far as the challenge to the appointment of the respondent number 3 as Vice Chancellor of the university is concerned, we do not find any merit in such a challenge. The view taken by the division bench of the High Court does not warrant any interference. As regards to the adverse comments made by the High Court, so and so, eitherly merit na mele agli, UGC regulation ಬಗ್ಗೆ agli, this honorable court also did not debate, nor, my lord, there is any observation on the appointment or following the UGC regulation or any such thing. In that view of the matter, my lord, my respectful submission is this cannot be treated as a precedent, and the Honorable Supreme Court itself, my lord, in Kunyamat case has observed these 4 categories. SLP one line dismissal, without notice SLP dismissal with some observations. Kunyamat, my lord.
Kunnayamat, 2008 ACC, yes. Justice Thomas Ordu, yes. Amale.
Then, my lord, my
That's followed in Code, sir, in 2018. 3 judges. Yes.
Ade Code Distillery versus Madheshwara Sugar.
Yes.
Then, my lord, my learned friend Mr. Sodhi, my lord, was on B report and registration of charge sheet.
Sodhi, sir, why you went away?
My lord,
I'm here.
So visibility had gone.
My lord, I have filed a detailed affidavit, my lord, what transpired and how all these things have happened. My lord, my lord, to trace it would be difficult, my lord. I have one extra copy, my lord.
Kodi sir, ಎಲ್ಲ ನಿಮ್ಮ extra copies ಇದೆ ಇಲ್ಲಿ ಕೊಡಿ. ಈಗ ಗೊತ್ತಾಗ್ತಾ ಇದೆಯಾ?
ಇದರಲ್ಲಿ ಇನ್ನೊಂದು IA ಅಲ್ಲಿ ಡೀಟೇಲ್ ಆಗಿ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೇನೆ.
ಅಲ್ಲ ನೀರು ಯಾರು ಕೊಡಿಸ್ತಾ ಇದ್ದಾರೆ? See the decibels now.
Sorry, first.
Yes.
One second, my lord. My lord, one Mr. Narayan Swami was my student. I was a guide to him with another professor by name Venkatesh for his PhD studies.
ಯಾರು ಇದು petitioner?
Petitioner alla.
Shivraj.
Petitioner was a guide to one Mr. Narayan Swami who is working in this VTU. He is an assistant professor. My lord, I was his guide for his PhD studies. My lord, this FIR and all is emanating from that.
All right.
This Shivaraj, my lord, sends me a one of 26.
Narayan Bhatt sir, cows are coming back.
Pardon, my lord.
Cows are coming back.
My lord, sorry, my lord.
Yes.
My lord, what happens is if papers are more, my lord, it becomes difficult to trace them.
Yes.
My lord, I'll read the affidavit. I so and so. I state that I was the research guide to Dr. Narayan Swami, presently working as assistant professor at the Muddenahalli campus of the VTU, which is the Center for Postgraduate Studies under VTU Act. I was his guide along with Dr. G.S. Venkatesh. Dr. Narayan Swami completed his PhD under my guidance, with the Dr. G.S. Venkatesh acting as a co-guide. Dr. G.S. Venkatesh, professor working in the department, Muddenahalli, Chikkaballapur. G. Narayan Swami and Venkatesh are my colleagues. I was the research supervisor to Dr. Venkatesh was the co-supervisor. On 3rd February 26, my lord, the alleged incident, here it starts. I received a WhatsApp communication on my mobile phone from G. Narayan Swami, along with the shared location, He telephoned me and requested that I come to the said location, stating that he intended to discuss something confidential. When I inquired about the matter, he stated, "Sir, please come, sir, to the location and I'll discuss it at the venue." As I was busy on so and so, it was difficult for me to go. I informed the same to my former student. Through WhatsApp, I also informed him that I was busy and that it was not possible to meet him, and that I would inform him about the timing of any future meeting once it was convenient to me. On 3/2/26, 11/26, I received another WhatsApp message from Narayan Swami asking me not to pick up calls from him. Narayan Swami ಕಳಿಸೋದು, ನಾನೇನಾ ಫೋನ್ ಮಾಡಿದ್ರೆ ರಿಸೀವ್ ಮಾಡಬೇಡಿ. I replied, okay, fine. Around 1:50 p.m. I received another message from him stating, please pick the call. As I was engaged, I could neither pick the call nor respond to said message. I thereafter received a WhatsApp call at 2:32 p.m. followed by 5 more calls at so and so. At so and so, I received a voice message stating that Narayan Swami was waiting near my house. This student came to my house. I received another message at 4:45. By that time, I had reached home. Dr. Narayan Swami informed me that he wanted to discuss some serious issues and requested me to accompany him towards Banashankari. I asked me to board his car. In the car, there was another professor, namely Venkatesh, who was the co-supervisor. I orally informed that Vice Chancellor I was orally informed.
ಈಗ ಇದೆಲ್ಲ ಹೇಳ್ತಿರೋದು ನೀವು ಸೋಂದಿ ಸರ್ ನಿಮ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಬಗ್ಗೆ ಹೇಳಿದ್ರಿ.
ಹೌದು.
ಯಾಕೆ ಹೇಳಿದ್ರಿ ಸರ್ ನೀವು?
ಅದಾದ್ಮೇಲೆ ನನ್ನನ್ನು ಕರ್ಕೊಂಡು ಹೋಗಿ ಟೀ ಶಾಪ್ ಅಲ್ಲಿ ನನ್ನನ್ನು ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಕಾರಲ್ಲಿ ಹಾಕಿ ಅವನ ಮನೆ.
ಯಾವ ಟೀ ಶಾಪ್ ಅಲ್ಲಿ?
ಅಲ್ಲಿ ಬಸವನಗುಡಿ. ಐ ಆಮ್ ನಾಟ್,
ಹೆಸರೇನಿಲ್ಲ,
ನನಗೆ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. Because it was evening, my lord, I did not bother. Then, my lord, they take me to
evening ಅಲ್ಲಿ ಟೀ ಶಾಪ್ ಬಗ್ಗೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ. My friend is reading an affidavit.
B report ಅವರು ಹಾಕಿಸಿದ್ರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. I did not receive any notice till today. They are very powerful. They can get the charge sheet issued and do several things. And I have also lodged the very same complaint, my lord, for taking me and doing all this nonsense. ಇದರಲ್ಲಿ ಈಗ ನಾನು ಹೇಳಿರೋದು.
ಟೀ ಶಾಪ್ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದು.
ಟೀ ಶಾಪಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅವನ ಮನೆಯಲ್ಲಿ ಹಾಕಿ ನನಗೆ ಪ್ರೆಷರ್ ಹಾಕಿದ್ದೇನೆ. ಐ ಹ್ಯಾಡ್ ಟು ರನ್ ಅವೇ ಫ್ರಮ್ ದೇರ್.
ಕಿಡ್ನಾಪಿಂಗ್ ಹಾಕಿದ್ದೀರಾ?
ವರ್ಚುವಲಿ ಕಿಡ್ನಾಪ್.
ಭರ್ಜರಿ ಕಿಡ್ನಾಪ್.
ವರ್ಚುವಲಿ ಕಿಡ್ನಾಪ್ ಅಂದ್ರೆ
ಕಿಡ್ನಾಪ್.
ಇದ್ರ ಮೇಲೆ ನಾನು ಇದು ಹಾಕಿದ್ದೇನೆ. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳುವುದಕ್ಕೆ ನನಗೆ ಇವತ್ತಿನವರೆಗೆ ನೋಟಿಸ್ ಇಲ್ಲ. ಹೌ ಮೈ ಲರ್ನ್ ಫ್ರೆಂಡ್ ಈಸ್ ಏಬಲ್ ಟು ಗೆಟ್ ದಟ್ ಇನ್ಫಾರ್ಮೇಶನ್, ಐ ಡು ನಾಟ್ ನೋ. As on today, there is no B report filed or accepted by the court. My lord, be that as it may, my lord, that is not the subject matter of this petition.
ಅದೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇಷ್ಟೊತ್ತು ಯಾಕಿದೆಲ್ಲ ಅಂತ. That is not the subject matter of the petition.
ಸ್ವಾಮಿ,
ಇದಕ್ಕೋ ವಾರಂಟು, ಇದಕ್ಕೆಲ್ಲ ವಾರಂಟೇ ಇರಲಿಲ್ಲ ಹೇಳಕ್ಕೆ.
ಸ್ವಾಮಿ, as a conclusion, my lord, how degeneration has taken place ಅಂತ ಹೇಳೋದಕ್ಕೆ
about,
my lord, your lordship knows Mr. N.B. Bhatt, my lord, who was representing the universities, advocate N.B. Bhatt. ತಾವು ಅಪೋಸ್ ಮಾಡಿರಬಹುದು. He was representing Gulbarga, Karnataka, Bangalore universities. My lord, during his first my lord tenure as an IPS officer, he was posted to Dharwad.
ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ?
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು. My lord, the Karnataka University Vice Chancellor those days, Professor Pavate, appears to have addressed a letter to the then Chief Minister S. Nijalingappa seeking an appointment. When the letter reached, instead of giving him an appointment, Nijalingappa was knocking at the doors of Professor Pavate. That was his stature, my lord, as the Vice Chancellor of Karnataka University. ಇನ್ನೊಂದು ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಸಬ್ಮಿಷನ್. Before reorganization of the state, my lord, Dr. Lakshman Swami Mudaliar was the Vice Chancellor of Madras University. Education, ಒಂದೇ ಸೆಂಟೆನ್ಸ್.
Times have changed.
A letter was addressed by an educational entrepreneur seeking permission to start private medical colleges. One line reply by Dr. Lakshman Swami Mudaliar: this university will not allow you to trade in education. That was the reply, my lord, of earlier to 1956. And my lord, now today we have come to this level. It is, my lord, we want our universities in the line of Ivy League, Harvard and Oxford, etc.
ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ ಸರ್?
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು.
We'll close this.
That's all, my lord.
इसी के साथ
I am grateful to your lordship, my lord, for
इसी के साथ आज का समाचार समाप्त हुआ.
Grateful, dear lordship.
my lord. There is another writ petition which your lordship may hear it separately.
Ah,
That
ಇನ್ನೊಂದು-
is nothing to do
ಇನ್ನೊಂದು
with this
ಉಂಟಾ?
vice chancellor appointment ಅಲ್ಲ ಅದು.
ಹಾ.
ಅದನ್ನು
ಅದು-
ಸಪರೇಟ್ ಆಗಿ ಹಿಯರ್ ಮಾಡಿ ಸ್ವಾಮಿ.
ಯಾವುದು ಕೇಸ್ ಒಯ್ಯೋದ?
ಅದು ಕೇಸ್ ಒಯ್ಯೋದು.
ಅದು ಇದು ಸಂಬಂಧ ಉಂಟಾ?
ಅದರಲ್ಲಿ R4 ಅಲ್ಲಿಯೂ ಇಲ್ಲಿ ಒಬ್ಬನೇ. ಅಲ್ಲಿಯ ಕರ್ಮಕಾಂಡ there is a refusal, my lord, under section 17A.
ಅದು ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಆ ಕಾಂಡ ಆಮೇಲೆ ನೋಡೋಣ.
that your lordship may delete from.
Anyway, it's by special order. I can't do anything.
ಅಲ್ಲ
It has to be done by the chief justice. ಇದನ್ನ ಈಗ ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ because I have heard all of you. ಅದನ್ನ ಇನ್ನೊಂದು ದಿನ ಕೇಳುವ.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. Any day convenient to your lordship, my lord.
Only two submissions I want to make, because one judgment I cited, that is of Premachandran Kilo. Certain paragraphs he referred and said that he could not have received report from the government and then from the representation from this one. What is the facts therein, my lords? The governor did not apply his mind at all. He surrendered his discretion to government.
That is what is at page para 81, 84, 85, 86.
Yes, that not
84, 85, 86 is the finding on
section 80, 81,
Para
83.
Para 80.
Paras.
Yes.
Paras 80, 81. There he said he was noose-led by the government. There is no such pleading in the present writ petition. Second one, taking assistance of somebody is some expert body is different. For example, initial appointment also. Chancellor depends on the recommendations made by the search committee. That doesn't amount to surrendering the discretion. Then another thing, only one paragraph in Srinivas Reddy, para 70, it is said, there is some, if there be any doubt, it has to be resolved in favor of holding the appointment, upholding the appointment. That is the only thing. And he has this for him to produce matter is very any.
ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಸಾರಿ ಮೈ ಲಾರ್ಡ್ ಫಾರ್.
You want some more water?
ಕಾಲ ಸ್ವಾಮಿ, 5 ಕಾಲರವರೆಗೆ ತಮ್ಮನ್ನು ಕೂತ್ಕೊಳಿಸಿದ್ದೀವಿ.
ಅದು ನಮ್ದು ಡೈಲಿ ಡೋಸ್. Yes.
Grateful, dear lordship.
ನೀವು 7 ಗಂಟೆಗೆ ಬಂದ್ರು ಹಿಂಗೆ ಕೂತಿರ್ತೀವಿ.
Grateful to your lordship's energy and stamina, my lord.
Lord, sir, mark the relevant portion of the.
ಅಭಿಷೇಕ್, ಅದು ಯಾವ್ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಒಂದು ಕಂಪೈಲ್ ಮಾಡಿ ಒಂದು ಡೇಟ್ಸ್ ಹಾಕಿ, ಪ್ಲೀಸ್ ಗಿವ್ ಇಟ್ ವಾಟ್ ಎವರ್ ಸೀನಿಯರ್ ಎಸ್ ಸೆಟ್. ಅಂಡ್ ಶ್ರೀಕಾಂತ್ ಸರ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ದಾರೆ, ಸರ್ ಮಾಡಿರ್ತಾರೆ, ಅದನ್ನ ಕೊಡಿ ಕರೆಕ್ಟ್ ಆಗಿ ಅಷ್ಟೇ.
We'll file a short note also.
Yes sir, you should. And by tomorrow,
please.
No time. By tomorrow, yes.
Senior note.
Your lordship wants me to file date.
Please do sir. ಅಯ್ಯೋ ನಿಮ್ಗೆ ಹೇಳಲೇಬೇಕು, ಬಟ್ ನಾಳೆ ಒಳಗೆ, ನಾಳೆ ಒಳಗೆ ಕೊಟ್ರೆ ಎಸ್ ಸರ್.
For the UGC matters. UGC ಅಲ್ಲಿ
ನೀವು ಇದ್ದೀರಾ?
ಅಲ್ಲ, ನಮ್ದ್ರಲ್ಲಿ ಅಷ್ಟೇ. My submission is only 2 ನಿಮಿಷ ಸ್ವಾಮಿ ಇದ್ರಷ್ಟೇ.
ಹೇಳಿ ಸರ್.
ಏನಂದ್ರೆ the UGC rules and regulations are regulate under section 2F. This is applicable to the BTU units.
ಅಷ್ಟೇ.
Applicable. It's applicable to.
ಭಯ ಎಲ್ಲಿ ನಾನು
ಇಲ್ಲ. It's applicable to the BTU. The regulations which the petitioner read are applicable to the BTU. The BTU is a university under section 2F matters. Those are applicable.
Yes, the D-Link, the connected matter, heard ಎಲ್ಲ senior council ಯಾರಿದೆ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ರಿಸರ್ವ್ಡ್ ಅಪಿಯರೆನ್ಸ್ ಎಲ್ಲ ಯಾರ್ಯಾರು ಎಲ್ಲ ವಕಾಲತ್ ಯಾರು, ಆಮೇಲೆ ಚೇಂಬರ್ಗೆ ಬರ್ತಾರೆ, ನಂದಿಲ್ಲ ಅಂತ.
Number 111.
111 gone.
This may have it on Tuesday, my lord. I'll file a rejoinder to that.
ಯಾವ್ದದು?
The SIT matter, my lord, where the CBI has filed a closure report.
Wait. ಅಲ್ಲ ಕರಿತೀನಿ. Please. Not who is getting up? I'm not getting up.
Your lordship record submitted it.
ಯಾವ್ದ್ರಲ್ಲಿ ಮೇಡಮ್?
Previous matter.
The record submitted, yes. Record submitted, recorded.
I don't know.
ನೆಕ್ಸ್ಟ್ ನಿಮ್ದಿದೆಯಾ ಸರ್?
ಅಲ್ಲ ಇಲ್ಲ, ಇವತ್ತಿತ್ತು ಫಿಕ್ಸ್ ಆಗಿತ್ತು, ಬಟ್ ಎಲ್ಲಿ
ಬಂದಿಲ್ವಾ? ಬಂದಿಲ್ವಾ?
98
ರೀಚ್ ಆಗುತ್ತೆ.
ಸರಿ.
ಇಲ್ಲ, ಯು ನೀಡ್ ನಾಟ್ ವೇಟ್ಸ್, ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ಅವಾಗ.
ಎನಿ ಟೈಮ್
Because Rejant, I'll finish the list and then leave.
No, I don't mind waiting.
First, there are two things. One, the settlement ಇದೆ, ಒಂದು 230 mode matters ಇದೆ. ಆದ ತಕ್ಷಣ I will take. It may take ಆಮೇಲೆ ಒಂದು ಒಂದೊಂದು ಇಡಿ ಮ್ಯಾಟರ್ ಇದೆ. ಆಮೇಲೆ ತುಂಬಾ ಇದೆ ಸರ್. We'll see. Yes.
Any time which is convenient to the court.
If I don't take it by 5:45, you can leave.
Huh?
But, the respondent has sent one email saying he wants to do a hunger strike in the institute on 27th.
Hunger strike? ಯಾರು ನೀವಾ? 98. ಯಾಕೆ ಹಂಗರ್ ಸ್ಟ್ರೈಕ್ ಹೋಗ್ಬೇಕಾ? ಹಂಗರ್ ಸ್ಟ್ರೈಕಾ?
ಇಲ್ಲ.
He has sent an email seeking permission to go on hunger
Hoax.
strike. But, that's
Not send any mail.
Hoax.
But he sent a letter to the institute as well as Milord to the police.
Why sir? ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಇರ್ಬೇಕಾದ್ರೆ ನೀವೇನ್ ಇದೆಲ್ಲ ಮಾಡೋದು?
I not at all sent any message, my lord.
Email
ಕೇಳಿ.
Email ಬಂದಿದೆ.
ಅದು ಕೇಳ್ಕೊಳ್ಳಿ, ತಗೊಂತೀನಿ ಆಮೇಲೆ.
Whom it is?
Ask Kasif. That's what
I'll give him the
ಅವ್ರಿಗೆ
email
ಕೊಡಿ,
copy.
ಅವ್ರಿಗೆ ತೋರಿಸಿ. I'll take it sir, little in a while. 5:45. ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದ್ ದಿನ. Yes. ಈಗ second matter, list on special ordering for the hearing 20 September 10th September 10th 11th Friday. Yes, 11th.
Serial number 93.
No out of turn, wait. One if I take, then I'll go by the order. Is now call of the 230 mood matters. Settlement ತಗೊಂತೀನಿ, ಇದಾದ ತಕ್ಷಣ ತಗೊಂತೀನಿ. ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ಹೇಳಿ.
498 matter was reported to settlement matters. Parties also have come. ಇದು ರೋಸ್ಟರ್ ಇದು ಮುಂದೆ ಹಾಕಲಿ.
ರೋಸ್ಟರ್
ಕೃಷ್ಣ ಕುಮಾರ್ ಸರ್
ಸೆಟಲ್ಮೆಂಟ್ ಯಾರು ಬೇಕಾ? ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಾ? ನೀವೇ ಅವರೇ ಕೇಳ್ತಾ ಇದ್ದಾರಾ? ಸೆಟಲ್ಮೆಂಟ್ ಯಾರು ಬೇಕಾದ್ರೆ ಮಾಡಿ ಕರ್ಸ್ತಾರೆ. ಯಾರು ಅದೆಲ್ಲ ಮಾಡ್ತೀರಾ? ಸೆಟಲ್ಮೆಂಟ್ ತಾನೆ? ಹಾ ಕಳ್ಸಿ. ಇಟ್ ವಿಲ್ ಕಮ್ ಡೋಂಟ್ ವರಿ.
ಇವತ್ತು ಟುಡೇ only.
Yes.
mood matters. Fresh matters, Seal number 1, Shri R.K. Mahadeva.
Appear for petitioner matters.
ಮೈಸೂರಿಗೆ ಹೋಗ್ಬೇಕಾ ವಾಪಸ್ಸು? ಇಲ್ವಾ?
ಆಮೇಲೆ ಮುಗಿಸ್ಕೊಂಡು
ಹೋಗ್ತೀರಾ? ಸರಿ ಆಯ್ತು.
ಡೇಟ್ ಆಫ್ ಇನ್ಸಿಡೆಂಟ್ ಇಸ್
ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಕೊಡದೆ ಹೋದ್ರೆ ಹೋಗ್ತೀರಲ್ಲ?
31(3) delay in lodging the complaint.
64(2)M sir.
ಅಲ್ಲ
ರೇಪ್
ಆಗ್ಲೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲ ಹನಿ ಟ್ರಾಪ್ ಮಾಡಿರೋದು ಇದು.
ಹನಿ ಟ್ರಾಪ್?
Yes my lordship, 62 years old age is incapable person.
Petitioner ಏನು?
62 years old age person.
62-year-old?
Petitioner 62 years.
ಅವರು 45.
19 years,
18 years old, your lordship. The girl is 18 years old.
18 years?
7.5 years. Absolutely the honey trap.
ಮೈಕ್ ಹತ್ರ ಬನ್ನಿ ಸರ್, ಕೇಳಿಸಲ್ಲ.
Absolutely the money trap, grabbing the money from the petitioner and
money trap
honey trap.
ಮತ್ತೆ ಮನಿ ಅಂತ ಇದ್ದೀರಾ?
Sorry, honey trap. Delay in lodging the complaint 1 month. Date of incident is 31/3/26 and lodging the complaint 6/5/26. And brief and also recorded the statement and also investigation is
ಸರ್ she is 17 years and 6 months.
17.5 years.
ಹೋಗ್ಸೋ ಹಾಕಿಲ್ವಾ?
ಹಾಕಿದ್ದಾರೆ.
ಯಾವ ಧೈರ್ಯದ ಮೇಲೆ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದಾರೆ? ಅದು 230 ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ಡೇಟಾ ಇದು 22nd ಚಾರ್ಜ್ ಇಯರ್ ಬಿಫೋರ್ ಚಾರ್ಜಸ್.
ಕರೆಕ್ಟ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ ಈಗಲೇ.
ಇಲ್ಲ, ಅಬ್ಸಲ್ಯೂಟ್ಲಿ
ಹಿಯರಿಂಗ್ ಬೇಕಾಗಿಲ್ಲ.
ನೋ ಮೆರಿಟ್ಸ್.
ವಾಟ್ ಸರ್? You are 62 years and the girl is 17 years and 6 months. Allegation is of raped her.
Not a rape.
Not a rape. In honey trap. Honey trap of a 17-year-old 6-month girl.
Another girl.
And you are 62 years.
Yes, my lordship.
What do you do, sir? Age is just a number ತರ ಆಡ್ತಾ ಇದೀರಾ ನೀವು.
60 old age not capable person.
Old age not capable. Yes, sir.
Yes, my lordship is.
Page 27, 164 statement.
64. Page number 25. Statement.
ಪುನಃ ರೂಮಿಗೆ ಚಿಲ್ಕ ನನ್ನ ಎಲ್ಲ ಮುಟ್ಟು. ಈಗ ಏನ್ ಮಾಡೋಣ? ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀವಿ. ಯು ವೇಸ್ಟೆಡ್ ಒನ್ 2:30 PM ಪೆಟಿಷನ್.
ಇಲ್ಲ
ಇಫ್ ಯು ಇದೇನಾದ್ರು ಓದ್ಬಿಟ್ರೆ ಯಾರಾದ್ರೂ, ಇಟ್ ಈಸ್ ಸೋ ಹೊರೆಂಡಸ್.
after lapse of
What do you mean?
What after lapse of 1 month?
What lapse of 1 month? Oh, you see this? What lapse of 1 month? Even if it is lapse of 1 year, I will entertain this.
Yes, my lord.
What is all this? Incapable ante. ಸುಮ್ನೆ ನರೇಟ್ ಮಾಡ್ತಾರೆ ಯಾರಾದ್ರೂ ಹಿಂಗೆ? You have not left the lady in the burqa also. What are you?
Statement before the court.
What statement? Honey trap ante idu. ಸುಮ್ನೆ ಹೇಳೋದೇನು?
ಇಲ್ಲ correct is my lordship.
What honey trap? Yes sir. ಎಷ್ಟು ಒಂದು 25,000 50,000 ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀನಿ ಈಗ, for having wasted the time moving at 2:30. How are you so overconfident that I will entertain this petition?
Yes, my lordship, agree.
ಏನು?
Absolutely no merit.
What absolutely no material, sir?
Except the statement.
This statement saku to pin you down completely. You have followed her everywhere into the bathroom. He is a child, sir.
Yes, I am agree, my lordship.
ಮತ್ತೆ 62 ವರ್ಷ ನಿಮ್ಗೆ, 17 ವರ್ಷ.
I appear for the petitioner in this matter, Your Lordships. It's a 138 matter in which the complainant has filed the case when the account has been blocked, Your Lordships. It is covered by Your Lordship's judgment.
ಆಯ್ತು, ಈಗ ಅನ್ಬ್ಲಾಕ್ ಸರ್, KPID ಚಿಟ್ ಫಂಡ್ ಎಲ್ಲ
ಅಲ್ಲ,
ಇದೆ
ಅದು
sir.
ಇದು ಏನಂದ್ರೆ they have removed it, Your Lordships.
ಏನ್ ರಿಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಸರ್?
ಇದು ಏನಂದ್ರೆ show Your Lordships the order sheet.
What?
ಇದು ಏನಂದ್ರೆ that is another crime in which I was, what do you say, implicated, and then that was being dropped. That was being dropped and I've
Yes,
also furnished the order sheet, Your Lordships.
State is not a party. ಯಾರು
state is-
ಡಿಫ್ರೀಸ್ ಮಾಡ್ತಾರೆ ನೀವು?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು 138 proceedings ಸ್ವಾಮಿ, ಇದು 138 proceedings. ಹೌದು. I've been, what do you say, arraigned as accused in another crime in which my account has been blocked.
Account is blocked not because of 138.
ಅಲ್ಲ
Account is blocked because of a crime registered by this, which is now investigated by the state.
Yes, Your Lordship.
ಮತ್ತೆ
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು that is other proceedings. This is, I am asking stay of the proceedings in 138 matter, Your Lordship. It is a 138 matter.
ಅಕೌಂಟ್ ಬ್ಲಾಕ್ ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ, I was in jail. I was in
2125.
ಹೌದು,
Situation
ಹೌದು.
covered under
ಹೌದು,
2125.
ಹೌದು.
ಅದೇ ಹೇಳ್ಬಿಡಿ.
ಹೌದು.
Emergent notice to the respondent, there shall be an interim order of stay of further proceedings where the petitioner, since the endorsement of the bank on the check presented is the account is blocked due to the account getting frozen and the issue standing completely answered by RBI circular number 2125. Situation number 2125. Yes. Last.
Number 3, P. Praveen.
Please sign this matter, my lord. At the forgery and impersonation, my lord. In fact, I am the purchaser. My vendor and the complaint, they have a litigation. Now they have filed it, and in fact, I have cancelled the sale deed also. The day I have moved for cancellation of the sale deed and paid the amount, that day they have gone and registered the FIR. However, I have cancelled the sale deed itself.
ಇದು ಅದರದೇನಲ್ಲ. Just check. Impersonation ಇದೆ. But these are bona fide purchasers, anta what Praveen Gowda
And
says.
I have also cancelled the sale deed immediately after coming to know the legal
The
issues.
learned HCGP is directed to accept notice for the respondent. The learned SPP to go through the papers and make his submissions as impersonation is the offense alleged against, not against these petitioners, but against the accused number one. The accused number one and the complainant do have a squabble with regard to the property. The petitioners being bona fide purchaser, I deem it appropriate to protect them till the next date of
I have
hearing.
also filed a complaint as filed a
One
suit before.
Protect to the next date of hearing. 25th fresh matters, no coercive steps will be taken against these petitioners till the next date of hearing.
Great.
Number 4, Lalit Kumar.
Lord, KOPD Act, my lord.
Madam.
You're Ravi Kumar.
Lalit Kumar, sir.
What was called?
Lalit Kumar. It's fine.
I believe it's Lalit Kumar's matter. I heard it as.
पहले आप
Mine is Ravi Kumar's matter.
ಹಂಗೆ ಸರಿ ಆಯ್ತು. ನೀವು ಪಹಲೆ ಬಂದು ನಾನು ಎದ್ದೋಗ್ಬಿಡ್ತೀನಿ.
ಇಲ್ಲ ಬೇಡ ನಾನು ಹಿಂದೆ ಹೋಗ್ತೇನೆ.
ಆಯ್ತು, ಎಸ್.
My lord, KOPD Act, my lord. Section 3, KOPD, Karnataka Open Place Disfigurement Act.
ಕೊಡಿ ಕವರ್ಡ್
Coordinate bench judgment ಇದೆ madam.
ಕೊಡಿ ಸರ್.
Without the permission of the BBMP, they have.
There it was not required, I guess. Coordinate bench ಇದೆ, even I have written. Yes. State ಆ cost ಆ?
Pass ಆದ್ರೆ
Pass ಆದ್ರೆ ಒಳ್ಳೇದು.
it will save the
Pass,
court's time.
yes.
Grateful.
Dispose, same order.
Grateful.
Number 5, please be ready.
Okay, for the petitioner, my lord, the offences are 292, 504 and 509, my lord. The petitioner is accused number 1. The allegation against the petitioner is this, my lord, that he has uploaded a video of one sitting MLA, my lord, Ramnagar MLA, and one the complainant.
When?
24, my lord.
2024.
Please, my lord. However, my lord, now there's no recovery. There's from the petitioner, from the present petitioner, my lord. Accused number 2 and 3, they've at least recovered phones, etc. Charge
From
sheet is now
them.
filed. Please, my lord. Apart from stating that there is a Facebook link that is uploaded on his profile, no material is also shown
No,
to
the phones
establish.
of A2 and A3 are,
Yes.
A2 and A3 are involved in that?
2 and 3, my lord, yes.
No.
The
Petitioner
statements
is
are-
accused number 1 or 2 and 3?
1. Now, my lord, this video that they're talking about was already viral. If your lordships will see, my lord, page 36. 58 other people have also uploaded the same video.
Not only you,
No,
allegedly you.
my contention is that this is not even me. As on today also, my lord, if a Facebook search were to be made in the name of the present petitioner, there are about 200 accounts at least. No material is shown as to how.
One
this is a-
HCGP to emergent notice in the meantime.
Grateful.
Yes, next.
Bill number 6,
Praveen.
Praveen Kumar.
The offense is punishable under section 85 and 74 and 115, Lordship.
74 ಯಾಕೆ?
Lordship, they're making the allegation is this, Lordship, I pulled her hair, Lordship, but.
Hair?
Yes, Lordship.
Mic ತಗೊಳ್ಳಿ sir. Pull the mic first. ಹೇಳಿ ಈಗ.
Petition number 1 and 2 is pull the hair of the respond number 2, Lordship, but Lordship there is a case and counter case, Lordship, and respond number 2 pick the quarrel, Lordship, and respondent and others broke my leg, Lordship.
Broke your leg?
Yes, Lordship.
Husband's leg?
Yes.
Where is it, sir?
Yes, Lordship, please come to the.
ಇದು husband page 170.
158, Lordship. Husband's complaint, Lordship.
Complaint ಅಲ್ಲ, photo at 170.
Yes, Lordship. Husband's photo, Lordship.
Wife has brought you to this state, is it?
Yes, Lordship.
Yes, Deepthi madam. ಒಳ್ಳೇದಾಯ್ತು ಅಂತ ಇದೆ. ಹಸ್ಬೆಂಡ್ ಏನದು?
Yes, Lordship.
Where is the wound certificate?
Lordship, it start from ink page number 170.
Don't start, sir. Where it is ಹೇಳಿ ಸಾಕು.
Yeah, 171, Lordship.
ಅಷ್ಟು ಹೇಳಿ. I
took
start
an
ಅಂದ್ರೆ
treatment
ಆಮೇಲೆ
at Medistar hospital, Lordship.
ಯಾವುದು?
Medistar.
ಆಯ್ತು. ಹೇಳಿ.
I took a treatment over there, Lordship, and thereafter, and given a statement before the respondent police, Lordship, and based on that, the police was registered a case against the respondent number 2, Lordship. Thereafter, they filed a counter complaint against me, Lordship.
Yes. One HCGP, 7 ಜನ ಇದ್ದೀರಾ accused?
And they are implicated all my relatives, Lordship.
Very good. ಇನ್ಯಾರು ಇದ್ದಾರಾ?
No, Lordship.
One HCGP to emergent notice in the meantime. Next.
Grateful, Lordship.
Yes.
Number 7.
Essential Commodities Act.
Please, my lord.
Urgency
this, my lord. They register a case stating that the shortage.
ಲಾರಿ ಎಲ್ಲ ನಿಂತೋಗ್ಬಿಟ್ಟಿದೆ.
ನಿಂತ್ಬಿಟ್ರು ಎಲ್ಲ. Now they cancel.
ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ರು
It
ಅವರೆಲ್ಲ.
appears your lordship
ಅವ್ರು
said
ಮೆಮೋ
that
ಮಾಡ್ಬೇಕಾದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
without notice how can they cancel? They did it. my
ಅದು
lord.
ಹೇಳಾಗಿದೆ.
ಅದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಬಿಟ್ಟರು. And
ಕಾಂಟ್ರಾಕ್ಟ್ ಎಲ್ಲ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತಲ್ಲ.
ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
ಅದೇ ಬೆಳಗ್ಗೆ
And my
ಹೇಳಿದ್ರು.
lord, and inquiry is now conducted. They say our load is already there. It's unloaded. They did not enter in the data.
ಸ್ಟೇ ಕೊಡ್ಬೇಕು
Please, my lord.
ಅಂತ ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ ಅವರು. Heard the learned senior counsel on HCGP to emergent notice in the meantime. Yes. All consequences of the grant of this interim order shall flow in favor of the petitioner, which would be subject to the result of the petition.
Grateful.
ಎಲ್ಲ ಲಾರಿ ವಾಪಸ್ ಬರುತ್ತೆ ಬಿಡಿ. ಮತ್ತೆ ಅದೇ ರೈಸ್ ತಗೊಂಡೋದ್ರೆ ಸೀಸ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ. ಹ್ಯಾಂಡ್ ನಾಳೆ ಮೇಡಮ್ ಇಷ್ಟೊತ್ತಲ್ಲಿ ಯಾವ ಹ್ಯಾಂಡ್ ಅಲ್ಲಿ ನಾಳೆ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
Please. We are grateful.
Number 8. Permanent.
ನೀವು ಬೆಳಗ್ಗೆನೆ ಹೇಳ್ದೇನೆ ಕೊಡಲ್ಲ ಅಂತ.
306 is the offense.
ಅದಕ್ಕೆ.
My lord, 108. My lord, what happened is, my lord, earlier also the deceased has attempted for suicide.
ಅದಕ್ಕೆ.
My lord, then what happened is, my lord, she has taken money and gold from the petitioners herein, and my lord, she did not return the money and the gold.
Who is she?
My lord, she is deceased now.
ಅಯ್ಯೋ ಗೊತ್ತು ಸರ್, ರಿಲೇಷನ್ ಅಲ್ಲಿ ಯಾರು ಹೇಳಿ ಸರ್?
Not related, my lord.
ಮತ್ತೆ?
She is, my lord,
She is deceased.
into
She is deceased.
some investment, and my lord, there, my lord, the accused number 3 cheated her, probably, my lord. That is the reason. We lodged a complaint 1 month back against her, my lord, and there was a recovery done at the instance of the petitioner's complaint. And my lord, pursuant to that, after lapse of 1 month, my lord, she committed suicide.
Get the records.
I will, please.
And let there not be any coercive steps.
Your lordship, it was on 4th, the FIR was registered.
4th August.
Yes, your lord.
Lord, but
ಬೇಲ್ ತಗೊಳ್ಳಿ.
Lord, only thing is, my lord, we have already, my lord, registered FIR against her. There was a recovery also.
So what?
Earlier she attempted. My lord, if a weak-minded person commits suicide, my lord,
How do you know she is weak minded?
she has already attempted suicide according to their own complaint. Kindly come to, my lord, page 24.
ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂಸ್ ಕಾಟ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ, continuous ಅಲ್ಲ, ಎಲ್ಲರಿಗೂ cheat ಮಾಡಿದ್ದಾರೆ, not the petitioner alone. He has, my lord,
Death note is
taken
also
money from so many
mentioned.
people.
ಡೆತ್ ನೋಟ್ ಇದೆಯಾ ಅವ್ರ
I
ಹೆಸರು?
will.
ಅಲ್ಲ, ಡೆತ್ ನೋಟ್ ಇಲ್ಲ, ವಾಯ್ಸ್ ವಾಟ್ಸ್ಆಪ್ ವಾಯ್ಸ್ ಮೆಸೇಜ್ ಇದೆ ಅಂತ
ಎಲ್ಲ
ಹೇಳ್ತಾರೆ.
ಒಂದೇ ಈಗ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಎವ್ರಿಥಿಂಗ್.
That's true, my lord, but the conduct and also, my lord, the person how we are placed, my lord,
And
ಗೆಟ್ ದ
yes,
ರೆಕಾರ್ಡ್ಸ್
yes, please.
ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
that there
ಮೇಡಮ್
not
ಬೈ
be-
ದೆನ್ ತಗೊಂಬನ್ನಿ.
that there not
ನೋ
be
ನೋ
any-
ನೋ.
Lord,
ನೀವು ಯು ಹ್ಯಾವ್ ಕಂಟಿನ್ಯೂಸ್ಲಿ ಟಾರ್ಚರ್ಡ್ ಹರ್.
no, my lord, that is not so. We lodged complaint. We
ಅರೆ ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್ ಮಾಡ್ಬಿಟ್ಟು ಆಯ್ತಲ್ಲ. ಎಸ್
ನಮ್ಮ ದುಡ್ಡು ತಗೊಂಡು ನಮ್ಗೆ ಚೀಟ್ ಮಾಡಿದ್ದವರು.
4th August ರಿಜಿಸ್ಟರ್ ಆಗಿರೋ ಕ್ರೈಮ್.
But my lord, my kindly see the situation where I am placed, my lord.
ವೇರ್ ಯು ಆರ್ ನಾಟ್ ಪ್ಲೇಸ್ಡ್ ಎನಿವೇರ್. ಬೇಲ್ ತಗೊಳ್ಳಿ.
I have, my lord, already filed complaint. There is an investigation going on. They have seized the gold and the ornaments, my lord.
ಲೆಟ್ ಮಿ ಸಿ ದಿ ಪೇಪರ್ಸ್ ಆಫ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
Some protection maybe.
ಅದೇ ಲೆಟ್ ಮಿ ಸಿ ದಿ ಪೇಪರ್ಸ್ ಆಫ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಎಸ್ ದೀಪ್ತಿ ಮೇಡಮ್ ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ, we'll get it.
ಎಲ್ಲ
your
ಮಂಡೇ
lordship,
ತರ್ಸಿ.
please.
Since, my lord, the petitioner is a lady, my lord. Some
ಯಾರು
protection.
ಅರೆಸ್ಟ್ ಮಾಡಲ್ಲ ಬಿಡಿ.
ಮಾಡ್ತಾರೆ. That is the reason why, my lord, we are before this court, my lord. and
ಬೇಲ್
end up this-
ಬೇಲ್ ಹಾಕ್ತೀರಾ? ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ ಬೇಲ್ ಕೋರ್ಟ್ ಟು ಕನ್ಸಿಡರ್ ಇಮಿಡಿಯೇಟ್.
that will
ಸರ್
again-
108 ಕೇಸಸ್ ಅಲ್ಲಿ ನಾವು ಎಂಟರ್ಟೈನ್ ಮಾಡಲ್ಲ. ಇಫ್ ಇಟ್ ಇಸ್ 1 week 10 days, ಐ ನೀಡ್ ಟು ಸಿ ದ ಪೇಪರ್ಸ್ ಆಫ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಯು ಶುಡ್ have sought bail by now. Yes, list on 24th will grant after looking into the papers.
Lordship may kindly have it day after tomorrow.
Day after tomorrow paper ತರ್ತೀರಾ?
No,
ಎಲ್ಲಿದು? ಮಂಡೇ. ಏನು ಮಾಡಲ್ಲ ಬಿಡಿ.
ಇಲ್ಲ, there, my lord,
SPP ಅವರು ಇಲ್ಲೇ ಇದ್ದಾರೆ, ಏನು ಮಾಡಲ್ಲ.
some protection will be granted, my lord.
Normally in crime stage, Lord, not entertained.
ಐ ಡೋಂಟ್ ಎಂಟರ್ಟೈನ್ ಅಟ್ ಆಲ್. ಅವರೇ ನೋಡಿದ್ದಾರೆ. ಸ್ವಲ್ಪ ಅಟ್ಲೀಸ್ಟ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ವಲ್ಪ ಆಗಿ ಏನು ಇಲ್ಲ ಅಂತ ಬಂದ್ರೆ ಇವ್ರ
ಏನು ಇಲ್ಲ, complaint, lordship.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ ಸರ್. ಎಸ್ ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Other accused, my lord, they have arrested. That is the reason.
ಓ ನೀವು ಎಸ್ಕೇಪ್ ಆಗಿದ್ದೀರಾ? ಎಲ್ಲಿದ್ದೀರಾ ಈಗ?
Outside.
ಔಟ್ಸೈಡ್.
But it is fact that, my lord, we have lodged a complaint 1
ಅಯ್ಯೋ
month back.
ಮತ್ತೆ 4ನೇ ಸರಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
No, not that, my lord.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಮಂಡೇವರೆಗೆ ಎಲ್ಲಿದ್ದೀರೋ ಅಲ್ಲೇ ಇರಿ. ಡೋಂಟ್ ಕಮ್ ಔಟ್.
Some protection may be there.
Don't come out. Monday will grant you. Yes.
Number 9, Shivanand Reddy, are we?
Please, my lordship. In this case, I'm for the petitioners, my lordship. The Royal Pod police have registered case.
ಏನು?
Royal Pod police have registered.
ರಾಯ್ಪಾಡ.
Royal Pod
ರಾಯಲ್ ಪಾಡ.
police house, please, my lordship.
Eh?
Under section 31 R.
ಕೋಲಾರ.
No, please, my lordship. SC/ST Act, my lordship. There is no-
Atrocities Act.
Atrocities Act, my lordship.
Yes, the one HCGP to emergent notice, there shall be an interim order of stay insofar as Atrocities Act is concerned till the next date of hearing. State ilva. HCGP accepts notice for the respondents. Praveen Godra.
Lords, 304, my lords. Your lordship to page.
304 A, B or bari 304?
4. I'm a landlord. I've let the premises on a rent. A4 in turn sublet to A1. So that is where the blast has happened. A1 and A2 are no more. And charge sheet has been filed against A1 and A2.
ನೀವು A3 ನಾ?
I'm A3.
ನಿಮ್ಮೇಲ್ ಮಾಡಿಲ್ವಾ?
ಸಂಬಂಧ ಇಲ್ಲ. I'm a owner of this particular site.
Let
The
me
shed
see.
which has been.
Yes, Leonard, HCGP is directed to accept notice, secure instructions and make submissions. Monday, fresh matters. Charge sheet ಆಗಿದೆಯಲ್ಲ ಹೆಂಗೋ?
ಅದೇನಾಗ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ, bail has been granted. I am from Udupi. ಇಲ್ಲಿ ಶ್ಯೂರಿಟಿ ನನಗೆ ಇಲ್ಲಿ ಯಾವ್ದು ಸಿಗ್ತಾನೂ ಇಲ್ಲ, ಅದೇ ಸಮಸ್ಯೆ ಆಗಿರೋದು.
ಅಯ್ಯೋ UP ಅಲ್ಲಿ ಇರೋರು ಸಿಗುತ್ತೆ, ಉಡುಪಿಲಿ ಇರೋರು ಸಿಗಲ್ವಾ?
ಅದೇ
ಏನ್
ಅಲ್ಲಿ
ಸ್ವಾಮಿ?
ಈಗಿನ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಸ್ವಾಮಿ ಮೊದ್ಲಾಗಿರೋ ಶ್ಯೂರಿಟಿ ಏನೋ ಕೊಡ್ಬೋದಿತ್ತು, ಇವಾಗ ಭಾರಿ ಸಮಸ್ಯೆ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಶ್ಯೂರಿಟಿ ಕೊಡೋದೇ
ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಎಲ್ಲ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ.
ಬೋಗಸ್ ಶ್ಯೂರಿಟಿ ಆಗಲ್ಲ, ಈಗ ನಿಜವಾದ್ದೇ ಕೊಡ್ಬೇಕು, ಅದೇ ಪ್ರಾಬ್ಲಮ್
ಅದೇ
ಆಗಿರೋದು.
ಪ್ರಾಬ್ಲಮ್. That's the reason I moved before this court.
ಏನ್ ತೊಂದ್ರೆ ಆಗ್ತದೆ ಈಗ?
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಈಗ ನಾಳೆ 20th if I don't place the surety, then police will start harassing me. I've already been harassed.
Don't worry, surety they will not insist. We'll list the matter on Monday, Tuesday in the fresh matters list. The state, ಈ bail ಆಚೆ ಇದೀರಾ?
ಆಚೆ ಇದೀನಿ.
The state shall not insist on surety till the next date.
Please.
Number 11, Venkatachalamapati M.
Appearing for the petitioner on this matter.
In terms of the withdraw ಮಾಡ್ತಾ ಇದೀರಾ? Memo for withdrawal ಅಂತಿದೆ? Oh, previous
Withdrawal.
Yes, sir.
The allegations is that, my lord, formation of the layout in government land, my lord. In fact, I would request your lordship to refer the page number 102, my lord.
No, sir.
102, the property stands in the name of my paternal father. I have nowhere related to the alleged sale deed, my lord. Either I'm not the party, I have not received even a single rupee of the sale consideration.
You're not signatory?
No, my lord.
Your accused number?
Accused
A2,
number 2
sir.
and 3, my lord.
ನೀವ್ ಯಾಕೆ, why are you into the picture?
That is a story, my lord. In fact, my lord, I would.
Wait. Learned HCGP is directed to accept notice, go through the papers and make
No, my lord.
submissions.
The
Again,
accused
problem
number 2, who is the petitioner number 1, is the son of accused number 1.
I think petitioner, problem in urgency ಏನು?
Lord, the trial court had issued the summons, my lord.
ಅಷ್ಟೇ
Summons ne
next day
NBW ಅಂತ ಹೇಳಿ Saturday and Sunday they have went.
A2 has received amount, I will.
1 minute, madam. Say, ಅದಕ್ಕೆ check into it. The learned HCGP Deepthi Alva is directed to accept notice, secure instructions and go through the papers and make submissions. 25th fresh matters. The sword of NBW hanging on the head of the petitioner shall remain state till the next date.
No NBW.
ಮತ್ತೆ
Summons
ಹೇಳಿದ್ರು.
ನ NBW ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು.
They don't know the difference between the summons.
NBW ಅಂತ ಯಾರು ಹೇಳಿದ್ರು ಸರ್? No precipitative action shall be taken against the petitioner to the next date.
Yes. Most.
Yes.
Orders number 12,
Charge sheet is filed, my lord, liberty to challenge the charge sheet.
13, Sridhar K.
Liberty may be.
Yes,
Please.
sir.
I paid for the petitioner. This case and the next case. My lord, the complaint is at Annexure A, page number 13. Kindly see, my lord, there was some civil litigation between the parties. The complaint is given after lapse of 49 days on the alleged offense. under POSCO Act, my lord.
Under?
POXO Act. Kindly see the complaint, my lord, given by him.
Allegation is of a 9-year-old girl.
ಹಾ ಕರೆಕ್ಟ್ 49 ಡೇಸ್ ನಂತರ ಕೊಟ್ಟಂತ ಕಂಪ್ಲೇಂಟ್ ಇದು
ಅದು ಗೊತ್ತಿಲ್ಲ.
ಹಾ ಇಲ್ಲ ಅವರೇ ಹೇಳಿದ್ದಾರೆ
ಅಲ್ಲ 49 ಡೇಸ್ ಇರ್ಬೋದು.
ಹಾ
ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
ಮೈಲಾಡ್ ಏನಾಯ್ತು ಅಂದ್ರೆ ನನ್ ಕೌಂಟರ್ ಕಂಪ್ಲೇಂಟ್ ಇದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಯ್ತು.
Anything may be, yes. When it involves a 9-year-old girl, no question of grant of stay at all. The learned HCGP is directed to accept notice for the respondent. Both these matters, for the respondents, list the matter on 27th in the fresh matters list.
15.
HCGP Deepthi Aldwan. Yes, next.
Next matter same.
Next same, 14 same.
15. Anandram.
For the petitioner, the offense under 5052.
5052. Iga.
2023, my lords, April. Cognizance is taken, my lord, without previous sanction under 196(1)(a).
And it should be allowed straight away.
Yes.
ಏನಾಗಿದೆ ಈಗ?
ಈಗ ಇವಾಗ ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಚಾರ್ಜಸ್ ಹಾಕೊಂಡಿದ್ದಾರೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕು. The
RP Act.
Representation of People Act along with ಅಂತ ಹೇಳಿ ಹಾಕಿ.
5052 RP Act. 123A covered ಕೊಡಿ ಎಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್.
Yes.
ತಂದಿದ್ದೀರಾ ಇಲ್ವಾ?
ಇದೆ.
Yes, anyway.
This is a recent one, my lord.
List the matter on 28th in the fresh matters list. There shall be an interim order of stay of all proceedings in CC so and so. CC 1189 of 2023 till the next date of hearing. It's covered, get all the judgments and close it.
The Lordship Syed Abdullah and B. Nagaraju.
ಯಾವುದೋ ಒಂದು. Next ತಗೊಂಬನ್ನಿ. Yes. ದೀಪ್ತಿ ಮಾಡಿ ಅವರು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. Yes.
Number 16.
It's covered, close ಮಾಡ್ಬೋದು actually. ಕೊಡಿ. Allowed cost. Same, ಎರಡು judgment ಕೊಡಿ ಇಲ್ಲಿ. Court, the petitioners are before this court calling in question.
The registration. Rahul Gandhi or the recent judgment.
ಆಯ್ತು ಕೊಡಿ.
Supreme Court.
The petitioner is before the court calling in question. They are seeking the following prayer. The offences alleged are the ones punishable under section so and so. The interpretation of those provisions need not detain this court for long or delve deep into the matter. This court in two of its judgments allowed question. Next.
Apply.
Sanction ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಹೋಯ್ತು, cuts the root of the matter. ಇದಕ್ಕೆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ.
Charges frame.
ಅದು 2:30 ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ? ಚಾರ್ಜ್ ನಾಳೆ ಫ್ರೇಮ್ ಆಯ್ತು. ಅವ್ರಿಗೆ ಹೇಳಿ ಏನೂ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ. Yes.
I appear for petitioner, my lord. In the said crime, the incident has taken place. I am an employee of Malamadeshwara Betta. My job is to cover the Dasoha Bhavana crowd management. And the said incident, on the date of incident, the temple along with the school, local school authority had a tie-up to inaugurate the Independence Day. Subsequently, there are 100,000 children where the food has been arranged by the temple authority.
ಏನಾಗಿದೆ sir?
My lord, on the said incident, some squabble has been taken between the complainant as well as two of the staffs. In between 109 has been,
ನಿಮ್ಮೆಲ್ಲ?
Yes, my lord. Out of
ದೇವಸ್ಥಾನದಲ್ಲಿ ಯಾರು ಹೊಡೆಯಕ್ಕೆ ಹೋದ್ರಿ sir?
No, my lord, out of 3 members, 2 members have mob has already been hit me and I've been admitted in a Mettur hospital where 40 kilometers from the temple premises. Till date also I have not been discharged. I am under medical treatment. Given the said counter case also been.
Deepthi Aldwa is directed to accept notice. ನೀವು ತಗೊಂತೀರಾ? Accept notice for the respondent to go through the papers, secure instructions and make submissions. The learned counsel Anand K submits that a scuffle that took place on a particular day in the precincts of MM Hills Temple has led to registration of 2 complaints, one against the petitioner and one by the petitioner against the complainant. The offense is the one punishable under section 109 against the complainant, so it is against the petitioner as well. In the light of the learned counsel submits that the petitioner is still in the hospital, having received blows, notwithstanding the same is now facing proceedings. In that light, there shall be an interim order of stay In that light, the petitioner, the state shall secure the entire papers of investigation and place it before the court. No coercive steps will be taken against the petitioner till the perusal at the investigation papers by this court list on 27th in the fresh matters list.
Jurisdictional police station may be convened, my lord. They are following it up with the family members.
Nothing will happen. Coercive steps ಹೇಳಿದಿನಲ್ಲ, nobody will do anything now.
Grateful.
ಯಾಕಂದ್ರೆ attempt to murder ಇದೆ ಅದಕ್ಕೆ.
I have a video, my
ಗೊತ್ತಿಲ್ಲ,
lord.
whatever. See, we don't know, it's still at the crime stage.
This
Yes.
has become viral in the Saturdays. This one, I have a video also where mob has been.
Don't give me viral fever, sir.
Grateful.
ನೋಡೋಣ ಆಮೇಲೆ.
17, K. Ravi Kumar.
Husband and wife are before this honorable court.
Both of them together.
Yes.
Why, sir?
It's an unfortunate situation where they are not educated.
So
And
what
in the
happened,
face
sir?
of a 14 lakhs check which is said to have been issued,
Oh.
an undertaking came to be filed and my lord gets the order, conviction order by the by the magistrate, passing a conviction order and also awarding an interest of 2%. And the settled position is that when a joint memo is filed by the parties, it has to necessarily result in either compounding. It cannot be an order of conviction, that too with an onerous condition about 2% payment, and my lord gets and also more so when the complainant has not disclosed how he paid 14 lakhs. At page
Adalla
number-
merits, you are before the appellate court.
I have to go before the appellate court now. I have to go.
Now?
Now means, my lord,
now,
the difficulty which has arisen is about the magistrate court is posting the matter for recovery. Yesterday, 17/8, for payment.
Correct, sir.
Yes, in my.
Why did you undertake, sir?
My lord, that undertaking was given under the circumstances where there was so much force. These two petitioners have no money to pay even.
Why
the
did you
legal-
undertake?
Even
First of all, ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೆ ಯಾಕೆ? ಕನ್ವಿಕ್ಟ್ ಆಗಿದೆ, ಕನ್ವಿಕ್ಟ್ ಆದ್ಮೇಲೆ ಅಪೀಲ್ ಅಲ್ಲಿ ಇವೆಲ್ಲ ಅಂಡರ್ಟೇಕಿಂಗ್ ಯಾಕೆ ಬೇಕು?
appeal ಅಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ.
ಮತ್ತೆ ಎಲ್ಲಿ ಕೊಟ್ರಿ?
Magistrate court.
ಅಲ್ಲೇ ಯಾಕೆ ಕೊಟ್ರಿ ಅಂಡರ್ಟೇಕಿಂಗ್?
Undertaking was given because he had no means to even defend the case.
ಅದಕ್ಕೆ?
It was, he was.
But they've engaged you, sir.
Yes, my lord.
They've engaged you.
No, not here, not there. There, and there is a peculiar aspect to the situation about my engagement. My lord will see the cast title in what way I am representing in this matter. My lord will see the cast title. It is a very, very unfortunate situation.
Right, we'll see. Emergent notice to the respondent returnable by the 28th. The petitioner shall also serve on the counsel, or advocate on record shall serve on the counsel who represents the respondent. There shall be an interim order of stay of further proceedings by the petitioners till the next date of hearing.
You oblige.
ಅಂತೂ ನನ್ನ ಕಾಸ್ಟ್ ಟೈಟಲ್ ನೋಡಿಸ್ಬಿಟ್ಟು ಒಂದು ಆರ್ಡರ್ ಆಯ್ತು ಈಗ. ಇಲ್ಲಿವರೆಗೂ ನೋಡಿರಲಿಲ್ಲ. ಆಯ್ತು.
Number 2, reporting settlement. Bill number 101.
Hearing for the respond number 2. Petitioner matter is settled before the mediation.
Offense.
498 and 596. So all the parties are present here. Petitioners are present. And also we are providing 14 lakhs DDO.
40 lakhs.
14 lakhs.
14 lakhs. ಯಾರಿಂದ ಯಾರಿಗೆ?
Your husband in the wife.
ಇಲ್ಲಿ ಯಾರು husband ಯಾರಿಗೆ?
Petitioner number 1 and respondent number 2. Wife is here.
All right, yes. ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. The petitioner hands over a demand draft of rupees 14 lakhs to the respondent wife, which is acknowledged by her.
2 DDs.
2 demand drafts, all right.
11 lakhs and 3 lakhs.
11 and 3 lakhs, yes.
Order sheet. Order sheet.
Next.
102.
One or two ಯಾರ್ದು? List after 8 weeks. Yes. Enter ಮಾಡ್ರಿ ಇದೆ ನೋಡಿ. List after 8 weeks.
103.
103.
103.
Hearing for the petitioner.
Offense ಏನು?
85, your lordship, BNS.
490.
498.
Where is it settled?
We have already settled.
Mediation.
No, your lordship. They have agreed to separate, your lordship.
Correct. Where is it settled? You're filing settlement here? Joint memo.
Yes.
Correspondent number 2.
Yes.
Order his latest. 104.
For the petitioner, my lords.
Offense.
Under section 196 clause 1 of BNS and 118 clause 1 of BNS. Joint memo is being filed.
Yes. Next. Hmm.
105.
Not joint memo, husband and wife.
Separated.
Family dispute.
Separated.
Yes, my lord. No,
Okay.
DD we are giving.
ಅಲ್ಲ ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
ಇಲ್ಲೇ ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಇಲ್ಲೇ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಜಾಯಿಂಟ್
ಇಲ್ಲೇ ಮಾಡ್ತಾ both of them are
ಅಲ್ಲ ಜಾಯಿಂಟ್ ಮೆಮೋ.
Joint memo.
ಕೊಡಿ.
I am handing over the DD.
ಎಷ್ಟು?
5 ಲಕ್ಷ.
ಹ್ಯಾಂಡ್ಸ್ ಓವರ್ ಸೆಟಲ್ ಫಾರ್ 5 lakhs. ರೆಸ್ಪಾಂಡ್ ಅಡ್ವೊಕೇಟ್ ಯಾರು?
ಇಲ್ಲಿದ್ದಾರೆ.
ನೀವೇನು ಒಟ್ಟಿಗೆ ಇದ್ದೀರಾ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ? ಈ ಕಡೆ ಬನ್ನಿ.
Connected matter is that.
Wait.
5.1.
So and so.
Non-petitioner.
ಆಯ್ತು. 105.1 ಇದೆಯಾ? ಹಂಗಾರೆ ಮಧ್ಯದಲ್ಲಿರಿ. Yes. So and so. Joint memo.
Joint memo.
Yes. Next. ಅವ್ರದ್ದು ಬಂತ ಮೇಡಮ್? Yes. ಅಲ್ಲ ಇದು ರಾಮದಾಸ್ ಸರ್ ಕಾಯ್ತಾ ಇದ್ರು ಒಂದು ಯಾವ್ದು ಮ್ಯಾಟರ್ ಕೇಳಿ. ರಾಮದಾಸ್ ಸರ್.
Number 98.
For respondent.
Respondent ಈಗ. ಹಾ.
Seek indulgence of the court to file the statement of objection. It's ready, man. Just serve the copy, even if it is on Monday.
What's the offense?
No, the last time he took time to say, I have not filed counter anta.
A week's time to file statement of objections.
So it's ready, madam. File it on.
What's the offense?
It had been disposed of once before. Again, my application recall ಮಾಡಿ ತಿರ್ಗಾ it is now.
ಯಾರು ನೀವು ಹಾಕಿದ್ರ ಅಪ್ಲಿಕೇಶನ್?
ಹೌದು, recall ಮಾಡಕ್ಕೆ.
Recall.
It did not come at all.
What's the matter?
It's an SCST.
Atrocities.
This is a case where Malas, I was appointed as an assistant professor in 2008 in IAS.
ಅಯ್ಯೋ ಇದು ಸಣ್ಣ ದುರ್ಗಪ್ಪ ಅವ್ರು. ನೀವೇನ್ ಬಿಟ್ಟಿಲ್ವಾ ಇನ್ನು? ಏನ್ ಪ್ರಾಬ್ಲಮ್? ಏನ್ ಸಾಕ್ ಸುಮ್ನೆ ಇರಿ. ಎಸ್ ಆಯ್ತು ವೇಟ್, ಅವ್ರಿದ್ದಾರೆ ಮಾತಾಡಿ ಸುಮ್ನೆ ಇರಿ. ಆಯ್ತು ವೇಟ್.
2008 I was appointed as a lecturer in IASC. Subsequently, Malas, I was promoted and my appointment was confirmed. Subsequently, I filed an application for an abroad scholarship. There was a disciplinary inquiry initiated upon based on that. Then, I filed certain RTI applications. I tried to whistleblow certain misappropriation within the institution. At that point of time, an inquiry was initiated. I was given a clean chit. Subsequently, within 30 days from the said inquiry, and complaint was filed telling that I have called a student beautiful and you look like Trisha.
Trisha.
Based on that allegation, the sole allegation, Manoj.
Now you can't say that, sir.
All those things happened long time ago.
Of course, long time. ಈಗ ಹೇಳಕ್ ಆಗಲ್ಲ.
2015 is the order of dismissal that was passed. He filed a writ petition. Then when the matter was pending, there was a proposal by his senior advocate to settle the matter. That was settled. And the termination was converted into one of resignation. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. Filed a challenging.
ಅಲ್ಲ ಈಗೇನು ಅದ ಅಲಿಗೇಷನ್ ಈಗ.
What has happened subsequently,
including everybody, even the lawyers against whom they were appearing, they are now made parties.
What has happened, my lord? Subsequently, he has given a complaint.
You're a professor and ಯಾಕ್ ಬೇಕಿದೆಲ್ಲ? ಅಲ್ಲ ಇದು ಈಗ ಎಲ್ಲ ಸೆಟ್ಲ್ ಆಗಿದ್ದೆಲ್ಲ ಆಯ್ತು, ಮತ್ತೇನ್ ಪ್ರಾಬ್ಲಮ್ ಈಗ?
ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಅಲ್ಲಿ ಸೆಕ್ಷನ್ ಹರಾಸ್ಮೆಂಟ್ ಅಲ್ಲಿ NGO ಮೆಂಬರ್ ಇಲ್ಲ, ಕಮಿಟಿ ಇಟ್ಸ್ ಇನ್ವ್ಯಾಲಿಡ್ ಕಮಿಟಿ.
ಆಯ್ತು, we'll answer all that.
2 other PCs were filed, they are quashed. Then he approached in the SC/ST Karnataka Assembly. They ordered reinstatement. That was challenged and that petition was allowed. SC/ST Commission ನಲ್ಲಿ again that was
quashed. Objection ಹಾಕಿ, let him file.
I'll just file my objection.
ಆಯ್ತು, ಇವತ್ತು ಹಾಕಿ. ಬಟ್ ಯಾಕೆ ಬೇಕಿದೆ? ಈಗ ರಿಟೈರ್ ಆಗಿದಾರ ಏನು?
ಟರ್ಮಿನೇಷನ್
ಎಷ್ಟು ವರ್ಷ ನಿಮ್ಗೆ?
ಟರ್ಮಿನೇಷನ್ ಜಾಬ್ ಇಲ್ಲ ನನಗೆ. 12 years ಟರ್ಮಿನೇಷನ್. ನನ್ನ ವೈಫ್
ಅಲ್ಲ ಆಯ್ತು
6/4/2016 this termination was converted one of resignation. terminal benefits was
I
settled.
will see. You file your objections. I'll post it on 27th, sir. 27th at 4:30 PM. ನೀವು 4:00ವರೆಗೆ ಬನ್ನಿ, ಅಲ್ಲಿವರೆಗೂ ಏನು ಬೇಡ. Yes. 4:30 PM, 27th. ಅಷ್ಟರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. If there's any range, ಇದ್ರಲ್ಲಿ rejoinder ಬರಲ್ಲ. Yes.
ಅಲ್ಲ ಹಂಗರ್ ಸ್ಟ್ರೈಕ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ನಾವು.
ಇದ್ರಲ್ಲೇನಾ?
ಹೌದು.
ಸರ್ ಇವ್ರದ್ದು ಒಂದು ಪ್ರೆಸಿಡೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾ ರೂಲ್ 29 ಅಂತ ಇದೆ ಸರ್, ಅದನ್ನ ಇವರೇ ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು. ಸಣ್ಣ ದುರ್ಗಪ್ಪ ಸುಮ್ಮನೆ ಇರಿ ಸಣ್ಣ ದುರ್ಗ. Yes. ಹಿಯರ್ ಮಾಡುವ ಸುಮ್ಮನೆ ಇರಿ. On 27th we'll hear it on 27th. ಅಲ್ಲಿವರೆಗೂ ಸುಮ್ಮನೆ ಇರಿ. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಾದ್ರೆ ಇವೆಲ್ಲ ಯಾಕೆ ಮಾಡ್ಬೇಕು? Don't do all that.
That I'll do hunger strike.
We won't do anything. 27th ವರೆಗೆ ಏನ್ ಮಾಡು, ತೀರ್ಮಾನ ಮಾಡುವ. Yes. ಅಲ್ಲ ಇವ್ರದ್ದು ಮಿಕ್ಕಿದ ಕಾಲ್ ಔಟ್ ಮಾಡ್ಬಿಡಿ. ಇಡಿದು ಇದೆಯಲ್ಲ ಅದು ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್. ಕಾಯ್ತಾ ಇದ್ದಾರೆ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲಿ ಕರೆದ್ಬಿಡಿ.
Passed or 85?
ಪಣೀಂದ್ರ ಸರ್ ಅದೇ ಅಲ್ವಾ? 85 ಯಾವುದು? 38 ಸಾರಿ, ಅದು ಸ್ವಲ್ಪ because she is handling.
I don't know, my lord. It's, I think she's.
What starts in the morning, we don't know where it will go in the evening.
They get used to, probably they'll get used to because of the.
Yes.
Bench.
Can't help. Yes.
Lords, they have furnished to us the reasons to believe.
Really, Anuparna madam.
I just.
Some personal emergency she has to leave.
I just pass on the reasons to believe what they have given.
Aithu kodi. No, anyway, Siddharth sir.
May please.
And the whole house today.
No difficulty, brother.
Thursday, fine.
I'm obliged.
31st is Monday, sir.
We'll finish our
on Thursday. You finish your argument.
Sir,
let him finish his arguments. Raju sir, let him finish whenever at a convenient date. You finish off on Thursday.
I'm obliged.
Sir, you finish on Thursday, sir.
I'm obliged. We'll do that.
Very much. But remind me, just 270 ಇದೆ ಅವತ್ತು ಅಷ್ಟೇ. ಅದಕ್ಕೆ I'll start at 10 AM.
That might be first list, my lords.
No, first list ಏನು ಇಲ್ಲ ಅವತ್ತು. Only second list. So first list, fresh matters finished everything.
Very well. My lords, objections we have served.
You have served, right?
We have served.
No problem. Yes. Objections.
We'll file the court copy. We'll file, or shall I?
Give it. Yes. The learned counsel. Don't so. Files a statement of objections, a copy of which is copy of which is served on the counsel for the respondents. Heard the learned senior counsel Siddharth Agarwal along with senior counsel K. N. Pandindra, where Ella Shivaprasad, Ella the ಹೆಸರು ಹಾಕ್ಬಿಟ್ಟು list on how long will you take? ಎಷ್ಟೊತ್ತು ಬೇಕು?
Not more than half an hour. Judgments ಇದೆ, ಅದು ಬೇಕಂದ್ರೆ I can pass on. If
ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ, ನಾನು ನೋಡ್ತೀನಿ.
With the proposition, I will just narrate.
Please give everything whatever you want.
In ಎರಡಿದೆ, ಅದನ್ನ stitch ಮಾಡಿ ಅವತ್ತು ಕೊಡ್ತೀನಿ. There are 2 more judgments that day. I will stitch and give. Reasons to believe.
Copy, give off a copy. Just go through it and come. Yes. On Thursday you finish your.
Please.
Then Raju sir ಗೆ ಯಾವತ್ತು ಬೇಕು ಅವತ್ತು. Whenever he wants.
Please apply.
Can I take the liberty of mentioning around 2:30 subject to my lord's convenience?
ಮತ್ತೆ don't make a mention there. All right.
Please, my lords.
Yes, sir.
Obliged.
How the cows would have reached home, my lords.
ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
I think it's time for my lord.
That's why I said cows are coming back. Stop. Yes.
Just continue. Hearing on IA 87.
Raghavendra sir.
I appear for the petitioner.
ಏನಿದು?
Is a retired joint director, my lord. A selection, my lord. The allegation is under 2465.
Who has filed vacating stay?
My lord, the made by the state. my lord, alleging, but my lord, my lord, the misconduct in the, my lord, in the selection process, in the cell, my lord. I was not at all there in that cell, my lord. It is entire thing happened in the, my lord, special cell, my lord, formed by the state. And one Prasad was responsible for that, this, my lord.
Anyway, state has filed alva.
Oh.
There is, we'll hear it later.
Mainly see, my lord, 68 years, retire ಆಗಿ 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ.
ಈಗ ಸ್ಟೇ ಉಂಟಲ್ಲ?
ಸ್ಟೇ ಇದೆ.
Yes.
But, my lord,
ಈಗ ಅರ್ಜೆನ್ಸಿ ಏನುಂಟು?
ಅರ್ಜೆನ್ಸಿ, my lord, ಮುಗಿಸ್ಬೇಕು.
ಅಲ್ಲ, ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಬಂದಿಲ್ವಾ?
ಅದು ಬಂದಿದೆ.
ಎಲ್ಲ ಬಂದುಂಟಾ?
ಅದೇನಿಲ್ಲ.
ಒಂದು 29ಕ್ಕೆ ಫಿಕ್ಸ್ ಮಾಡುವ. ಅವತ್ತು ಸ್ಯಾಟರ್ಡೆ ವಿಲ್ ಫಿನಿಶ್ ಇಟ್. Yes, 29th. Interim order subsisting will continue to the next date. Rajat?
88.
Covered, my lords, NDPS, landowner, my lords, where the plants were grown. I was not arraigned as an accused in the FIR. Just filing a
Ganja?
Please, my lords. Three plants.
ಗಿಡನೋ ಮರನೋ?
1.5 feet each, my lords.
1.5 feet.
Co-accused, my lords, have given a
Small
statement.
plants.
They co-accused have given a statement, my lords, that they planted it. And, my lords, the proceedings have been initiated.
ಒಂದೋ ರೆಡಿ. ಅವ್ರ ಕನ್ಸಂಪ್ಷನ್ಗೂ ಆಗಲ್ಲ.
I am the hotel owner, my lords. None staff have done this.
I mean, Gopal Reddy's case.
Please, my lords. Gopal Reddy and the others.
ಅಲ್ಲ, cross pollination is Gopal Reddy ಅಲ್ಲ, ಚಂದ್ರಶೇಖರ್ ಅದು. Gopal Reddy is that resort where he was the owner ಅಂತ they admit. No, what is happening in the party?
And also, my lords, Ajesh Shankar, coordinate bench of this court, that, my lords, that he does not have control on the affairs.
Day after tomorrow.
Obliged.
Day after tomorrow, 24th, fresh matters, Monday.
Please, please.
Yes, next.
89.
An offense? 326. In settlement?
My lord, it was referred to settlement, but they did not settle the matter. My lord, in the main petition, my lord, petitioner number 3, my contention is petitioner number 3 is coming from the poor family for the first time.
KS of
Nivena. Yes, my lord. He has cleared the mains exam, my lord.
Iga?
Now.
He has not stopped this creating nuisance and he's regularly quarreling. I have the videos where
you ask accused number 1, who is he? In relation
father. Is the father.
ಈಗ ಅವ್ರು ಸ್ಟಾಪ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ KS ಆಗಲ್ಲ. You ask the accused number 1 to be present.
My lord, in the last hearing, it happened that even we installed CCTV camera. There is a lot of
you
provocation.
Ask accused number 1 to be here. On 24th, you ask him to come.
76 years. Yes, my lord.
96 years old.
76 years.
Yen parvalla. Yes.
Yes, my lord.
One ನಿಮಿಷ. List the matter on Monday in the fresh matters list. There shall interim order ಕೊಡ್ತೀನಿ. Settle ಮಾಡ್ಕೋಬೇಕಲ್ಲ.
We are ready to settle. They are not settling the matter. They are demanding land, my lord, now.
We are not demanding any abandonment. They are frequently quarreling.
Now, whatever it is, you get the accused number 1, you also get your parties. List the matter on Monday at 4 p.m. The companion petition also shall have the benefit of the interim order till the next date, Monday ವರೆಗೆ. ಇಲ್ಲಾಂದ್ರೆ ವೆಕೆಟ್ ಮಾಡ್ತೀನಿ. ಅದರಲ್ಲೂ ಇಲ್ಲಾಂದ್ರೆ ಮಂಡೇ ಡೆಫಿನೆಟ್ ವೆಕೆಟ್ ಮಾಡ್ತೀನಿ. ಇಲ್ಲಾಂದ್ರೆ ಕೊಡೋದೇ ಇಲ್ಲ. ಈಗ ಯಾವ್ದು ಬೇಕು? ವೆಕೆಟ್ ಮಾಡೋದು ಬೆಟರ್ ಅಲ್ವಾ? ಸರಿ. ಎಸ್.
Number 90.
For petitioner. This case is covered by your lordship, so judgment, my lords, dated 25/4/2026.
What is that, sir?
The promise of marriage.
Promise to marry.
Yes. 2018-19 ಇಂದ ಗೊತ್ತಿದೆ ಅಂತಾರೆ. 2022 ಅಕ್ಟೋಬರ್.
ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಲ್ಲಿದ್ದಾರೆ?
ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ಲ.
ರಾಜಮೋಹನ್ ಬರ್ತಾರೆ ಅವರು?
ಇಲ್ಲ, continuously he is not appearing, my lords.
We'll see.
Last date of
there
hearing
is no represent 6 ಗಂಟೆಲಿ ನಾವ್ ಹೆಂಗ್ ಬರೆಯೋದು ಅದನ್ನ?
Last time fresh matters ಒಂದ್ರಿ.
As a last chance, list this matter on 24th in the fresh matters list. ಅವತ್ತು ಬರೆಯೋಣ.
Please.
Yes, next. Interim order continues. Anuparna madam.
One of the matter notice was issued. The other two are the tag matters.
ಏನಿದು?
Not revision petition challenge the discharge application.
ಕೊಡಿ, ಎಲ್ಲ ಕೊಡಿ. Yes.
In 1702, notice has been issued. In the other two, my lord, notice is not issued, which is listed today, my lord.
Notice, yes.
Great.
Wherever notice is not issued, issue notice in Mekedo registry to, sorry, post immediately after service of notice upon the respondent.
Great.
Yes, next. Yaudral notice agilla adu. On delay. Yes. Notice on delay and also main eradu matli.
Obliged.
92.
92.
My lords, I appear for the respondent number 2, my lords, in this case.
Vacating stay.
I pray for time in this matter, my lord. Senior is
Yes.
unwell, my lords.
2 weeks IO. Next.
93.
Interim order continues.
Much obliged.
For the petitioner, my lords, 93. It's vacating, they have filed, my lords. Atrocities Act, my lords.
There is an interim order.
Yes, my lords.
28th.
My lords may be taken up on Tuesday, my lords.
28th. Yes. Interim order continues. Next.
94.
94. My lords, there is a two case, my lords, 94, 94.1. 94.1 to be heard at first, my lords. That one, it attracts like they have filed the Atrocity Act, my lords. Means
There is interim order.
No, my lords.
No interim order.
No interim orders. She has filed the cancellation of bail also, my lords. That's for reserve for orders.
I have reserved.
No. Justice Rachaya.
Yes.
Before Justice Rachaya, my lords.
Yes, 1 moment. 94.
94.1.
Yeah, atrocities.
Husband and wife issue, my lords.
List the matter day after tomorrow in the fresh matters list. Day after tomorrow in the morning itself it will come. When it's reserved, is it?
For orders, my lords, any
No
time.
Don't worry, it won't come. Yes.
If it is heard, it would be more appreciated.
Don't worry, day after tomorrow. Yes.
95.
Anything may happen there. This is on a different footing. We'll do it. Yes. 95.
95.
False trap. Yes, sir.
Criminal breach of trust and civil dispute is pending, my lords. Still, they have not.
Mahesh.
But I appeared for 95.3 in this.
Ian Mahesh.
But I am for one of those purchases. You pay a considerable sum of money to the society. Society would say that there is a developer who would who would allot me a site. The developer and the society would fall into a squabble. Ultimately, I go before the RERA authorities, file a complaint for the recovery of money. Neither there is site nor there is a sum of money being paid.
List the matter on 27th in the fresh matters list.
Yes. Interim order.
Interim order till then will continue. I'm going to close it.
Please.
On 27th.
Please, my lords.
96.
Appearing for the petitioner, my lords.
Yes, Mayur.
This is that matter, my lords, wherein two neighbors are fighting, my lords. The petitioners are staying in a parallel road.
Dog.
Yes, my lords, the dog one.
Yes, my lords.
Yes, my lord. The dog, yes, my lord.
Okay.
Yes, my lord. The dog barks, my lords. They come and file a complaint against us saying animal cruelty, my lords.
Yes, madam.
My lords, I would like to produce few photographs, my lords.
Of the dog.
Of the incident, what transpired on the date of the.
I have produced the entire CCTV footage along with the pen
My
drive.
lords, from that CCTV, there is a tree blocking, so nothing has been seen from whatever.
ಎಲ್ಲ ಇದರಲ್ಲಿ ಇದೆಯಾ?
ಅವ್ರು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಏನು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
ಏನ್ ಮಯೂರ್ ಎಲ್ಲ ಕವರ್ ಮಾಡಿ CCTV ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
My lord, there are two angles that I have given from my lord.
camera
Both
right
of these angles cover the incident.
1947 camera?
No, my lords, there is one camera right in front of their house
Right
gate.
in front of.
ಅದರಲ್ಲಿ ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ, but the CCTV footages, whatever they've produced, they've given it in that there's a tree which is blocking. So you can see the respondent has gone to speak to them, but nothing has been recovered. Nothing is seen in that footage.
The video would indicate, my lord, that the respondent has tried to assault the children of the petitioners herein when they have stepped in to stop the respondent number 2.
ಏನದು ಕೈಯಲ್ಲಿ? What is that?
This is the.
ಒಂದು ನಿಮಿಷ ಮಯೂರ್.
Yes.
This is the photographs, my lord.
ಆಯ್ತು ಕೊಡಿ ಅವ್ರಿಗೆ. ನೀವು ಮಯೂರ್ ಕೊಲಿಗ ತಗೊಳ್ಳಿ ಇದು. ಇದು 27th fresh matters.
My lords,
Grateful.
finally on 26, my lords.
26th.
No, my lords, 25th or after 28th, my lords.
29th.
Grateful.
Obliged, my lord. Obliged.
97 ಆಯ್ತಲ್ಲ ಮೇಡಮ್.
99.
ಕಮಲಾಚರಣ್.
99, lord.
For the respondent number 2, my lord.
ಅನುಪರ್ಣ. ನಿಮ್ದೆ.
Petitioner, my lord. Atrocity case, my lord. Case and counter case. ನಾನು ಫಸ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿರ್ತೀನಿ ಸ್ವಾಮಿ, they'll not register.
ಇದೆಯಲ್ಲ?
No, there's no stay, my lord.
ಏನಿದು?
There's no stay. Atrocities Act, my lord. Lord,
It is stale.
No,
what had happened, my lord? I gave a statement. They don't register my statement as an FIR. They take their complaint first.
24th fresh matters.
Please, great. My lord, 25th, my lord.
25th. All right.
100.
My lord, appearing for respondent number 2 in the matter, the arguing counsel, Mr. Vikramaditya Singh, is not available today. There is some inconvenience. The matter may kindly be posted 2 weeks later, my lord.
They have no food.
We were responding to the ED matter. There are two matters, my lord.
Because you've taken over our food. Yes. Let's the matter on 27th.
My lord, if matter may be posted in the first week of September.
No, madam. That day we will post it. It's question of food.
Much obliged, madam. Much obliged.
Further hearing 106.
For the petitioners, my lord, it's a demonetization.
2,000 rupees.
Yes, 500 and 1,000 minutes.
No, we'll see. Early next week.
Interim order.
That will continue. 29th, yes.
107.
The release matter from state is being part heard. Post the matter before the bench having roster. Next.
108.
Petition. ಇದು 26th ಅಲ್ಲ ಇದ್ಯಾಕೆ ಪಾರ್ಟೆಡ್ ಆಗಿದೆ ರಿಲೀಸ್ ದ ಮ್ಯಾಟರ್ ಸ್ಟೇಟ್ ಇಸ್ ಬೀಯಿಂಗ್ ಪಾರ್ಟೆಡ್ ಪೋಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ನೆಕ್ಸ್ಟ್
109.
ಇದು ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 29th.
Close my habit first week of September.
No sir, 29th. Yes.
My lord, interim order.
Interim order will continue.
Same interim order.
Yes, yes. Ashana madam. End of the list.
111.
Nimda.
111 at 4 p.m.
Oh.
SIT, my lord.
111.
Yes.
Inondinama.
CBI had filed a closure report.
Yura. Yes. Oh, this matter. Yes, sir. 4 p.m. matter. Ready na?
Ready.
Start.
It's 91 application we issued a notice. 91.
ಏನು ಆರು ಕಾಲಕ್ಕೆ ನಾನು ಸುಸ್ತಾಗಿರ್ಬೇಕು ನೀವೇ ಸುಸ್ತಾದಂಗೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಎನರ್ಜಿ ಇಲ್ವಾ
ಮತ್ತೆ ಆಫೀಸಿಗೆ ಹೋಗಿ ಮತ್ತೆ
ಆಫೀಸ್ಗೆ ಹೋಗಿ ಬಂದ್ರಾ
only will not say this
Tuesday fresh matters ಅದು ಬೇಡ ಹಿಂಗೆ ಇರಲಿ 4 p.m. Yes. Tuesday 4 p.m. for further hearing. ಇದು fresh matters 4 p.m. ಬೇಡ ಮೇಡಮ್ 4 p.m. for further hearing ಅಂತ ಮೇಡಮ್
2:30ಗೆ
2:30ಗೆ ತಗೊಳ್ಳ 2:30ಗೆ ಹಂಗಾರೆ ಇಲ್ಲೇ ಇರಿ ನೀವು ಆಫೀಸ್ಗೆ ಹೋಗ್ಬೇಡಿ ಅವತ್ತು ಪ್ರಸಾದ್ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಬರಬೇಡಿ ಇಲ್ಲೇ ಇರಿ 2:30ಗೆ ತಗೊಂತ
ಅಲ್ಲ ಈಗ ಹೋಗಿ ಮತ್ತೆ ಆಫೀಸಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳಿ
ಆಯ್ತು
Tuesday, my lord.
Tuesday.
30 more.
Interim order to be extended.
Voting settlement.
Interim order to be extended.
That will continue. Yes. For further hearing ಅಂತ ಅವತ್ತು ಮುಗಿಸ್ಬೋಣ ಪ್ರಸಾದ್ ಸರ್ ಟ್ಯೂಸ್ಡೇ ಮುಗಿಸ್ಬೋಣ
not maintainable.
ಅದಕ್ಕೆ ಅವತ್ತು ಮೇಂಟೈನ್ ಅಲ್ಲ ತೀರ್ಮಾನ ಮಾಡ್ಬೇಡ
91 application notice issue. Again, that order, my lord, they filed
91 notice challenge
yes,
madara.
In the guise of notice issuing... issued, my lord, against that order they filed a writ petition. They are not the accused, and only they have to produce the document.
You know, the
And
kind of
they are
documents.
ಅದಕ್ಕೂ ಪ್ರಾಬ್ಲಮ್.
The kind of documents they have asked me to produce, my lord, goes on to show they have no intention of arraigning me as a witness. They have in fact called me as an accused.
Anticipation, my lord. The anticipation
No,
they filed.
I'll show. I'll show. My lord.
Then we'll decide. ಜಾಸ್ತಿ ಹೊತ್ತಾಗಲ್ಲ
As
ಹಂಗಾರೆ
and when my learned friend allows me to argue, my lord, I'll make
2:30 2:30 on Tuesday.
Please.
Yes madam ಬಂತಲ್ಲ
Petitioner number 1 and
2 ಏನು offense 498
Wakalat and joint members.
Respect to
Husband
husband, it
number
was quashed long back.
it's kulanama
Respect to husband, it was
Right,
quashed
Mama,
long
Wakalat.
back. Settlement ಆಗಿತ್ತು.
ಇದೇನ್ ಮತ್ತೆ
ಇದು respect to mother-in-law and brother-in-law.
ಅವರಿಬ್ಬರದು ಮಾತ್ರನಾ
Husband.
where is the complainant ಇವರೇ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಜೊತೆಗಿದ್ರೆ ಆಮೇಲೆ ಗೊತ್ತಾಗಲ್ಲ ಎಸ್ ಕ್ಲೋಸ್ ಸಿಗ್ನೇಚರ್
Thank you. Order sheet signatures.
ಅರ್ಬಟಿ ಸರ್ ಏನು
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 2627. ನಾನು ಅಷ್ಟೇ learned senior also thought your lordship said your lordship will pass order for referring.
referring.
serial number 26, the one,
ಅದು
175 3
ಬೆಳಗ್ಗೆದು.
order, my lords.
ತಾವು ಸ್ವಲ್ಪ ನೋಡ್ಬಿಟ್ಟು ಯಾಕಂದ್ರೆ 175 3 and 4 are both stages are yet to be there.
ಅದೇ whether I can do it, I'll see. ಅದು ನನಗೆ ಗೊತ್ತು, I know that.
ಅಲ್ಲ, that anxiety was there.
No,
Even
because the job that the court should do, I cannot do.
ಅಲ್ಲ,
Will do.
ಯಾಕಂದ್ರೆ subsection 4 ಕೂಡ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
I'm aware of it.
And your lordship's orders are there.
Yes. ಅದಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ರ, ನಾ ಆ ತಪ್ಪು ಮಾಡ್ತಾನೆ ಇರಲಿಲ್ಲ.
Grateful, my lords.
Yes.
ಅಲ್ಲ, ತಾವು ತಪ್ಪು ಮಾಡ್ತೀನಿ ಅಂತಲ್ಲ,
ಅಲ್ಲ.
ಕೇಳಿಸಿದ್ದನ್ನ ನಾವು
ನೀವು
Your Lordship, Mr. Abati was quite anxious on 175(3), since Your Lordship would use the word investigate.
Echo ಆಗ್ತಾ ಇದೆ ನಿಮ್ಮಿಂದ. Yes. Albati sir.
Your Lordship, am I still echoing?
Yes. See? ಅದಕ್ಕೆ
ಆಯ್ತು, because 6 o'clock.
ಅದು ನಿಮ್ದು. In the lighter way to
ಇಲ್ಲ